You let me know when you're ready, Ms. Radom.
Oh, apologies. I am ready.
All right, thank you. Good morning.
Good morning, CJ.
And apologies to you and everybody else again that we could not start on time. Good news is we are correct now and we can begin the business of the day. Premier, I understand that you wanted to say something. You can say it on record.
Good morning, Chief Justice. I sincerely want to apologize. I went to bed very bad yesterday. I was not feeling well, so the alternate agreed to come here, only to find that he's missed his flight this morning, so I was forced to come back to join you. So my sincerest apologies for the delay.
No, thank you, Premier, but I must express my extreme disappointment with you. And it's an aggravated situation because you're not doing this for the first or second time. You always keep us waiting. And that's just unacceptable. And I have said previously that if you are that busy, then just send a representative. You have many people working for you. If one is not available, have alternates lined up for you so that this does not happen again.
Indeed, I will do. My apologies.
Thank you. Ms. Radom,
CJ.
you hold 2 law degrees.
I do.
One, an LLB from the Potchefstroom University.
We were the last class for it to be called Potchefstroom University. The next year it became the University of the Northwest.
Yes. And then you obtained an LLM in extractive industry law in Africa.
Yes, that's a very fresh one. I obtained that one this year. It's mining law, it's extractive industry.
All right. Oh, you just got it this past May.
Yes, yes.
Congratulations.
Thank you.
That's from the University of Pretoria.
Indeed.
All right. In your early life in the job market, you were a research assistant and class facilitator at your university.
Yes, sir.
Potchefstroom. And then you did a few things in London, then came back and did your articles.
Indeed.
Okay. And became an attorney until 2009.
2000 until the end of 2009. I was admitted in 2008. And then I was an
So
attorney
it was
until
just 1 year
2009. Yeah.
at the sidebar. And you became an advocate in 2010.
Yes.
Okay. At which bar are you?
Pretoria Bar.
Okay.
Pretoria Society of Advocates. It's called.
So it's been 15 years at the bar.
Yes, yes. I was reminded of that the other day. It's been a
Time
stint.
flies. What kind of work do you do?
In the earliest I've said in my answer, everything, whatever.
The general practice.
Yes. A lot of personal injury, a lot of RAF that predominates our court roles there, but also do medical negligence now, contracts, commercial work, some opposed motions. But predominantly, as I think I said, 80% is in the sphere of the law of damages, or personal damages, albeit whether it be medical negligence or unlawful arrests or whatever the merits, the damages portion.
Okay. So you started acting as a judge from 2019 already?
Yes,
yes. Just short spells. Then you attended the Aspirant Women Judges Program in 2023.
Yes, it's called the Bridget Mabandla program now, but and I'm quite glad about that because calling it the Aspirant Women Judges Program, it seemed as if there was confusion that it was the 2-week course, whereas this one was an 8-month intensive, I won't say grueling, but grueling.
Well, it is demanding.
It's very demanding, and we had a very strict taskmaster in our first intro back into the course. I understood it previously was presented in 2007 in a similar format, but yes, no, it was just the most amazing experience, I think.
So you found it useful?
I beg your pardon?
You found it useful?
It changes everything, and I think if anyone that wants to come to be a judge, if the capacity was there, and everyone could be subjected to that type of program, it would be amazingly beneficial for the bench. But I mean, yes, as I said, it does take a lot of time out of one's practice, and you have to really be dedicated to it.
And that
then
has
the
been a
resources.
challenge, actually.
Yeah, and the resources are, you can't, we were 17 people, and the resources just weren't there to sustain it in that format for that long. I mean, it's impossible. But in an ideal world, everyone would have the chance to be exposed to that type of training, especially from other judges. I think that's the most important portion there.
Well, unfortunately, its continued existence has been perilous for a while because
Yes.
there's no money.
Yes.
And the practitioners who leave their practices, who are breadwinners, who have bills to pay, have to get a stipend, and funds have run out, and all sorts of other problems. And we do hope that we'll continue hoping for a miracle, continue getting support so that it does not die.
We had that was at the closing of the function. One of the main issues raised by DJP Mojapelo was about the fact that in our group, at least 4 of us were single mothers, advocates, who had to give up our practices. And it's not just missing out on a trial date. You have to understand the nature of the practice is if I'm out of the running, my attorneys forget about me.
Yeah.
Fortunately, I'm very blessed. I don't have that issue. I've got a wonderful support system in that regard, but a lot of people don't. So stipends would be necessary. Otherwise, you're saying we're uplifting these women, but you're not.
Well, the minister is here, like
Minister.
She in her own capacity and with her network, good connections, will hopefully continue supporting us in our efforts to keep it alive. So you've acted in 2021 as well, 2023, and last year.
Yes.
When was your last stint?
I'm actually currently acting again for this last week, and I'm actually playing hooky today. I'm supposed to be in the civil trial role today, so I'm acting until the end of today. End of this week, not to the end of today.
Okay. So for how long have you acted?
At my last, if I take into account this week, I think the spreadsheet that I sent through to the AJP, it's 36 weeks in total.
36.
Yes. There might be some discrepancies because the early acting stints were those 2019, 2020 were those what we call ad hoc acting stints pro bonos, and I wasn't keeping as much of a record at that stage as I do now, but it's in the region 34, 36 weeks.
Okay. And in which courts have you sat?
I've sat in all of the courts, save for criminal trials, where as an ACWO court during criminal trials. I have done full court leave to appeals and special reviews, and I'm currently sitting with petitions and bails and things like that. But I've not sat as an ACWO criminal judge. Apart from that, I've not sat in the new family court, but previously under the old format, the unopposed roles, the opposed roles, I did deal with the matters that are now resorting under the family role.
And you've written judgments, hopefully?
I have written...
How many?
I think it was about 42, 40. I did attach it to my CV. When I sent in the form, it was 40. I think it's now 42 or 43. I've delivered... I found one that wasn't on here, and I've delivered another judgment since. So it's 42 now.
All right. And none of them have been reported?
I reported S versus the Swane, which was a criminal special review. I marked it reportable. I tried to find it. I know that on Utah Stats, it's noted as an unreported criminal trial.
The special review?
Yes, and that was just reportable because they were busy with the commission. It's a lacuna in this where the CBI is, that we keep getting the special reviews even when the proceedings were void, from the start. It's a recusal, the magistrate recused himself. They keep sending these special reviews back to the High Court for us just to order that the proceedings are declared a nullity and referred back, when they shouldn't have been doing so for ages. So that was marked, and then the judgment that I delivered on Monday, I will have also marked reportable, but I'm sure I will be getting.
What is it about?
It's about the common law. Well, it's actually about the very simple common law question is, if I find you guilty of contempt of court in a civil setting and I sentence you to unsuspended punitive committal, whether that translates into you obtaining a criminal record.
And what is the answer?
No. And you don't have to change the common law to get there.
Okay. All right. You are involved in other extrajudicial activities. You are quite active in the SACA IWJ. You're one of the mentors.
Yes, I am fortunate enough that I have now, I think this is now the second year that I've been.
Can you just explain briefly what that means, what you do?
So these are typically from the areas, the final year law students, and they essentially they need guidance about where they're going to go in their career. What is the law about? I remember I did not know the difference between an attorney and an advocate until I started practice. So you take them and you train them, you take them with you on trials, you give them guidance on how does one write heads of argument, how does the plea system work, and you just sit there and we have a list of what they should achieve and what the meeting should be about. But the role for me is more that to help these ladies understand where they're going and what they want to do with it, and to show them in a practical sense, this is what, if you're an advocate, this is what you're going to be doing in this. If you're an attorney, this is what you're going to be doing, and this is how it works. And how does one get there? And what do you need to get there? And how do you need to, all these academic concepts that you've now learned and you're brilliant and you're bright, how does one integrate them on a practical level? Because it's one thing to know what res judicata means. It's another thing to understand where it fits in. So it's very enriching to sit and see maybe a young myself and see how far one comes. So yeah, that's the essence of it. We have meetings. They also have separate training sessions by the organization itself that gives lectures. I find them very instructive for myself as well. It's always useful. So yes, it's essentially that type of a proper mentorship role to take them under your wing.
You are also involved, you're one of the judges in the JSOP moot court competitions.
Yes.
You lecture pupils, lecture and mentor pupils.
Yes, that's part of being at the Pretoria Society of Advocates. I've had pupils, and then I give lectures every year on whatever subject they allocate to me.
And you've also listed the subcommittees in which you are involved at your bar.
Yes, I've been involved in quite a few over the years. I don't know if I've listed all of them, but presently I'm sitting on the ethics committee. I used to sit on the Judicial Review Committee for the GCB, but I took myself off that committee for this year, obviously. And then I've sat on the Human Rights Committee as well for fair stint.
Okay. Thank you. SJP?
Thank you, Chief Justice. Good morning once again, Advocate Strader.
Good morning, AJP.
Your acting stints, you've listed about 36 weeks, which tallies with our records. And on these stints, are you able to indicate how many were pro bono, usually the ones that are done during recess period?
Yes, if I look at the spreadsheet, AJP, you would notice that 2019, 2020, and 21, predominantly the recess periods. The ones that I've put in italics, in fact, are pro bono, where I've put it in italics on that form. So those, let's say the pro bono appointments were therefore up until 2021. And as you would recall, this is the period when the request went out to the bar for us to assist with these appointments. From 2023 onwards, I've had stipend appointments, and those weren't necessarily in recess. Where those were in recess, that was, I would be, for instance, on the urgent role during a December recess, I recall, or things. So whereas let's say the pro bono appointments, predominantly those ad hoc appointments are to do with the RAF role. From 2023 onwards, where I worked recess, it wasn't as part of that project, it was part of the normal recess work allocated in our division.
Have you also acted in Johannesburg High Court?
I have. I acted there for 2 weeks. I did the urgent role there, and if I recall, I did the unopposed motions. I'll have to double check, but I acted in Johannesburg for 2 weeks, yes.
And according to the spreadsheet that I've got, you've also not sat in the criminal appeals, is that right?
I've not in that sense. I sat in a full court criminal appeal.
Right. Have you done bail appeals?
I did an urgent bail appeal, but just one, and that was also I think that was in Joburg while I was sitting there.
The petitions from the
I
lower court?
I have one petition. That was allocated to me this week. I have not completed that one, but I've done special reviews. I've done, I think 1 or 2. And that's the one that I wrote a judgment on. But yeah, the petition is on my desk as we speak.
This training for final year students, for how long have you been involved in this training?
The mentorship program.
Yeah, mentorship by PSA.
Yes, it's not by the PSA, it's by the South African chapter of the International Women Judges.
Oh, okay.
Yes. There I've been involved, this I think is my second year, I'll just have to double check. I've had, yes, so this is my second set of 2 mentees, so yes, it's my second year that I'm involved in that program.
There's another one by PSA. Are you also involved in it? Pretoria Society of Advocates?
For final year students, no.
Okay.
I train pupils for the PSA.
All right. Thank you. You would have seen the comments by GCB.
Yes.
That the appointment may be premature. What's your comment on that?
The problem with the problem, let me phrase it politely. The GCB, I don't know if they have properly perused my application form. JP, you would note that they say, for instance, regarding my appointment, that I've predominantly worked in recess periods, therefore default judgments, unopposed motions, and the like. I'll get to how condescending it is to assume that people who work in recess periods aren't doing proper work. But I mean, factually, that is incorrect. I've not predominantly sat in the default judgment role. If IJP, if you have regard to that spreadsheet, I have spent 8 weeks on the unopposed motion role, of 4 weeks on the, let's call the TIC role, 3 weeks opposed, interlocutories 2 weeks, civil trials 11, special civil trials 1, full court appeals 2 weeks, urgent court 4 weeks. So it's definitely not that I've only sat in recess periods. That's factually incorrect. Since 2023, I've sat in recess twice. So that is just blatantly incorrect. And then the notion that I've only sat most of my periods are 5 days, that again seems to be a reference to those early stints where I was doing the pro bono work, where we were called upon to do 5 days here, because we were doing it pro bono. Since then, after the Bridget Mabandla course, when I started earning stipends, it's 2 weeks, 3 weeks, and then if one wants to use such terminology, then it's proper judge work, then it's not the RAF project. I'll get to how condescending the terminology of the GCB is in this form in that regard. But doing proper court work. So that assumption is blatantly incorrect. And while I'm on this subject, and I've now alluded to it, I might as well address it front out. The intimation that these ad hoc recess appointments are somehow lesser law, or that the work being done by the judges, acting judges in those types of instances is somehow lesser of importance, I quite frankly, find offensive. They're doing important work. Whether you think RAF is important or not, it's in our courts, and it's important to every claimant, whether it is a TIC. It is a pet peeve of mine, this attitude, and I'm very disappointed that the organization to which I subscribe takes this type of view of those types of appointments. So that is incorrect, yes, sorry.
I agree with you. It is an important job, and the minister also decided to give extra 10 judges so that we can deal with this work. There's also a criticism by GCB in paragraph 9.4. They say that you don't give your own reasons in your judgments. Yes. Can you comment on that briefly?
That case, firstly, that they're referring there to, it's not a judgment, it's the reasons that were asked, and you have to understand the context. That judgment, or that's one of the cases that led to the writing of the judgment that I included in my bundle, the Old Trafford case. And it's essentially sitting at unopposed motion court. And every day we get applications for the sequestration. Body corporates are applying to sequestrate someone because they got a nilla bona in the match court for 30,000 rands, and now they want to take his house. And it's stratagem to bypass the provisions of Rule 46A. It's blatant. But be that as it may, my sister van der Schuyf had written a fantastic judgment in Waterkloof Boulevard. In court, this particular counsel, I took him through his papers, and I took him through Judge van der Schuyf's judgment, and I said, please, in future, look at this judgment. And I even remarked, as he was going out, don't ask me for reasons, I've already given you the reasons. And the next thing, the request for reasons come. So the paragraph they've quoted at the end, I actually do say these are the facts, and they are the same as my sister van der Schuyf's judgment in Waterkloof. But in probability, because I probably should maybe have not explicitly put it like that, but this was the admonition as he was walking out of court was, we've now gone through the exercise, so don't ask me for reasons, and they ask for reasons. So admittedly, when read on its own, it might seem like I'm not giving my own reasons, but I do. She's already written it perfectly. The applications are cookie cutter applications. Why I should write when she has written it much more eloquently. So that's the context of that particular one. It wasn't a judgment. Firstly, it was reasons, and then there's some background there. But then they've also commented on other cases that they've not read. The comment regarding, I think it's Moloi Sane, where they say that I erroneously left in the word insert. It just shows that they simply haven't read it, because in Moloi Sane, it was an extempore judgment that I had typed, and upon reading the typed judgment, it didn't work in terms of as a standalone judgment. And then I start the judgment with explanation of the rules and where one can insert clarification. And then I set out at paragraph 13, framework for revision in CASI. And then I say the transcript of the extempore judgment and the transcript of the proceedings will be uploaded. Save for the usual editing of spelling and linguistic errors, the removal of interjections and addition of citations, the extempore judgment as transcribed will be reproduced below. And then I say, where the extempore reasoning is obscure and requires clarification or further context, such contextualization or clarifications will be clearly demarcated in italics following the designation insert. So if they'd read the judgment and not just scan through it, they would see the use of the word insert is actually quite pertinent to the judgment. So they have not read this judgment. Similarly with day. They criticize me on day for the crisp point and then going into peripherals. But if you read day, I start off in paragraph 3 saying, yes, this is what the crisp issue should have been before us. But as per the norm, they've come with all sorts of technical objections, which form the greatest portion of the argument. Here we go. Let's engage this. It's actually a commentary on the habit of counsel to not just address the clear point, but to take these technical points. And it's not a peripheral for a full court to decide the arguments before it. A point in limine is a point in limine, whether I think that it's ridiculous to take these technical points. You can't not engage with it because the points in limine is raised in day were the majority of the argument.
So you are saying some of the criticisms are unjustified.
Yes.
I sometimes invite you to come and assist at short notice, and you do come
Yes.
to deal with matters, and that would also call for you to spend time in preparation. So as far as you are concerned, are you ready to be appointed permanently?
I am more than ready.
More than ready.
I'm chomping at the bit.
Okay. Thank you very much, Chief.
Thank you, AJP.
Thank you,
President.
AJP. Premier.
Thanks so much, Chief Justice. I'm covered. Thank you so much.
The next hand. JP Tlaleti.
Good morning, Advocate Stradom.
Good morning, JP.
Yes. The company ADV Current Stradom Pty Limited, what kind of business is it conducting?
It's me. I pay myself, and then I get a pay slip so that I can, for instance, get a cell phone contract or a home loan. Or it came by virtue of the fact that as advocates, we don't have a company, we're sole practitioners. And when I tried to take out a bond for my house, they're like, do you have pay slips? No. Do you have, in your sole practitionership, any assets? No. And I'm unmarried, so there's also not another spouse. So I pay myself from that account. I pay the pay as you earn, etc. But it's me. I'm the sole shareholder, sole director, sole everything. It is just to simplify it in terms of explanation. When, for instance, really cell phone contracts and home loans, they wouldn't give me a bond because I didn't have a pay slip. My secretary, who gets a pay slip from me, on the strength of that, was able to get a home loan. But yeah, so that's the business it conducts.
How do you define that business in the memorandum?
It's a legal services provider.
Legal services provider. Yeah. Thank you, President.
You, Prof.
Good morning, Advocate Stradom.
Good morning.
I want to talk to you about two cases.
Yes.
In the back of my mind, I know that you wrote the Moloi-Sani judgment. For some reason, I don't get it from your document. Did you refer to it in these documents?
Sorry, which judgment?
The Moloi-Sani.
Moloi-Sani, the GPF one.
Yes.
Yes, it's not in yet.
Can we start talking about? Do you still remember it? Because that's the one that I wanted to talk to you about.
I should have suspected it. I briefly went through it. It's the one about the pension fund and the benefits. Yes.
Because I just got reminded now when you mentioned it, and I know that I've read it before. So and it's still
Yeah.
very much fresh in my mind.
I should have
Can we-
expected that you would have read it.
Yes, can we
Yes.
deal with it?
Yes.
My understanding in that judgment, it was an anticipation sort of order that was requested, and you had to interdict
Yes.
in the case. And from my understanding, and correct me if I'm wrong, you are dealing with a pension interest
Yes.
and how a pension interest ought to be dealt with. And what I saw, it appeared to me that you dealt properly with the requirements of an interdict in that case. But what appears to me is the same as something that seems to be happening across the divisions in South Africa of the High Court, where there is no proper engagement with the relevant pension law principles that are applicable.
No.
In other words, when one look at the legal framework that governs pension interest, once the pension interest accrue or the pension benefit accrue before divorce, that means the non-member spouse is not entitled to benefit from that as a matter of statute.
Yes.
But perhaps from a marriage point of view, it is something different. But it appears to me that courts are not grappling with that particular position, even though there is a Supreme Court of Appeal case that was written by now Chief Justice Maya, crucial case that gives a platform or a framework as to how those cases should be dealt with.
I haven't read the current judgment. The problem is, and this is especially in Molosani that I was confronted
Yeah.
with, because on the one hand, they're asking me from the interdict perspective to protect something that you don't have. They don't have an interest yet because it hasn't accrued yet.
Yes.
But if they don't approach the court for this protection, for this anti-dissipation type of proceedings, then exactly what you've now referred to happens when it does accrue. Simply the pension fund is dealt with, because what happened, if I recall correctly, and I've said it's been a while, is the respondent, via the grapevine, they found out that he has now resigned from his employer. But they won't even admit that. They won't. So now she is sitting in a position where she knows he's going to dissipate it. She doesn't have that interest yet because the divorce is not settled. So there's a definite, it's kind of a damned if you do, damned if you don't type of scenario. Where,
Yeah, but the problem is this.
Yeah.
In terms of the Pension Funds Act, Section 5,
Yeah.
Subsection 2, it is quite clear that once the fund has received the contributions, those contributions are deemed to be part of the assets of the fund. They don't form part of the estate of the member. So in other words, even somebody comes on an anticipation or interdict, there's no real life sort of interest that they can claim on. But anyway, let's leave that aside because it's a little bit technical. You don't have the judgment with you. I want to ask you about, there's a judgment that you circulated to us, and we've just spoken about that you delivered quite recently, the
Yes.
contempt of court judgment.
yes.
I read that judgment. I looked at paragraph 38 of that judgment, where you articulate what the vexed question is in the case. And then in paragraph 41, you go on to explain the UK position as to how civil contempt of court is actually dealt with in that case, in that country, that it does not constitute a criminal offense. And you go on to say you accept that in South Africa it does constitute a criminal offense.
Is that sorry, I just want to get the right
Yes.
judgment. There are two.
The second one.
The second one.
Yes,
Okay.
the second one.
Yes.
And then in paragraph 42, you go on to say that there is an uncertainty as to the impact of civil contempt in South Africa. I could not, because when I read the judgment, it appeared to me that your biggest issue there was how should we treat the disobedience of court orders, and should this disobedience lead to a criminal record? I think that was the
question,
fact
yeah.
issue, right?
Yeah.
But I could not understand why is this an issue, because in Zuma 2, both the majority judgment and the minority judgment, to some extent, they do answer this question, that a contempt is a crime, even though whether it comes through civil or criminal, it's a crime. And if you are found to be in contempt, we might argue about whether you're going to be coerced first or you're going to be punished directly. But at the end of the day, ultimately, if you are punished through being sent to prison and you are serving, you have been convicted, and that is a crime. I think the Constitutional Court has answered this question, but it seems like you don't agree that it has.
No, because and that is exactly why this question is, this case has broken me, to be honest. That we started off from that perception, but you'll see halfway through the second judgment, I say, this is what we thought. And I set about saying, okay, initially the query was fine. There's a precedent that if you've got unsuspended punitive sanction, then it counts as a conviction. Okay, but now at what stage do you become the criminal? Because in criminal procedure, the criminal case, regardless of the sanction, you get a criminal record by way of conviction. In other words, when I make the declaration XYZ committed murder, that's it, regardless of the sanction imposed. So we can't take it that way. Surely the contention has never been that if I give a unsuspended sentence that you now have a criminal record. So we can't use that. That's when we started asking the questions. That was the central premise of the problem statement that I issued in 2024 and that we discussed. And Zuma, IC versus Zuma, this is MK then came back. And I started writing the judgment. Not with whether it's coercive, whether it's punitive. And you'll see in the second judgment, I say, and a wonderful judgment was written. But this is not that judgment, because go and look at where we're getting the terminology. First of all, if you put it here, because and I don't want to step on any toes. IC versus MK, or MK versus IC, depending on which part you were. The court never said anything about a criminal record. The court was interpreting conviction and sentence within the context of the provisions of the Constitution about the eligibility provisions. Similar in the parole matter, conviction and sentence were being used within the context of that act. You'll see the Zuma, I've referred to it now as the Zuma contempt order, doesn't use words conviction, etc., and refers to committal and so forth. And that's, upon reading it, the concept that civil contempt, disobedience of a court order, is a crime, arises from Farki. That's everyone citing Farki. And you'll see at the start of that first judgment, the introductory paragraph is Judge Cameron in Farki, asking this very question. The very question that I was posed with was asked in Farki in 2007. And that was the start of the niggle. And throughout the remainder of the first judgment, I go through and I trace back exactly what was said. And this is where it becomes important to remember that we have a criminal offense of contempt of court. We have that. S versus Bayer. Civil contempt, but tried in criminal proceedings. Yes? By virtue of the fact that we have, in terms of our Criminal Procedure Act, we have incorporated common law offenses as listed offenses. And I even go through the example of saying, let's call it another name, then it becomes more clear. So there's the criminal offense, contempt of court. That's why I sent the judgment through, because it is quite a lot. There's the criminal offense, contempt of court. And everyone's defined it as a crime, and it's a defined crime. But that is not the same as an offense of a criminal nature. And what you'll see is, in Farki, they're not saying that it is a crime, boop, in isolation. In Farki, they're saying What they've said is because of the criminal nature, we're imposing a criminal sanction. So in civil proceedings, it goes towards, that is why, as a justification for imposing a criminal sanction, it's not a conviction. And where the Constitutional Court and the SCA have in the parole matter and most recent MK used a case law that relates to the prior convictions and determination for the prior convictions, they've been very clear that they've been using it within the context of that act. But you've got to define, if you want to, criminal records resort under the Criminal Procedure Act. So the concepts of conviction and sentencing must be defined in terms of that act.
Definitely, I don't have enough time to take it through, but to say that in the Zuma 2 case, the word conviction appears about
Yes.
28 times.
It does.
And Theron in particular deals with the issue of how conviction impacts the whole thing. And there was no need at all to deal with criminal record. I mean, it follows suit. But anyway, let me leave it there. Thank you very much, CJ.
Could I follow up on this?
Is the follow-up, Commissioner?
Yes,
Mangena?
it's a direct follow-up on this one.
Or the Mangena has his, Commissioner Mangena has.
No, he can go first.
All right, go ahead, Commissioner Ngaito.
Thank you, Chief Justice. Advocate Stradom, if in that native child case there had been a summons for contempt and a trial, would that be a criminal conviction for the purposes of Section 271 of the CPA?
I'm sorry, a summons, and I couldn't quite catch that.
If there had been a summons to attend court
Yes.
in a criminal trial,
So he's been charged.
yes,
There's a charge.
through a
there's-
summons, yes.
Yes. Well, then if a criminal court says we find you guilty and we sentence you, that's guilt and sentence as per the various cases that were cited.
No, just please, more specific, would that constitute a previous conviction under Section 271 of the Criminal Procedure Act?
If he was tried and convicted in a criminal court, yes. But that doesn't, but the sentence is irrelevant. For
No, I'm not
purpose-
talking about the sentence, I'm
Yes.
just talking about the conviction.
correct?
Would that be a conviction for the purpose of Section 271?
Yes.
Now, all of the cases then that Commissioner Maruma Okhaya is taking you through
Yes.
say that the so-called civil contempt is a combination of a criminal process and a civil process. And that's why in South African law, contrary to English law, the finding of guilt for contempt is a crime and has the natural consequences of it being a crime.
Commissioner,
But you
that is-
seem to have a different view on that.
Commissioner, that is not what those cases say, with all due respect. The
Sorry.
cases where it says, we're talking about, let's start with Faki, because this is where it's a crime comes from. In Faki, it's quite clear that the justification for imposition of the sanction is the inherent criminality. So there's a distinct difference in terms of, it's not a conviction and sanction.
That's what I'm struggling to understand, because that's precisely the finding of the Constitutional Court.
Yes, the
In,
Constitutional Court's correct. 100% correct.
All right, but okay, somehow. Anyway, let me ask you a different question. I don't think we have enough time today to
If
discuss
I just
this.
may, Commissioner, it is a very, and I would like an engagement on it. It is actually much simpler than one would think, but that's why, and I apologize for sending that through too late, because one does need to really grapple with the constructs and what was said in an interpretive sense. And that's why I sent through the judgment, but I appreciate that this commission is too busy to have had regard to it. But
we did have
I just want to
regard
make sure. I just want to make sure that nothing in my judgment is contrary to the finding in the Constitutional Court. In fact, it supports everything the Constitutional Court has said, the SCA has said. It's just about the approach. But yes, sorry, I interrupted you about your second question.
Yes, the GCB says that you took a year and a half to give that judgment.
Yes. The second judgment.
Yes.
This one.
Yes. In fact, now you gave that judgment on the, I think, yesterday,
Yes. No,
that you had
on Monday.
on Monday, or well, we got it, I
Yes.
think, yesterday or the day before.
I do explain it in my judgment, and I'm thank you for the opportunity for addressing it because I know what it looks like. Let me start off by saying the judgment between the parties was delivered. I heard them in December. It was delivered in January. My findings, my order, inter parties. This issue of the criminal record, I had raised very much and I reserved it. Then because at that stage, the whole eligibility issue was coming to the fore. So then we had the discussion in the June. And as I said there, at that stage, the Law Commission, and that's what I'd really actually like to engage with you. The South African position and the British position actually aren't different. But the Law Commission was busy with a report. The Victorian Law Commission was busy with their own report. It's taken them 7 years, and I waited for these outcomes. When they finished their reports, I started drafting the judgment that I referred to, and that dealt with all the issues such as coercive or punitive, etc. And that's why in this judgment I say, this is not that judgment, because I was wrong.
No, I'm talking about the second judgment. You
Yes.
reserved that judgment in January 2024. You
No.
gave directives that
Sorry, I did not reserve that judgment in January 2024.
when you gave directives in January 2024 that parties must address you within 10 days on your problem statement.
That they must file their papers. They addressed me in June 2024.
Not within the 10 days in the
No,
judgment.
they had to file their papers within 10 days.
Yes,
It was
all
an
right.
engagement, and this was a mere motu thing.
All right, let's work on June. I don't want to quibble with that. Let's work on
Yes.
June 2024. The GCB says it's still a year outstanding at the time they wrote.
Yes, and I considered that, and it is contained in the second judgment. So what's happening here is, as result to the parties, the applicant there was compliance. The respondent had complied. The applicant has withdrawn for all intents and purposes and not taken.
Sorry, Advocate, I'm sorry. If you could just really be precise. I just want to know the reasons for the delay.
I'm trying to get there.
Okay, well.
The
that's fine.
question
I'm
is
listening.
not a simple question. And we can sit here and we can debate it for the next 2 weeks.
No, Advocate Stradom. The rules are clear. You must give a judgment in 3 months.
I gave the judgment.
And then, yes, but this judgment is reserved from, according to you got submissions in June 2024.
Yes.
You've given the judgment only yesterday, on Monday.
Yes.
Now, the rule is that you have to give a judgment in 3 months, and the maximum period is 6 months. And then if you can't do that, you must ask the judge president.
Yes.
That's what I'm asking you about. The GCB says you cannot wait for a year and a half. So what is the explanation?
If I may, the judgment as on the issue that was before me was given. The only question was whether the respondent would have a criminal record as a result of my findings. That I had raised mere motu. And I explained in my report that there was no clear-cut answer, because despite the common perception that it has been decided, it has not. I waited for the reports of the UK Law Commission. I waited for the reports of the Victorian Law Commission. Those came back inconclusive. I addressed it in the second judgment when I looked at the question of delay. As to the applicant had gotten what she wanted, of what they wanted, the company. They'd gotten compliance. As to the prejudice to the respondent, while she was at risk of a criminal record. So there's no prejudice to her to make sure that it is correct. So as between the parties, the justice had already been done. I had raised this point meru motu, and now I have a duty to make sure that I get it right, because I was not prepared to, on the basis of a rule of general application, to make criminals of everyone that's ever been imposed a sanction in a contempt of court proceedings. So the judgment, I've written 2 judgments. The normal course judgment I gave well within the 3 months. The portion that I saddled upon myself, yes, that took longer. But because of
That's
how
what I'm asking. What is the explanation for that? You say you
And
waited for the
I,
research.
yes, I waited for that report. I waited
When
for
did those come?
the Victorian Law Commission is now postponed it to the end of November.
So they never gave a report.
They've not given the final one. They've got the interim commentaries one. I've looked
When
at
did
those.
that come?
Those, the interim commentaries.
Yes.
And there are several different portions. So I think the last ones that I looked at are also about June. Similarly with the British Law Commission.
All right. So in June already you have the British Law Commission and the Victorian report. But what is the explanation from June up until yesterday?
And that's also contained in my judgment. When I received it, I started writing the judgment. And it was a brilliant judgment, setting out all sorts of very clever concepts. But I was wrong. I was wrong, and I referred to it in the judgment as confirmation bias, in assuming that the Constitutional Court had said, yes, you will have a criminal record.
But the only thing I could see in the judgment is that you were busy researching the judgment and then changing your view as you go along. I couldn't see anything objectively that stopped you from finalizing the judgment timeously.
As I've said, the judgment that I'd written initially was based on the incorrect premise that has now been canvassed, or the incorrect assumption that the common law has, after the Constitutional Court had answered Judge Cameron's question in Farki, which they decidedly did not.
All of those judgments of the Constitutional Court were out by June 2024.
Yes. And I assumed that exactly as everyone else apparently, that it stood for one, in principle, that you would have a criminal record.
That's what happens when you write a judgment. You read a judgment and then you
Yes,
can...
but it doesn't say that.
Sorry?
I
What does it
disagree that it says that.
I'm not saying whatever the outcome.
Yes.
What I'm saying is, though, everything that you needed to write your judgment was available in June 2024.
No.
But you gave the judgment. So what you say was not available in June 2024?
I'm not sure you're going to get the result you need by taking this any further, Commissioner Ngugaitobi.
I stand
I
corrected,
get-
Chief Justice. Thank you very much for the
But
time.
you can continue if you
Yes.
want.
All right. I do, unfortunately. What was outstanding from June 2024?
As I've indicated, in June 2024, we had the meeting, and I started as I go through Mighty Solutions in terms, of course, of the meeting. We had the matter was argued. I go through Mighty Solutions, and I have to answer, what is the common law? Why is it there? And the position is not clear.
No,
And
I
note
understand
from-
that. I don't have a problem with the method of writing a judgment. I'm not questioning it. I have a problem with an unexplained delay of more than a year.
I'm trying my utmost to explain the delay, to explain why I could not willy-nilly, because I'm now being forced to a 3-month period, make a determination on something as crucial as criminal records. And in that regard, I had to have regard to what is the real common law position. And there were no judgments within South Africa. There was no position in South Africa. The British common law seemed to be at odds, and I needed an explanation, but then why is the British common law at odds? And then I noted that they are busy with their review, and they're busy with their program. And one of the pertinent issues raised in their Law Commission report is that they are criminal records are still being noted against people for civil contempt, even though in that jurisdiction it's not supposed to happen. A similar issue was raised in the Victorian Law Commission's report. Both of those commissions were intensively looking at that. We have nothing in South Africa. I have to go look outside of South Africa.
Yes.
And I
All right.
waited for those reports. When those reports came in, I started drafting the judgment. I finalized the judgment, and I realized there was such a degree of confirmation bias that the Constitutional Court has decided Section 271 as being applicable in civil contempt proceedings, that we've approached this from the entirely incorrect perspective.
Yes.
And that you
Did you ask
can't use.
Did you ask the JP for an
Commissioner
extension?
Nugaito, that is her explanation. Whether or not we find it satisfactory is something else, and we can, talk about that at deliberations when you assess her.
Yes.
I think she's given an explanation.
I stand corrected. I'll stop here.
Yeah. Commissioner Mangen?
Thank you, Chief Justice. Advocate Stradom, one of the key attributes of a judge is good judicial temperament. And the factors to be taken into account, one of them is patience and willingness to be persuaded. I got a sense that you are impatient with, and you were impatient with Commissioner Marumagai and Commissioner Nkweto. Is that assessment correct?
I apologize if that may seem that I would rather, I'm not impatient. It's just that this particular subject and both of the commissioners featured the submissions and the articles that they've written and the heads of argument they've submitted actually featured significantly in this judgment that I've written that has taken over my life for the past year. So if I seemed impatient, it's more because I feel very passionate about this particular subject. And I do apologize. I don't mean to seem impatient. It's more a question of that the very people that I've been having conversations with in my mind for the past year, I actually get to talk with in a live setting. So I do apologize if that seemed if it came across that way.
Okay. In the answers that you gave to the AJP regarding the comments made by the GCB, you used the words like the GCB is condescending, the GCB probably has not read, and their objections are technical. And I thought that whatever comments that they made them as part of criticism of your judgments and your work as an acting judge. And shouldn't you have seen that as part of constructive criticism and as something that you can learn from instead of being defensive?
As I've said, I've sat on this committee, and I am very, very FA and prefer constructive criticism. The reason in my conversation was, and that's why I pointed out, that they did not read the judgments. It's not me being defensive. If you just look at where they're commenting on the Mulasani case or the Mulasani judgment, they're saying, I forgot to take out the word insert from the judgment. But the word insert should be there, and if they'd read the judgment, they would know that. Similarly, the day matter, if they'd read the entire judgment, they would know the entire judgment is an ode to a full court's complaint about these other technical points. And then in terms of the condescending comment, I actually stand by it because of the way that they've phrased the default, the recess work being undertaken by pro bono advocates. It doesn't apply to me because they're factually incorrect. I've not spent most of my time in recess, but I think it is condescending, the tone taken, that somehow advocates that take time away from their families and come and act for free to help out the court are performing lesser judicial work than other people. And I'll stand by that comment. It is condescending. So insofar as I'm not being defensive, they're correct. On the, not the Deswani, the Zarambi matter, I probably should not have, in my reasons, I should have put it better. I agree. But don't be factually incorrect. And don't act as if some law is more important than other law. I'm sorry, and if they've taken the time to read my application, I actually went on quite a bit about that it is my pet peeve that somehow it's more important if you do a big competition matter than if you do an RAF matter. And that I'll stand by that, and I will be probably noting an issue with the way they've raised this. Yes.
Thank you, Chief Justice. Thank you, Advocate Strader.
Commissioner Jivan?
Thank you, Chief Justice. The one case that you cited in the cases that you appeared in on 6.3 of your questionnaire answered, in which cases you have appeared would you regard as being more significant and why? You cited the J.M. Koza versus the Ayers.
Yes.
As somebody involved as a property practitioner myself, I find that a common problem, as you cited in your response. What was the outcome? You haven't given us in the summary what was the outcome of that case.
The registration, fortunately, this was in the Polokwane High Court, where the judges perhaps have more of an instinct towards what's happening in the rural communities. It was granted, that occurred, and they duly got the property. And regrettably, it's one of those cases where it would have been great to have an updated judgment, just saying what we already know, because it's apparently the situation is prevalent when one goes into the more rural areas.
Thank you, Chief Justice.
Commissioner Hassan?
Thank you, Chief Justice. Advocate over here. Advocate Stratham, I also want to ask you about the process of being appointed to the Refugee Appeals Authority in February of this year. Have you already begun that work, or when did you start?
No, so actually we got an email yesterday to give dates for when we can start assisting them. So we haven't started. We did receive, after the application, we did receive our appointment letters from the minister. So, and essentially we work on an ad hoc basis to help. It's similar to what we're doing in the courts, a project to assist to get rid of the backlog. So we've got to give dates now this week for when we are available to come and sit and work through that backlog.
Okay, so I'll ask these questions in a future context. So in my constituency work as an MP, there have been quite a few, in fact, persistent complaints about the backlog. And even this most recent weekend, I had a complaint come to me about the inability to even access the refugee center in Marabastad. So it's a very, very big issue. And these are obviously people from war-torn countries. We know that in the last 2 years, we have seen more conflicts in the world than I think the most recent 50 years or something like that. So we recognize that it's a geopolitical issue. But I'm interested, Advocate, especially now that we're looking in the future, what your plan might be in terms of practicalities to eradicate the backlog, bearing in mind, those real barriers of language, trauma, missing documents, and other precarious legal statuses.
So the assistance of the members of the GCB is actually a proactive step from the side of the minister to eradicate that backlog. And what we have already received is quite invaluable training about how it should be done. Because you have to remember, we're sitting on the appeals tribunal. We're not the port of first entry or the point of first contact. So it does make it difficult. They first got to go on appeal before they even get to us. But in terms of and I found it fascinating the way it's handled. It's not an accusatorial, it's inquisitorial. There are procedures in place for dealing with trauma, for missing papers, so once they get, I'll leave you to this, so once they get to us, they are well catered for. The problem being obviously at the point of first entry, where they've now got to declare that they're looking for asylum. Those are where the complaints are. And invariably, this is now from my acting stints, we deal with those in court on review mostly. Yeah, so unfortunately, there's not much that we can do as the appeals tribunal, that has to actually go to the, let's say, the point of first entry.
All right, I'll ask this question, I think, regardless, because I am interested in your views. I had initially thought that the process had begun, and so I was wondering, based on some of the experiences you might have had, who else needs to be at the table? You know, do we need the Department of Home Affairs, legal aid, pro bono panels to ensure that backlog is eradicated successfully? And now I am also interested, and I also am interested in the colleagues in the room, whether one can serve on the bench and also serve on this appeals authority.
About your last question, I'm not sure. In any event, these aren't permanent appointments, these are ad hoc. So I don't think that should necessarily be an issue, should I be appointed, but I mean, that's what we'll deal with. As to who else can be at the table, in terms of the constituting the members of the tribunal itself, that is set by law. In terms of who can help out, so for instance, like the PSA, we've now offered our time, etc., and we're getting a stipend for it. You can get more people involved. The problem just being, where's the money coming from? And what I understand, the biggest problem, the backlog, is that the EU, and I was talking under correction, the UN used to give a substantial amount of funding for the tribunal, which funding has now been revoked. So it's literally just a case of we need money. But I think that's the common theme with all the great projects that we want to embark on.
Thank you, Chief Justice.
No further questions, colleagues? Commissioner Matolo Tlebu.
Thank you, Chief Justice. Good morning, Magistrate.
Good morning, Commissioner.
I just want your response to the LSSA comment. They say she has one reserved judgment, whether she has no reported or appealed judgment, she has no publication in the legal field, she has not held any quasi-judicial role, nor served as a magistrate. Considering her experience in litigation and judicial exposure, she retains qualities required to serve as a judge. However, she will benefit from additional acting stints to accumulate reported or appealed judgments. What do you say to that?
Obviously, one always experience is great, but if the purpose for further acting stints is that more of my judgments can be appealed against, and that somehow subjects to scrutiny, I don't see, I don't quite know how long I'll be waiting, depending on my judgments, I guess. So I don't think it's a well-formulated, I actually don't know how to answer that. In terms of how much more experience I need, there might be disagreements about with correctness of my judgments, but I've written widely on various issues ranging from contempt of court to criminal appeals to deciding issues between the LPC and the DEL. I've had that experience, but and I think, and I'm talking under correction, I think a lot also arises from looking at the week's experience and saying, well, we think you should have more experience. The problem just being is it doesn't take into account the 8 months of my life that were dedicated to receiving in-depth training. And I can assure you, for the rest of my career, I will never have that type of training again. I'm not going to be able to have such a course again. So I don't think, I can't wait until all my appealed so that the ECA can tell me how wrong or right I am. The long and short answer to that question.
I mean, the second one, having had the exchange between you and the commissioners, do you think you have patience to sit, to be as judge?
I definitely have. Anyone that's appeared before me, I've listened. I listen long and I listen to the entire argument, and I listen even if I'm being criticized for the day judgment, but they engaged in very lengthy debates about issues that actually weren't mundane. But I listen to them and I entertain them, and I go through the trouble of writing a full judgment on them, even on the leave to appeals, where I am passionate about subject matter. I can become impassioned, but not as a judge, as especially on this. If you're talking about the exchange of the contempt of court, it's simply because this is, for the past year, my child is so tired of this case that he doesn't even want to look at the products anymore. But I'm definitely a patient person with everyone that's appeared before me. And I don't think that there would be any comments to the contrary thereof.
Thank you, Chief Justice.
Anyone else, colleagues?
Thank you very much, Chief Justice. Good morning, Advocate Stradom.
Good morning, Minister.
I noted, which I'm quite impressed, I noted your work around mentorship and also your participation in moot court. Maybe just take us through part of why you've decided to be part of this and your experiences out of it.
Well, moot court, I don't know if I should admit it to everyone present, but I wasn't necessarily the best student when I was doing my LLB initially, until I was part of the moot court group that went to Washington and did the JSIP. And it changed everything. It made law this beautiful, beautiful thing. Anyway, so then we move on in years, and the previous JSIP contestants get invited to sit as judges and to assist in that sense. And the answer is of course. And it's very rewarding to see how clever the current students are. I can't recall us ever being that clever. So I've sat once or twice as a judge. Unfortunately, during COVID, usually what happens is we sit, it's supposed to be a live session, but we had to do them online. And depending on what goes forth from here, I'm hoping to go and sit in on the live sessions as a judge there as well. So it's there. I've not done it's not a mentorship part of the program because I'm sitting as the judge in some of the rounds for the JSIP competition.
On your mentoring, you're currently mentoring 2 legal practitioners?
They're students.
Or they're students?
Okay. So I have, in terms of the Black female counsels that work with me, I'm not mentoring them. They're quite clever. They're working with me, and I'm assisting them in terms of skills transfer or handing over briefs to them. One of them's acted as my junior. I think last month we were in Polokwane with the trial. So that's a separate issue to the formal mentoring positions are with the South African chapter of the International Women Judges, and mentoring in terms of the Pretoria Society of Advocates. These are colleagues of mine who are junior to me, who I'm assisting with skills transfer.
No, that's commendable because we quite raise it quite often about the need for mentorship, but also for appointing juniors as senior advocates so that there is that skills transfer. So it's quite important that we continue because we're talking about transformation of the sector. But from your point as well, talking about that, in terms of the work that you do, how do you see access to justice and also the work? Yesterday or the past few days, we've heard about advocates and legal practitioners who are talking about lack of briefings, especially for female practitioners. And therefore that actually continues to perpetuate the inequalities. Your views on that?
It's very difficult for me to say that I'm not being briefed because I'm a woman. Might be that they just don't like me. I've seen it happen to juniors. I've seen it happen, regrettably, to friends of mine. I've been very fortunate. Obviously, as I've gotten more senior, I have a core of supportive attorneys, but it does happen. And I've obviously been told not to engage specifically, but it's all fine and well. We have these beautifully now transformative rules that you must brief this and you must brief that. The problem is, and this is I do RAF. There is no way you can justify costs of two counsel. So what I do with my matters is they're not briefed per se as my junior, but I would do if there's the merits are simple and it's a separated trial. They would come in and they would do that for their own account. Likewise, if it's an unlawful arrest matter and the merits are difficult, I would do the merits portion of the trial and then stand back and let them do the quantum. And we each say it's costs of one counsel, but we do separate work and the client only pays costs of one counsel, if you understand where I am. Because it is true, you have to in court, if you want costs of two counsel, you have to justify it. That's the practice. So I understand when my colleagues are saying we can't afford costs of two counsel in our practice, that is quite correct. But that does not mean that where you get a brief that is because your attorneys like you, is in actual fact one that is far more befitting someone more junior, that you should then hang on to that brief at all costs just to make money. If you know of a deserving candidate, there's no reason you can't, as I've done now with one of my attorneys, ask him to pull in this junior and first work with this junior so that they're at a level that the attorneys are comfortable with him, and then to step back and to say, listen, I'm still here, but you handle that side of the work. I think that's the only other practical way we can actually draw people in and assist them.
Commissioner Pillay. Thank you, Chief Justice. Good afternoon, Advocate Strader.
Good afternoon.
I just want clarity on the answer you gave the Minister now before I put the questions to you that I intended to. Are you saying that you don't bring juniors onto your matters in the ordinary sense?
No, I do. I have just, in September, I had, in the proper sense, I was the senior and she was the junior. But that case, I could justify the cost. In other words, when we win, which we will inevitably, it's part of it, but when we win, the state will have to pay costs of two counsel and we can recoup costs. What I'm saying is, it is in the sphere of the type of work I do, it is rare that a case is that complicated that would justify that. But that does not mean that you're excused to sit back and say, well, I can't help it, my work is not enough. If you get briefs in that are that simple, then this junior, for instance, the junior that now sat with me is one of the juniors that has come up from my attorneys, from that incentive that we're training her up, and invariably she will be at a level where I can quite comfortably say, my attorney, I've seen this brief on this matter, I think maybe she should rather take it. We're comfortable with her progressing like that.
You're saying in your field of work, it's rare for you to have the opportunity to bring on a junior?
Yes. Where you get, if you do RAF work, if you do a lot of damages, unlawful arrests, remember, if your client, RAF is a bit different, but your client has to pay. So your clients are usually indigent. So how are they paying for two counsel? They can't even afford one counsel. It's not that the work necessarily is that simple. It's that your client is not a bank or a big government entity that can afford to brief seniors and juniors. Some people just have to get by with what they have.
Right, now to the questions that I wanted to raise with you, and I'm going to put the problem statement to you, Advocate Stradom, and then perhaps get your response generally, and if necessary, we can go into the specifics. I was listening to you, your critique of the GCB in relation, I think, to your Moleisani judgment. You said that you thought that they didn't read your judgment because they didn't pick up what the insert means where you used it. Isn't the problem a different one? Isn't the problem that you adopted a very complicated way of dealing with this? You handed an extempore judgment, comprehensive judgment, and then later decided that you wanted to either add on or supplement the judgment. And that's why the poor GCB is left with a judgment which, to be honest, we haven't seen before in this environment, where you've got a judgment and then insert, and then trying to figure out, well, why is this insert here? Is it a substantive change that should have been in the initial extempore, etc.? So it's a complication that you've created through the mechanism you used.
Two parts to that. When I said they haven't read it, it is simply because they say, oh, it should have been taken out. They don't say it's because it's complicated. They say, obviously, as in my secretary left it there in error, it should have been taken out. As regards to the format that I used there, and I've discussed this with quite a few senior judges as well, and I've been critiqued from either side about the approach that I've taken there. All I can say is, as part of our training course, we have to start thinking about judgment writing in not new ways, but you can't just follow the tried and tested. And the reason why I employed that was to make sure that it's clear that I'm not changing anything on the extempore, because I did not want a situation where between the lines I'm reading things into the extempore that weren't there. So that's why I wanted it to be clearly delineated. Here is what the extempore as is, and this is, the additional, so that there's no confusion that somehow I'm changing
I accept that, Advocate Stradom. I think where the difficulty comes is when that moment presents itself, you're either ready to hand down an extempore judgment or you're not.
Yes.
Which touches a move. If you opting to, at that stage, hand down a fully substantive extempore judgment, that's it, that's your judgment.
As I said, I've looked at it, and I don't like doing extempore judgments. I think that's probably one of my only extempores. One of few, and it was the first time I encountered it. But Commissioner Marumkhao raised it, that whole issue regarding the pension interest was so important that I did not want the extempore, the way the extempore read, if you take away the inserts, and you take it out of context, and they put this on Safri, it's going to be that acting judge said X. And I could not have it be presented in that manner without the necessary context in which it was said.
And that's
looking back at it now,
that's why
I just would have avoided
it shouldn't have been an extempore.
No, I'm in total agreement with you. I just could not let that go out under that perspective.
In defense of the tried and tested, and as we understand the tried and tested rules or principles around judgment writing, it's keep it simple. And in fact, the judges have a little acronym, I think it's called IFILARO or something to that effect, which ensures consistency in your judgments. Now, I've looked at your judgments, and it struck me that you use very complicated imagery, for example, in your judgments. More often than not, in fact, I think almost all your judgments start with a quote, and then you try to make the quote relevant to the issue you're dealing with in your judgment. And I think sometimes what end up doing is you complicate the judgment to such an extent that it's difficult to follow exactly what happened. Can I just finish the point and then get your response? I'm particularly concerned about the St. James de Chantal Home judgment. You use very complicated imagery there. What troubled me is that you had an unrepresented person involved in that matter. So I just want to get your comment on that.
That case, and AJP is sitting here, that case has become a rite of passage for every acting judge in the division. The judgment's quite long, and I've set out there. I couldn't even trace all the people.
Advocate Stradom, I read the judgment, so I know
Yeah,
how
okay.
complicated
So,
the issue is.
and you'll see there that I say, yes, they're unrepresented. They're not unrepresented, they're representing themselves.
Yeah, well, they were representing themselves.
And you know, they've been representing themselves in this matter since before the respondents' counsel had been admitted. So they're not quite.
But please, if you can just address the issue of substance that I'm putting to you, is that the judgment uses such complicated imagery and you sustain it throughout the judgment.
Yes.
That the issues get completely lost. So I only picked up three-quarter into your judgment, three-quarter way into your judgment, what the application before you was. You, for example, you add at the beginning of the judgment, add a whole lot of parties on. Then you've got a footnote that says, these are not cited as parties, they're here to demonstrate how complicated the matter is, etc. So it's those kind of tools which I'm saying renders the whole judgment so complex.
That judgment, I'm glad if you could find out what the application before me was, because it was a frankenbug of applications. But I take your point on the complexity of the imagery. What I can say is, I think that's also a 2023 judgment. A lot of the judgments where I have employed that type of judgment writing style were done during my period of we were doing the training, the British Mabanda training, and we were being challenged to not follow IFILRA, to think and write judgments from a new perspective towards the people. So the St. Charles and James case is an absolute, if you saw the notice of motion, you would understand my reticence to say what the actual application before me was, because there wasn't. It was, they put everything into one. But some of the other judgments, and I do take your point, are very, say, poetic or complicated feature. But that was whilst in that period I was writing, I was being trained on judgment writing, and we were being challenged to not just follow IFILRA, to write judgments that matter, to write judgments that impact people. So in that period, maybe I could have taken it too far, but that was all part of the process of not seeing judgment writing as a mechanical process of X, Y, Z, etc., but seeing judgment writing for what it is, and it being a proper tool that you have to address towards the people, towards the parties. So yes, but I do take the point that it does get long. And St. Charles the James was, it's a very different type of matter. The parties that were cited there were cited by the applicants. What they would do is they would bring an application, and then the respondent, whoever the respondent is, this advocate would, they would invariably lose. So the next round, when they come to court, that advocate would also be cited as a criminal, as a this, as a that, or the judges of this, or so the out end of St. Charles the James is that it's absolutely an abuse of process. What was happening there? But I do take your point that during that period, I might have been having too much, tasking myself too much with exploring judgment writing.
Sorry, just a final question for me. You're aware that on the 9th of August, the judiciary adopted its sexual harassment policy.
Yes.
Have you been through the policy?
Yes, we had to, before we were sworn in now, we had to confirm that we've gone through it. I've not picked through it with a fine-tooth comb. In some extent, it greatly resembles what we already have at the PSA and other companies that I've worked with. Yes, I've seen it.
And your views on any challenges or hurdles to implementation of the policy?
Policy should be implemented, and I'm glad that there are structures for reporting. So I don't think there are challenges per se with the implementation. The challenges with any sexual harassment policy is changing the perspective of the victims. Because you can create all the structures in all the world. If the victims are still scared to come forward because of that negative connotation that invariably attaches, it's going to be a very pretty empty space. But in terms of the implementation, it should be implemented. I can't believe that such a document hadn't existed previously. But yes.
Thank you, Chief Justice.
If you didn't go through this policy carefully, as you say you didn't go through it with the fine tooth comb, but it was something you had to acknowledge, being aware of during taking, when you were sworn in. What were you signing to?
No, when I say I didn't go through it with a fine tooth comb, is I'm aware of some comments about the issues regarding some of the definitions. I didn't go through it with a fine tooth comb, as in I now have to set out whether or not the definition, for instance, of one incidence of sexual harassment constitutes an actual series of harassments, etc. But then I read it, I'm aware of what it says. I'm just not going to sit, I wasn't asked to expose on whether it's right or wrong. To me, it seems perfectly in order. As I said, it's on par with what we've had for a while now.
You are aware that you are bound by each and every clause in that document?
Yes. Now, I just know that there are some issues that have been raised regarding the definition about, what is one instance of sexual harassment, when is it a repetitive pattern, etc. But I mean, that is not for me coming in as an acting judge to be taking up writing it. But of course, I see myself bound by each and every single clause contained.
Okay. On the issue of your writing style, as was raised with you by Commissioner Pillay, I will just tell you that in my many years on the bench, the one important lesson I've learned about that exercise is to write as crisply and as simply as you possibly can, so that anyone who chances upon that judgment, even a high school child, ordinary person who can read the language you've written, can understand it. Keep things simple. That's the trick.
Yes.
Yeah. All right, we've reached the end of your interview. You're excused.
Thank you very much.
Good morning, Chief Justice.
How are you?
I am well, and how are you?
I'm fine, thanks. Just close the door. You hold a BProc degree from the University of the North.
Yes, Chief Justice.
And you're an attorney through and through. That's all you've ever done.
That's all I know.
You did your articles and then started practicing in 1996.
Yes.
And then you did a few things. You were in a partnership, then you ran your own solo practice. But until 2020,
Yes.
and since 2022, you're a consultant.
Correct,
at
Chief Justice.
Nguni Attorneys. Okay. You have sat in the executive committees and at some stage or the other chaired both the then Northern Provinces Law Society and NADEL.
Correct,
of
but
which
Nadel was not national. It was the Mpumalanga branch of
Oh, I
Nadel.
see. Okay. And you've also presided in the small claims court.
Indeed, Chief Justice.
Okay. You have acted, you've, as a practitioner, you describe a practice, a mixed practice that includes a huge portion of labor law work.
Correct, Chief Justice.
All right. So you've appeared regularly in the labor court as well as in the high court.
Correct.
And you have acted as a judge, of course.
Indeed, I have.
And you say you've acted since 2013 until this year for a cumulative period of about 3 years. Is
Yes,
that right?
The most recent calculation that I have, the cumulative period is actually 4 years.
4 years.
Yes.
All right. The first stint having been in 2013.
Correct, Chief Justice.
In which divisions? What division?
The division has always been Gauteng, but at the time, the Gauteng division was responsible for circuit courts in both Mpumalanga and Limpopo. So I did stints in both Limpopo and Mpumalanga, and after Mpumalanga was established, I did some stints there.
And during these acting stints, you've written over 100 judgments.
Yes,
How many is it?
My count is at 150 or thereabouts.
And you say some have been confirmed by the SCA, with some confirmed, others have said, and that 2 have been confirmed by the Constitutional Court.
Correct, Chief Justice. My calculation, and this also appears from comments from the GCB, is that 4 were confirmed by the SCA and 4 were upset.
And 1 of your judgments is reported?
2.
Oh, it's 2 now?
Yes.
Right. What are they about, briefly?
The one matter was about, it was a criminal appeal matter, and it was whether or not minimum sentence legislation is applicable to accomplices. And I found that it was, and they thought that ought to be reportable. The second one was about, was a matter where an applicant before me was going to leave the country for a sex change operation as a man, but come back as a woman. So an urgent application was brought seeking to compel Home Affairs to alter the traveling documents of the applicant so that when she comes back as a woman, she doesn't get into difficulties with immigration officials. So I penned a judgment. I made a ruling there on an urgent basis that Home Affairs ought to alter the traveling papers so that she can live as a man and come back as a woman and not get into trouble.
All right. You have not listed any reserve judgments as far as I can see.
No, Chief Justice, at the time they were not, but I have acted again since then.
Yes.
And I've picked up about 4 reserve judgments.
But they are well within the
Yes, it was in
requirements
August.
of the norms.
Yes, it was
Okay.
in August.
Well, the commentary from some of the law bodies is that you have a good turnaround on judgment delivery.
It's excellent, thanks.
Okay. There is one issue, though, that has caught the attention of almost all the law bodies who have sent in comments about your candidacy. Your suspension from practice for a period of 18 months, not so long ago, and the complaint is that you do not appear to take this as seriously as you should, and you have been you've not been generous with the information you've placed before this body. You've not explained it adequately.
Yes.
Would you mind explaining what that was about, what had happened?
Thank you, Chief Justice. I'm happy to explain. When completing the questionnaire, I did indicate that the transgressions which led to my suspension were administrative in nature. And it would appear that when the law bodies picked up on this, they got the impression that I was sort of trivializing the fact that I was suspended and that I was suspended for administrative issues, or that suspension was administrative in nature. I prepared a memo when the complaints came, and I explained myself that I had used administrative in nature is the terminology of the judgment for my suspension, that the judges felt that the transgressions or the offending conduct was administrative in nature. In no way am I trivializing or minimizing my offending conduct.
So you have not practiced for your own account since the lapse of the suspension period?
No, I have not. What I've done, though, was to apply for the upliftment of the order of suspension and to seek permission to once again be permitted to practice, and the High Court granted an order for me to resume practice.
Oh, it has been granted?
Correct, Chief Justice.
All right. Thank you, Mr. Toban. AJP, do you have questions for this candidate?
Yes, thank you, Chief Justice. I see in your CV career summary, you say, you mentioned Limpopo, Dwaba, and Sekaki. Who was your principal?
It was you, AJP. You are the one who signed my fit and proper affidavit.
Yeah, I hope I did a good job when you were still a candidate. And I just also want to disclose that you're my candidate and you are also my PA at a certain moment.
Yes, that is true.
also mentioned my name for references in your CV.
Yes. May I just explain that aspect, AJP? When the application was made, Deputy Chief Justice Mlambo was still the JP of Gauteng. And obviously, when I prepared the questionnaire, I had no idea that at some point you'd be the acting JP. So the explanation I can profile is that at the time when I prepared the CV and the questionnaire, the Deputy Chief Justice was still the Judge President of Gauteng.
You also state that you were a commissioner at the Small Claims Court until 2013.
Yes.
Why did you decide to not to be a commissioner any further after 2013?
2013 was the year I was approached to act as a judge, and it just became too difficult for me to act as a judge or to be an acting judge while at the same time doing duties as a commissioner of the Small Claims Court, because they generally take place after hours.
Then, after your suspension, it was on 14 May 2021 to September 2025 when the suspension was uplifted. What were you doing?
Sorry, come again.
What were you doing between May 2021 and September 2025 when the suspension was uplifted?
When it was uplifted, I then did some consulting work.
Can you maybe explain in detail what do you mean by consulting work?
Consulting work was I would be approached by legal practitioners to give assessment of witness statements in criminal matters and to also assist them with interpretation of contracts. It was generally that kind of interaction. I never consulted with any clients or appeared in court.
Did you charge a fee for the services you were rendering?
No, I did not charge a fee. It was just for my personal development to keep my mind busy during that period.
And I looked at the court order that was granted recently in September 2025. What relief did you seek when you filed your application for upliftment?
When I was approached to make myself available for the vacancies in Gauteng, one of the requirements is that one ought to file a letter of good standing. So when I approached my professional body with Thank you, Chief Justice. When I approached my professional body to be supplied with a certificate of good standing, they informed me that they could not issue out that certificate because, in their view, I was still under suspension. I was suspended by a court of law, and the only thing that should happen is that a court of law is the only body that can uplift my suspension. So the court application was informed by the response of the professional body, the Legal Practice Council, that I ought to approach the court to get an upliftment as well as to expeditiously be supplied with a letter of good standing. So then I wrote an urgent application requesting the court to lift the suspension and also requesting the court to direct the LPC to supply me with a letter of good standing, which happened.
Because in the court order stated the respondent is interdicted and directed to issue the certificate. So there was resistance. Was there resistance from the Malanga Provincial Legal Practice Council?
Indeed, there was. And when shortlisted, when I was informed by the JSC Secretariat that I've been shortlisted, they indicated in a letter that I also ought to supply them with a letter of good standing. And I approached the professional body, and their posture was that they could not support my candidature, or they could not supply me the letter of good standing. That then necessitated me approaching the court to bring the application. But once the papers were drawn and served on them, I must say that they simply filed a notice to abide, and they did not oppose the matter any further.
From your side, Mr. Tubane, because the suspension was for about 2 years, why did you wait until September 2025 to file an application for suspension to be uplifted?
I understood the suspension to be automatic, because it was a 2-tier suspension order. It said you are firstly suspended to practice as an attorney for 18 months. You are further suspended to practice on your own as an associate, as a director, for a further period of 2 years. So I had to wait for both the period of 18 months plus 24 months to lapse before I could do anything.
And why didn't you comply with what you call it was just an administrative misconduct?
AJP, I at the time had what I can call a modest practice. And when called upon by the then JP to act from time to time, it was for me an honor and a rare privilege afforded to very few. And in a way, I must say that I kept my eyes off the ball. My practice was in the hands of a practitioner whom I expected to help with such administrative issues. I accept that the responsibility lay with me. I'm the one who ought to have ensured that there is compliance. The period of 2 years gave me an opportunity to introspect and reflect. And I am disappointed in myself that I allowed such administrative problems or issues to fester to a point where the professional body thought it fit to discipline me. But what I must say is the following, is that once I had seen that there was trouble coming, I then ensured that I filed the outstanding audit reports and that I do all the administrative things that ought to be done. And when the order of suspension came, my practice had been closed for 14 months, and all the outstanding audit reports had been filed, and all of them had been unqualified.
Do you admit that practicing as an attorney without a fidelity fund certificate it's a serious misconduct? It's not just administrative.
Definitely, I do agree, AJP, and like I've sought to explain, my characterization of the transgressions or the offending conduct as administrative in nature is something that I lifted from the judgment for my suspension. But I readily concede that it is a serious transgression. I was a senior practitioner at the time with more than 20 years experience. I knew the rules, and I ought to have acted better. And I regret that I acted in the manner that I did.
In addition,
I have learned a lesson, and I look forward and leave the past behind.
Mr. Tuan, in addition to that, you were the president of the Law Society, 2010 to 2011. Furthermore, you were a councillor at the Law Society for about 7 years. And as councillors, you deal regularly with practitioners who practice without Fidelity Fund certificate.
Like I've indicated, AJP, those are serious transgressions, and I'm disappointed in myself that I allowed the situation to fester to that extent.
Thank you, Chief Justice.
Premier?
Thanks so much, Chief Justice. Mr. Tawan, how are you?
I am well, Premier. How are you?
I'm okay. We as a province of Gauteng, we argue very strongly that the bench must have the necessary skills that will assist us to resolve legal matters as speedily as possible so that the economy of the province is not delayed by lack of skills within the bench to deal with some of the matters that are presented in court. I'm trying to get the relevant skills that you feel that you will add in enhancing the skills base of the bench.
Yes.
Take into consideration that we've acted on various occasions in our province. So, can you just take us through the skills that you really believe that you will bring when you can be appointed a successful candidate?
Yes. Thank you, Premier. Premier, I have acted since 2013. During that period, I've been able to produce about 150 judgments. And during that time as well, I have served the bench at the request of the Judge President, who I believe came back to me from time to time because he believed that I've got a skill set that the province needs. And he has requested me on more than, at his request, I have served the province over 204 weeks. I've given them over 204 weeks, which equate to 4 years. And during that time, if I may add, I've been able to sit considerably in the criminal court. I've been able to do most matters that are listed on the spreadsheet from the province. The only kind of work I have not been able to do is tax law. But otherwise, all areas of the law, I have sat in with colleagues, whether it's full bench or full court, and I have, as I said, produced judgment, some of which are reported.
The small claims court plays a critical role in the economy of our province, especially the underprivileged.
Indeed.
And your migration from that level to where you want to go now, don't you think that it disadvantages that particular sector, or what would be the advice with the experience you've acquired that we need to strengthen that small claims court?
There is generally a reluctance, particularly of senior legal practitioners, to participate in that space. More needs to be done to encourage them to avail themselves to act in that space. I have done what I could when I was in my province. We established the small claims court at KwaNdebele, and if I may add also that Marble Hall and Groblersdal, which fall under Limpopo, also did not have the small claims court. And senior legal practitioners in those towns, which are surrounded by people who are in dire need of legal services, did not make themselves available to act in the small claims court. With the result that even though we were from Mpumalanga, we had to travel considerable distances to service those areas even after hours. In fact, because they are after hours. So you would leave your practice around 4, travel for about an hour to Groblersdal, do some 2 to 3 hours, and travel back at night and be ready for your general court work the following morning.
Thanks so much, Chief Justice.
Yes.
Thank you very much, CJ. Good afternoon, Mr. Tuan.
Good afternoon, Commissioner.
I just want to ask you about a judgment that you wrote long time ago, and I don't want to hold you to that judgment because I think personally your views might have developed over time, but I just want to check whether they have. It is a judgment that appears on page, I'll give you the page number now. It is page 18 of your document, and hand paginated 18. I'm not sure if
hand paginated.
Yes, there's the one that has been paginated by a marker.
All right.
Book 2.
There's book 2 of 2.
Yeah, probably it might be that one because I don't see the typed pagination. So, but nonetheless, it's the matter of Shebeen investment versus Esther.
Yes.
That was delivered in 2015, and it's the one that dealt with the PI Act.
Yes.
Yes. And in this matter, obviously there was a commercial lease agreement, and you found that the respondents, the tenants, were just playing games, and they were not as poor as they claimed to be.
Yes.
And they are protest for rent and all those kind of things. But what I'm interested in is some of the comments that you made on the judgment, and I just want to hear what your views are currently. Because among others, you said that it was not compulsory to serve the municipality in terms of Section 4.2 of PI Act, or to join the municipality in the proceedings.
Yes.
I'm not sure. Do you still hold that view?
Well, what I found then was that because these were not indigent persons, these were persons who could afford and who deliberately avoided paying rent and obstructed collection of rent and obstructed the landowner from accessing the property, that they were not deserving of protection.
Yes. No. And please forgive me. I accept the facts for what they are.
Yes.
And I think what I'm asking is a different question.
So, yes.
That when you look at Section 4, subsection 2,
Yes.
of that particular act, makes it or provides a sense as to who should be served with the Section 4.2 notice, who should be notified about the impending eviction.
Yes.
And the municipality plays a particular role in evictions. Yes, you might join them in the proceedings, you serve them with documents, they don't do anything. Sometimes they provide a spreadsheet where they are telling you, no, we are doing the best that we can, but there's nothing in our available means. What I'm trying to get to is it compulsory, in your view, to join the municipality? In other words, is it compulsory to serve the municipality with the eviction proceedings? The municipality which has jurisdiction over the property upon which eviction is actually sought.
Yes. No, Commissioner, my opinion has since developed. I believe that they ought to be served, and it would be entirely up to them to, yes, whether they abide, whether they oppose, whether they, yeah, but
and if the municipality is not served, that's a ground to strike off the matter from the roll so that they can be part of the proceedings. I was just worried about that, but thank you very much. Thanks, CJ.
Commissioner Mangen?
Thank you, Chief Justice. Good afternoon, Mr. Tobani.
Good afternoon, Commissioner.
Yes. I need to converse with you the court order of the Mpumalanga Division of the High Court.
Yes.
I'm interested in order number 3,
Yes.
the one that says that before you can practice on your own account, you need to make an application to court.
Yes.
And I want to assume that you have elected not to practice on your own account, and that is why you did not make an application.
Yes.
Instead, you choose to make an application to assume a position with more power and authority than being a director of a law firm. As I see it, your application is actually intended at bypassing order number 3. Am I correct in my reading of that order?
No, that is not correct. What is correct is the following: that in the pursuit of obtaining a good standing certificate, the Legal Practice Council indicated that there ought to be an upliftment for them to supply me with a certificate. The court ought to grant me permission to practice. And once the court does that, in other words, lift the suspension, they will then supply me with a good standing certificate.
I'm talking to you about a completely different matter.
Oh, I see.
I'm not interested in the letter of good standing.
Yes.
The position you now seek to occupy carries more power and authority than that of a director of a law firm.
I agree.
And the court has said to you, before you assume directorship, you've got to come before it and satisfy that court that you are a fit and proper person and you can be trusted. But instead of doing that, you bring an application to be a judge when you have not gone before the court that said that there is some character defect in you and you cannot be trusted with responsibility of managing a law firm. As I see it, you first have to prove to us and the country that you can be entrusted with a small institution like a law firm before you can actually be entrusted with the responsibility of taking care of adjudication of legal disputes in a society. And I have serious difficulty that you do not appear to be taking these court orders very seriously, because it is said that these orders still stand, and up until they are set aside and or reviewed, they remain binding.
Well, the judgment does not say I've got a character defect. It's a different determination that was made. The judgment specifically says that the respondent, which was me, we are not dealing with a person with a character defect. So characterization of my offending conduct as amounting to a character defect is not how the court found.
Commissioner Pillay?
Thank you, Chief Justice. May I just ask you to please have a look at your application in addition to what Commissioner Mangena has put to you? Just want to raise a related concern. Can I ask you to open up your application form and specifically go to item 3 of your application form?
Sorry, where?
It's on page 13, handwritten 13.
Yes.
You asked there, has any legal professional body ever found you guilty of unprofessional or disgraceful conduct, or are there disciplinary proceedings pending against you? And I just want you to have a look at your answer. You say, on the 17th of May, I was suspended from practice by the High Court and precluded from practicing until September 2021. And the transgressions were administrative in nature. But that's not an accurate portrayal of what the High Court had said in your suspension order.
Well, it's not. It's not. I have not couched it as it was couched in the order itself.
Yes, you gave the impression that your suspension lapsed in September 2021, when in fact it didn't lapse.
Well, that was my understanding of the order at the time. And hence I approached the court for upliftment when the Law Society said you were suspended by a court and only a court can uplift your suspension.
Mr. Tlani, with respect, if you look at the High Court's order, there could never have been any misunderstanding about what the court ordered. It's very clear. The court says, firstly, that you are suspended from practice for a period of 18 months to be calculated from the 13th of March 2020. That's what you reflect in the form.
Yes.
So that would have ended in September 2021.
Yes.
The court goes further. It says that you are precluded from practicing as an attorney for your own account, either as a principal or in partnership or in association or as a director, for a further period of 24 months.
Yes.
From the expiry of the suspension. So from September 2021, there's still a further period of 24 months where you can't practice for your own account.
Yes, my reading of the order was that
Can I just ask you, that's not disclosed in your form?
Well, that is true. It's not couched in that manner.
Didn't you think it was necessary to disclose that portion of the order?
Well, I have subsequently supplied further information.
No, I'm asking Mr. Tabani, at the time that you were completing your form, yes, didn't you think it was necessary to disclose that part of the order?
I should have.
And any explanation for why you didn't?
Well, it was just an omission, and perhaps I ought to have given further detail about the order of suspension.
Because you see, it gets worse, Mr. Tabani. If you look at the third part of the order, yes, the court goes even further. They say that should you, after expiry of both periods, so September 2021 and then 24 months from that period, so after the expiry of both periods, should you elect to practice for your own account, either as a principal or in partnership, you must satisfy the High Court that in which you so intend to practice, that you should be permitted to practice. So in a sense, it's almost a suspension, not time bound, until you come back to court and persuade the court that you should be allowed to practice. That's not reflected in your form.
Well, I accept that it's not reflected. And the first portion of the suspension was that I could not practice for my own account. And the second portion then says, should I wish to so practice as a partner for own account, as a director, then I ought to satisfy the court.
You see, Mr. Tabani, your failure to disclose this has quite serious consequences. And I need to put that to you. It means that at the time that you submitted your form, that you were not entitled to practice as an attorney?
Well, that is not my understanding. I was not entitled to practice as an attorney for own account as a director or in partnership.
All right, let me nuance my question. At the time that you submitted your form, you were not entitled to practice for your own account as an attorney. And that's not disclosed to the commission.
Well, that is not my understanding, Commissioner. My understanding was that the first period of suspension, that of 18 months, precluded me from practicing as an attorney.
Yes.
Then the second leg.
The 24 months.
Yes, the second leg of 24 months precluded me from practicing for own account, partnership, or as a director.
Yes, and the third leg, the indefinite one?
Well, my understanding, if I may just finish this portion, my understanding was that after the 18 months had expired, I could practice as a professional assistant or I could practice in any other manner, but not as an attorney for own account.
Yes, and that applies to the third leg as well, which is the indefinite period, until you come back to court and persuade a court that you should be allowed to practice for your own account.
The third leg, as I understood the order, was that if I want to practice for own account, in partnership, or as a director, then I ought to approach the court for relief.
So you're agreeing with me, Mr. Tabani, that as at the time that you filed your application, that you were not entitled, you could not by law practice for your own account.
I agree.
Now, the consequence of that is, as at the date that you filed your form, made your application, you were not entitled to a certificate of good standing.
Well, my understanding was that the first suspension period having expired, I could be issued with one.
But you now know what should have been very clear to you. You're a senior attorney, you established attorney. You now know because your law society has told you that, the Legal Practice Council has told you that prior to the 4th of September, you were not entitled to a certificate of good standing.
Hence, I approached the court for them to issue me with one, as the entire period had now expired.
And so your upliftment of that portion of the order only comes on the 4th of September?
Yes.
Not at the time that you submitted it. So what I'm putting to you is, at the time that you put in your application was non-compliant. But nobody picked it up because of how you had framed this response in your form, because you were not entitled to a certificate of good standing at the time that you filed your application.
Well, I can see how it can be interpreted in that manner.
Thank you. Thank you, Chief Justice.
What do you mean you can see how it can be interpreted in that manner? Do you accept that this is the only interpretation that can be given to it?
No, Chief Justice, all that I'm saying is that I prepared the form, the questionnaire, and gave the impression that...
I just want to know if you accept what Commissioner Pillay put to you unequivocally.
Which is what, Chief Justice?
What she put to you. What did she put to you?
Well, she says at the time, the application was not compliant.
Yes, and it's your answer that I don't understand, that you can see how it can be interpreted that way. Do you accept unequivocally that when you applied, you were not entitled to a certificate of compliance? And you actually had no right to apply for this position?
I accept, Chief Justice.
Okay. Commissioner Ngaitok?
Thank you, Chief Justice. I think it's just two parts, Mr. Tuban, which really follow up on your discussion now with Commissioner Pillay. Your characterization that the judgment that suspended you stated that the offenses were administrative in nature. You remember that?
Yes,
And you also remember that you said to Commissioner Mangena that judgment said you had no character defect.
correct.
Now, the problem I have with that is that it is a selective and a misleading reading of the judgment. If you go to paragraph 111 of the judgment, what the court actually said,
Sorry, where do I find that?
paragraph 111 of the judgment that suspended you, the LPC versus Tobane.
I am struggling to.
Yes, all right. Well, trust what I'm reading to you.
Yes.
We don't have a lot of time. In paragraph 111, this is what the judgment actually held. And it was on sanction, not on conviction. The respondents' transgressions were serious, particularly when viewed in their totality, and can therefore not be gainsaid. The question is thus whether these transgressions are serious enough to warrant the penalty of striking off. In the present instance, a penalty of striking off might be too severe, considering that the offending conduct was largely administrative in nature and does not disclose, again, a permanent character defect in the respondents. However, the respondents' misconduct was continuous and displayed a complete lack of insight, justifying specific protection of the public calling for additional measures. So, firstly, your characterization that the judgment said these were administrative offenses actually doesn't tally with the language in the judgment. And your characterization that the judgment said you had no character defect also doesn't tally with that, because it simply said your character defect is not permanent. Hence, I'm saying your characterization today, I'm not talking about what you did in the past, today is misleading.
At best, what I can say is that the suspension, since it had periods, 2 legs to it.
No, you've debated that with Commissioner Pillay. I don't want to get back to that topic. What I am talking about is that the way you've characterized administrative as well as character defect is misleading. On character defect, what they said is that your defect is not permanent. They didn't say you had no character defect. On administrative, what they said is that these offenses are largely administrative, but extremely serious. None of those came in your responses. So what I'm putting to you is whether you accept or reject my suggestion that I feel misled.
Well, if that is the, well, I did not have the intention to mislead.
Yes. Thank you, Chief Justice.
Thank you, Chief Justice. Mr. Tobane, I find you've applied previously for this position in 2016, am I correct?
Yes, I have.
Okay. And you also served on the Council of the Law Society of the Northern Provinces for the period 2006 to 2013.
Yes, I have.
That's eight years on the council. You also served as its president in 2010.
Yes.
So how is it that somebody with inside knowledge of how the council works, how the Attorneys Act functioned in those years, came to neglect your practice to the extent that you were suspended for this period of time?
I have said that after a period of reflection, I am disappointed in myself that my circumstances had to arrive at that. I was a senior practitioner at the time. I knew the rules and allowed such a situation to develop.
Was that all from you, Commissioner?
Thank you, Chief Justice.
Commissioner Matolo Hlebo?
Thank you, CJ, and good afternoon, Mr. Tavan.
Good afternoon, Commissioner.
I just have to declare that I served with you at the Law Society then, and no, I know you.
Indeed,
you're
we
very
have.
conscientious attend. But don't you think you need to go back and deal with the court order first before you make another application? Or for me, as Commissioner Pillay said, you dealt with only a part of that application. You need to go back to court, make sure that by the time maybe you want to apply again, at least that court has been addressed.
Go back to court to practice, or what?
Go back to court for them to uplift your suspension properly. Remember when you do an application, you go to court after a suspension, what will you want to do? They'll give you conditions. You can do this with the suspension after you get, maybe you go for a accounting course for 6 weeks or whatever it is. I think do that, you know that.
Yes, Commissioner, but the order simply says if you wish to practice for your own account in directorship or in partnership, you ought to satisfy the court in the area in which you wish to practice. And what I did with, or what I sought to do with the application was to show or to satisfy the court that I ought to be given permission to practice. The language that was used by the court is to that effect. But I accept that if the view is that the court, in fact, that is not a suspension upliftment, the order that I obtained. But the couching of the order, unfortunately, led me to take the action that I did. You are suspended from practice as an attorney, number one. Number two, should you wish to practice for your own account, you must satisfy the court that you should be permitted to do so. So I went to court and I sought to satisfy the court that I be permitted to practice, and the court granted that order.
Thank you, CJ. That was my advice.
Thank you, Commissioner.
After the conversation you've had with the commissioners from that end of the table about the effect of the order of the High Court, all its elements, and what you have considered now, do you still insist with this application?
No, I don't.
Do you think you are ready to
No, I don't.
jump onto the judicial bench?
I don't. I will go and correct the situation.
Okay, thank you. Thank you, Mr. Chaban. You're excused.
Am I excused, Chief Justice? Did you say I'm excused?
Oh, yes. Advocate Van Niekerk,
Good morning.
it's no longer morning.
Good afternoon.
How are you?
Very well, thank you. Thank you for being here.
Good. Thank you for making yourself available for the position. All right, let's get started. You have listed two academic qualifications. One I have not heard of. It's a BLC.
Yes.
What is that?
The university at those days had a 3-year course, BLC, instead of the old BA, which was more law orientated, which then leads to the LLB.
Oh, I see.
So, but it lasted not very many years.
So is this BLC and an LLB both from Tekis, University of Pretoria?
It is essentially a BA LLB.
All right. And you were once a legal officer with the South African Medical Service. You would have been quite young at the time.
Yes.
Having done your articles at Shapiro and Pokroy.
That's correct.
Then you decided to join the bar.
That's correct.
And you've practiced since 1987?
That is correct.
In Pretoria?
That is correct.
Okay. You took silk in April 2008?
Indeed.
Okay. And you state that your practice is primarily focused on civil litigation.
Yes.
And that you have a special interest in aviation law?
It's one of the matters that I'm interested in. I've actually have quite a wide commercial practice, in the sense that a lot of the matrimonial work that I do is actually commercial. And I do pure contractual matters. I've done civil aviation matters, aircraft accidents. I've done a very wide diversity of matters.
Mm-hmm. But then you have this special interest in aviation law.
Well, my interest, I am regarded as a specialist in the role of trusts in divorce matters. And protecting trust or attacking trust, if I can put it like that, for purposes of patrimonial claims. And then I would say I'm the most interested in aviation law, because the rest becomes a bit mundane after many years.
And I see that in your private life, this keen interest extends. You are a member of a number of recreational flying organizations.
Indeed, Chief Justice, I find solace in the air.
I'm not sure. We wonder what judges doing power flying and hand gliding. I'm not into adventure sports. That kind of activity gives me sleepless nights. But that's what you do. And you cycle and you run as well.
I cycle. I don't run.
Or road cycling.
Yes,
so
road cycling,
and
track cycling, and mountain bike cycling.
Okay. You have authored quite a few publications. Can you tell us a little bit about those?
Madam Chief Justice, I've authored the publication, A Practical Guide to Matrimonial Litigation and Divorce Actions, which is exactly what it says. It's a practical guide containing an exposition of the law, the relevant authorities, and then how to approach that for purposes of litigation, preparation for trial, precedence of pleadings, the applicable legislation, etc. That publication was referred to in a lot of other publications. I see that there was one of the
Is
reviews.
it the one that has been cited with approval in court judgments?
Indeed.
Like 3, no less.
Indeed.
All right. And what are the others?
That publication was cited in those other papers, law commission reports, articles from authors, academics, etc. I see that one of the reviews say that those are papers that are delivered, but that's incorrect. It's been cited in those papers.
All right. and cited by one of the commissioners sitting in this very room, Professor Marumakhai. You have acted as a judge.
Indeed.
Where and when?
I started in 2012, and the last stint was now a month or two ago, in May, over those years.
And in which division of the High Court?
I've acted in the Gauteng division in Pretoria, as well as the local division in Johannesburg. I was there last year for a full term, the first term of 2024 in Johannesburg.
Okay. So how long in all have you acted as a judge?
48 weeks.
48 weeks. And in which courts have you sat?
I've sat in unopposed motion court. I've sat in a motion court, civil trials, special civil trials, special motions, civil appeals, criminal appeals, family court.
Tax court?
Yeah, I think, yes, I've sat in a tax appeal where I wrote the majority judgment, which is referred to in the papers, which was overturned by the Supreme Court of Appeal.
Any criminal trials?
Pardon?
Any criminal trials?
I've done no criminal trials. I've only done criminal appeals.
And not in your practice either?
No, in practice, one tends to either be a civil advocate or a criminal advocate.
Have you written judgments?
I've written a number of judgments. The ones that I could find in my research amount to, I think, 42. There are judgments that I've delivered ex tempore, which I can't find, but those that I could gather from my collection of written judgments and from SAFLI, I did compile them in a list, and it's about 42 of them.
All right. Any of them reported?
Yes, there's one that was reported, a matter of fools, which has been followed in the Western Cape as well as in other courts in Gauteng. But I don't think that's such an important judgment. It just dealt with the issue of whether or not a person who did not apply to, in terms of the National Credit Act for debt review, can apply for surrender of voluntary surrender without following those procedures or without explaining why those procedures would not have been more appropriate. And so that was followed in other courts. And I've then also delivered judgments which were not reported but then followed in other divisions and approved in other divisions, as well as by a full court in Pretoria and Gauteng.
You mentioned that some years ago you were fined and reprimanded by the Pretoria Society of Advocates for a transgression you described as minor, double briefing.
Yes, that is so.
But you've kept on the straight and narrow since that incident.
Yes, Madam Chief Justice. That was about 35 years ago.
Yeah, 1990.
Yes, since then, I have not been found guilty or even charged with any transgression. And in fact, I've served on various disciplinary committees as either chairman or board member, and some of them important ones for the Pretoria Bar, which I submit is a reflection of what the bar's view is on my sense of ethics and as counsel. So I'm not proud of that. It's not one of my proudest moments, those events, but as a junior counsel, it happened, and I can't do anything about it.
Okay. And the commentary from the law bodies is that you deliver your judgments promptly. Is that so?
Madam Chief Justice, if one has regard to my list of judgments which I compiled, most of my judgments are delivered within 1 or 2 weeks. Some of those judgments are even delivered within days. And The judgments that takes 2 or 3 months are judgments that I was involved in with other judges that in either full court or full bench appeals where one has to wait for the other judges. The ones that I deliver by myself, I take great pride in saying that they are never ever delivered more than 3 or 4 weeks later. And in most instances, within approximately 7 to 10 days.
You are 65.
I'm 65.
And so you still have quite a number of years to serve if you are appointed.
Yes, as I
Still
say,
until 75.
Due valenti, I've always said, if I'm not appointed as a judge, I will work until I drop. But I'm not one of those people that want to stop working.
Are you in good health? Well, for someone who does all the things you do, you must be in excellent health.
I'm in very good health. I train every day. I walk or I cycle.
Okay. Yes. Thank you, Advocate van Niekerk. AJP?
Thank you, Chief Justice. Are you involved in training of pupils?
AJP, I've been involved with training of pupils since, I think, 2003 at the Victoria Bar. I underwent the courses for a trainer presented by the General Bar Council, where I qualified as a trainer and later qualified as a trainer of trainers. And I was involved with the training committee of the Victoria Bar when in 2013 I took over the reins as the convener, and I held that position until 2017 when I gave that over to someone new. And since then, I've still been involved with training in the sense that I assist with workshops, I present lectures, and it's something that I'm very passionate about.
You're also involved in the training of final year law students. At one stage, you invited me, you and your colleagues at the University of Pretoria. I think even last year or 2 years ago, there was another training at your center. Are you still proceeding with those training of final year students?
AJP, that is also one of the good moments of my life. Myself and one of my colleagues, Mr. Mullins, and one of our junior colleagues, Mr. Nadia, went to the University of Pretoria, and we presented to them the opportunity to, in collaboration with the Victoria Bar, present a certificate course in advocacy for final year LLB students. And that started, I can't even remember, started around about the middle of 2008, 2009, if I remember correctly. And that developed into a yearly, an annual course, and was later extended by invitation to other universities. And it's a 3-day course where we teach the students the basics of cross-examination, examination, preparation for trial, and then they participate in a mock trial. And we invited judges of our division to come and assist, to sit as judges, with a specific intention to expose the students to those judges and to serve as inspiration to them. And the purpose of that was to give the students a kind of taste of what it is to be an advocate, to make them understand that if they elect whatever choice they make in their lives, there is the one of advocacy available, and that is more or less what it entails. And it was very successful. The feedback we got was extremely good. To this day, people approach me, and tell me, oh, I've been in your course in so-and-so year, and it was so fantastic, and thank you very much. And I'm still involved with that. We've given the reins over to people who continue with the momentum of that, but I'm still involved there in the sense that I go there as a trainer or sit as a judge in the moot court, and help with the presentation of some of the lectures and things that we do in that course. So we're still involved with that.
I still remember about 10 years ago when you invited me to the University of Pretoria, I suggested that I think other universities should be involved. Which other universities are now part of this training?
AJP, we've invited University of Venda. They sent students. We've invited the University of Northwest. They sent students. I can't even remember all the universities that we've invited, but I know that we've had students from those universities also attending. And in terms of attending the course, it was difficult for some of the students, especially those that have to travel. So we created a kind of a bursary fund where, for instance, my colleague Mullins and I, we contributed from our pocket to assist some of those students to come and attend the course. And I think it played a great role in their lives.
Premier?
Thanks, Chief Justice. I'm fine. Thanks.
JP Tlaletsi?
Good afternoon, Advocate Van Niekerk.
Good afternoon.
Yeah, just one small issue. Going through your CV and the form, I do not see anything to do with what used to be compulsory military conscription. If you did, is it something that you think is private? If it does not appear anyway.
I've disclosed in the form that I did 2 years in the South African Medical Services as my compulsory medical service.
That was part of it.
It is stated there, yes.
I see. Thank you.
Commissioner Moimang?
Thank you, CJ. Good afternoon, Advocate.
Good afternoon.
Just one from myself. The minimum sentence creates a bit of confusion on my part. And of course, appreciating the fact that the CJs usually says the lawmakers makes law and then thereafter complains. So the question that I want to ask is whether the minimum sentencing in terms of the Criminal Procedure Act, doesn't it interfere with the discretion that the court has to impose sentence? And under what circumstances will the court deviate from a minimum sentencing as prescribed? Thank you.
My view is this, that the courts must apply the law. The courts doesn't make the law. The law is made by the legislature, and the courts must apply the law as it stands. And when the law provides for circumstances where there can be a deviation from a prescribed minimum sentence in terms of certain criteria, then obviously a court must consider that. But I think in terms of the separation of powers, if that is the law, it's not for the court to say then and there that the law is wrong. The court must apply the law.
Thank you, Advocate. Thanks, CJ.
Commissioner Marumachai?
Thank you very much, CJ. Good afternoon, Advocate Van Niekerk.
Good afternoon.
I want to talk to you about two things. And you are quite right. The guide that you write is quite useful for practitioners. And I see that it was last updated in February 2025, which means that it's quite fresh. It has probably the most recent information in it. I had a chance to go through some of the aspects of that guide, and in particular, I'm interested in chapter 7 of it that deals with pension interests.
Yes.
I realized that, and correct me if I'm wrong, and I'm actually looking at it now, that you still define pension interest exclusively in terms of Section 1 of the Divorce Act. And I just want to get a sense from you that, are you aware of the amendments that were brought by the Pension Law Amendment Act 31 of 2004, and what those amendments did to the concept of pension interest in South Africa?
Professor, I do not think with respect that it's correct that I say it's strictly defined by Section 1. The definition of a pension interest is defined by Section 1 of the Divorce Act, read with the provisions of the Pension Funds Act, read with certain sections of the Income Tax Act. I don't have my publication before me, but there's one section in my publication where I specifically actually refer to the steps that one goes to find whether or not a policy is a pension interest. And in fact, there was a decision from the Supreme Court of Appeal which eventually held that those living annuities, which were previously excluded by courts as a pension interest, are in fact a pension interest, which is something which I advocated if one goes through that, let's call it checklist, in terms of the definitions. So that is my view.
No, you are quite correct, you do that. But my question was this: are you aware of the amendments that were made by the Pension Law Amendment Act 31 of 2024 in relation to how we should view pension interest in South Africa? Because what that particular provision legislation does, it creates a separate and parallel definition of a pension interest. And this is something that the courts will have to grapple with now. And what it does also, it provides a measure of supremacy on the different definition of pension interest that is introduced by that particular provision. So what I'm asking you, because this is a guide that will guide practitioners, I'm saying to you, are you aware of these provisions, and are you taking them in account when you are updating the work that you are providing to practitioners?
Well, when I update my work, I look at the authorities, because it's basically there for purposes of updating the practical approach and especially authorities. But that is not specifically in the guide. Yes.
I would advise you to look into it. I think it will be.
Yes, thank you very much. I will.
Thank you very much, CJ.
Commissioner Hassan?
Thank you very much, Chief Justice. Advocate Commissioner Hassan over here. I want to ask you about transformation in this space. I think we agree, Advocate, that transformation is not only a numbers exercise. It's much about the legitimacy of the law in a society marked by deep historical exclusions, and courts tend to shape who gets to speak, who to be heard, and to build expertise, even the bar, to a great extent. You come from the senior ranks of the bar, where briefing patterns and even pipeline diversity are quite huge issues even to this day. What have you done to make a difference? And I recognize what has been said earlier about the training program for final year law students. I'm asking beyond that, what have you done to change briefing patterns in the sector?
Madam Commissioner, the practice that I have, the kind of practice that I had, I acted for private persons and small entities, not big corporations who can really afford to spend hundreds of thousands of rands on litigation. So the opportunity that I had to appoint a junior was very limited, but there were opportunities where I was able to do that, and which I in fact did. I think my contribution to the imperatives that you refer to now lies in the fact that I assisted a lot of counsel, and most of them black, to develop as an advocate through advocacy, to choose a career as an advocate, and to train them. I can go into the details. It's a bit of a story, but I can go into the detail of exactly what our pupillage program involved. And it was extremely lots of work and hard work. And I spent a lot of time in that, pro bono, not being paid, to do that. And I encouraged a lot of people to get involved in that from previously disadvantaged backgrounds in order to assist with that. And that is what I could do in terms of my abilities to further the career and progress of previously disadvantaged persons.
Advocate, I want to bring your attention to the AFT's comments on your candidacy under paragraph 2.3. They go into some level of detail in sub-paragraphs around resistance to transformation during leadership roles, or should I allow you, let me allow you to get there?
Yes.
So for me, it's page 4 of AFT's comments, but I think it's easier to say paragraph 2.3.
Just a moment, please.
No problem.
Paragraph 2.3 of the AFT comments.
Yes. Have you found it?
Yes.
Right, so if we look at 2.3.1, they talk about resistance to transformation during leadership roles. They say that you have been widely regarded as resistant, if not openly hostile, to initiatives aimed at widening access to historically disadvantaged aspirant advocates. 2.3.2 talks about a failure to mentor or elevate Black juniors. It talks about no record of the candidate consistently leading or contributing positively to the careers of Black juniors. And they keep saying, this is a point that keeps being made, the candidate's alleged conduct is contrary to the explicit responsibility of transformation. So they keep saying in further paragraphs even that you've said this, but in reality, something else is being said, particularly by Black juniors who have chosen to remain anonymous, which is their right. And the last point I'll just mention here, a stark contrast exists, that's 2.3.3, between the conduct and your contemporaries who have actively advanced transformation through mentoring programs. How do you respond to AFT's comments?
My response is the following. That allegation made against me by an anonymous person is not correct. And since I've received that comment from AFT, I've given it a lot of consideration because I wonder where that comes from. And I've come to the conclusion, and first of all, I respect AFT. I respect what they stand for. They've achieved a lot. And AFT consists of advocates. And I do not think an advocate will make an allegation like this solely out of malice or falsely in order to incriminate me. That person who made that allegation probably believes what that person wrote there. But I think it's a matter of mistaken identity. And I can explain to you why I say that. And for that purpose, I have to give you a background as to the events during my tenure as chairman of the Pretoria Bar Training Committee. When around about 2012, when we started, the selection of pupils were made by certain members of the bar who interviewed a pupil and then said the pupil is selected or not. There was no proper structure for selection of pupils. We as the training committee trained those pupils, but the people who elected them were, I don't know how they got to elect the pupils, but that's how it happened. When I took over the reins in 2012, at that time, we were receiving about 150 applications for pupillage per annum. And we knew that it was urgent that we had to increase the number of pupils that we selected. Now, at that time, the number of pupils selected amounted to 20 to 30. And from that 20 to 30, the Black pupils that we received, or previously disadvantaged pupils, numbered about 4, 5, sometimes 6, sometimes 7. And in 2012, when we identified that we had to increase the number of pupils, we did an investigation. We consulted the the administrative people at the bar looked at our facilities and decided that we can accommodate 60 pupils. We discussed this with the Bar Council, and the Bar Council then determined that 2/3 of those pupils must be black. Now, and this is an unfortunate part of the history of our bar, but there was a lot of resistance to that, because there were advocates who said that that is becoming a, let's call it numbers game, and that they are imposing a quota. And they resigned from the training committee. And I said to the remaining members of the training committee, we will make that work. And we will comply with that. And we will increase what we have been doing in the past. And that is at the time when I took over the chairmanship. So what we then did is I convened numerous meetings of the training committee. I spoke to other members at the bar, tried to encourage members of the bar to join the training committee, new members, and especially the young black members. Because at one stage, I even sent out a memorandum to all the members at the bar and said to them, we have a serious difficulty in terms of people willing and able and making themselves available to assist with training, and we specifically need young black people to do that, which rendered results. So then we started this training program, and I said to them, although we've lost some of our core trainers, experienced trainers, we have a mandate. We cannot accept these young pupils into pupillage and set them up for failure. We have a mandate to get these pupils to pass. We set up a very intensive training program at the bar. It consisted of lectures to the pupils. It consisted of a mock examination where they received feedback on the examination. It consisted of practical workshops. I don't want to bore you with the details, but to set up one practical workshop is a tremendous big job for 60 pupils, because you have to involve, you've got to break them up into between 6 and 10 groups. You have to find between 6 and 10 to 10 real judges. I had to go and arrange the judges. I spoke to the AJP on numerous occasions. He assisted me in finding judges. We set up these exercises in the Supreme Court building. We had to get trainers who assist during this training process, because there's a very specific formula in terms of how we train the pupils to make it as valuable as possible for them. So it involved a lot of work. We had to generate paperwork and programs.
So Advocate, just to be clear, in your career, your sum total contribution to transformation was the training program?
No. If you can give me an opportunity, I can just...
Tell me beyond the training program, and also how many black juniors you yourself have mentored over your career.
First of all, in the training program, we actually assisted the black juniors to eventually become trainers and start taking over some of the training functions. And that was an initiative that I started. So the point is, I would not have done that if I was hostile to transformation. No person who is hostile to transformation would go to those lengths and spend those hours and do that kind of effort in training pupils. What I did myself is, when the opportunity arose, and I agree, it did not arise that often, but when opportunity did arise, I did have counsel or junior counsel from disadvantage. I recently, and in fact, it was pro bono recently, I acted for the Cycling South Africa in a review application where one of the coaches was accused of sexual harassment and was disciplined and sanctioned, and was, well, I don't want to go into the details of that, but the fact is, I acted pro bono for Cycling South Africa, who is a non-profit organization tasked primarily with promoting cycling in South Africa to the greater population, which they do. It's a transformation initiative. I acted pro bono for them, and in doing that, I had a previously disadvantaged junior from our bar Mr. Adrian Thompson, who's a colored person, who I hold in great respect. I asked him to assist him. I explained to him it's pro bono, but I paid his cost to travel down to Cape Town to assist me with this matter. And talk about pro bono initiatives. I've done a case utilizing my knowledge and skills in aviation law. If I can use the advocate tea room language, tied a big corporation in knots after a young guy, Mr. Malotu, suffered a double amputation of his legs following an aircraft accident. And I got them, they tried to escape liability on the basis that they sold the aeroplane to an offshore company. With my knowledge of aviation law, we got them to agree to a stated case. We went to court and we got an order, all for free. I didn't charge a cent. I did what I could in terms of my abilities and the nature of the practice that I had.
All right, and just the amount of black juniors you yourself have mentored over your career?
Well, I can, if I must think off my head, I think, are you talking of black or previously disadvantaged, including
black?
Black, 2. Now,
Sorry, just to be clear, 2 out of how many?
out of how many what?
How many juniors have you had?
I've not had many juniors. I think in my practice, and you can you can check the matters that are reported in which I appeared. I appeared by myself because that's the nature of my practice.
All right, thank you, CJ.
President Molemer.
Thank you very much, Chief Justice. Good afternoon, Advocate Paniker.
Good afternoon, President.
How are you?
Very well, thank you.
My question, I have 2 questions, they are related. The first question is whether skewed briefing patterns are a reality, or is it something that is not a problem in our country?
I've no doubt that there are skewed briefing patterns, but Madam President, it's a very complicated issue because I don't know what the answer is because it's very complicated and it can be seen through many lenses. There are certain aspects of law. If one really makes an analysis, I think, there are certain areas in law where the briefing patterns are not skewed. And there are other facets of the law where it in fact is. I sat, for instance, in the court in Johannesburg last year for a whole term. And I must mention, it's a very enlightening experience to see the difference between 2 divisions so close to each other. But in Johannesburg, in the whole time that I sat there, I was in civil court and the Road Accident Fund Default Judgment Court. And I think in the whole time that I sat there, in all the matters that were before me, I could count on my one hand the times when there was a white counsel before me. The rest were all black counsel. If you go to Pretoria, it's less so. In Pretoria, I think it's more of a probably 50-50. It's difficult to say because, I mean, obviously we don't keep statistics. But the fact of the matter is, I think at the end of the day, there's also the issue of, depends on who the client is. They, to a very large extent, dictate who their lawyers are going to be, and the lawyers dictate who the counsel are going to be. But I don't have the answer. I can just agree that it is probably skewed.
Yes, and you did say that there are some areas of the law, branches of the law, where there's definitely a skew.
Definitely.
In favor of white counsel.
Yes.
Yes. Now, we have this constitutional imperative
in section 174 of the Constitution, which relates to how judges should be appointed, it must be fit and proper, and also talks about demographics. So it seems to me that a diverse bench is actually essential. Would you agree?
Indeed,
Yes, and why do you think it's important?
because we have a diverse population, and diversity on the bench reflects diversity in the population, and it reflects the fact that one part of the population is not elevated in terms of stature or importance to another part of the population. So therefore, there must be a reflection on the bench of all parts of the population.
Now, the question that I often ask myself is, how is that going to be achieved for as long as we have skewed briefing patterns? Because I'm sure when we are talking about a diverse bench, we're also talking about people from different backgrounds and diverse skills and so forth. So if we have these skewed briefing patterns, how are we going to achieve the diversity that is envisaged in the Constitution?
Madam President, I think briefing patterns is something that is it is changing, and I think everybody who sits on the bench will agree with me, because that personally is my experience. It is changing from what it was, say, 10, 15 years ago to what it is now. And that change is brought about by the fact that the number of previously disadvantaged advocates and attorneys are increasing proportionally more and more with progression of time. If I just speak about my and their ability and what they can achieve, and the perception about them is changing. And if I can just, as a matter of example, say why I say that. It was striking to me when I started my journey in advocacy training. If you have a lecture in the mornings for the pupils, the black pupils would sit right at the back, and they would keep quiet, and the white people sits in front. And the numbers started changing, and very contributing during a lecture, asking questions, raising issues, engaging with you, and the white pupils are starting to sit at the back. And not as to who sits where is important. I think what is important is to show that the confidence level of the black pupils increased with progression of time, and being accepted into the fold of the bar, and being trained and being accepted. Now, that thing, I think that aspect filters through in practice, because you see many, many more large black attorneys firms, competent attorneys firms, and you see many, many more black counsel and extremely competent black counsel appearing. And the message filters through, and that will change. That fact, competence will change briefing patterns. It must. There's just nothing else. There's no other result for a change in competence is a change in briefing patterns.
Thank you, CJ. I've exceeded my quota of questions, so I will leave it at that. Thank you, Advocate van Niekerk.
Minister? Thank you, CJ. I think I'll follow on President's questions around transformation. Good afternoon, Advocate van Niekerk.
Good afternoon.
Since last week, we've been listening quite significantly, especially women legal practitioners, talking about lack of access and briefing patterns that remains a bit skewed. I've looked at your work, and I was also I was battling as well with the comments by EFT, but I think we'll come to that. Just from your experience, having been in the sector for some time, what do you think we should be able to do to encourage more or to change the current issues that are being raised with us, especially by female practitioners in terms of access to opportunities as part of transformation?
Madam Minister, speaking for myself, the bar that I live in Pretoria, there are many female colleagues. I remember when I joined the bar, I think there were 2 or 3. And now, the floor that I am on are mostly females. When we have tea in the morning, at least half of them are females. And they are busy. I mean, they are busy. So when I sit on the bench as an acting judge, there are many of them before me. So I'm not saying that there is not a skewed briefing pattern or that they do not have reason to complain. What I'm saying is, I think there's a gradual change of mindset, and that it is, the legal profession have always been a very conservative profession. And it takes time for new ideas or new models to establish. And I think that is something that is increasing. The pattern of briefing of ladies at the bar is improving, and it will continue to improve. Because once again, these ladies are proving themselves to be very formidable and competent counsel. And that will obviously improve briefing patterns for them as well.
Yeah, just to going on with that one, seeing them there, majority of them are saying they are given your non-significant briefs. So when you come to commercial, you don't find them. Critical cases that are lucrative, where there's money, if we're to say that word. Majority of them are finding themselves having to deal with divorce cases of individuals, not commercial, being briefed by large firms, sometimes even blaming us as government to brief them not much on critical and complex matters as part of them gaining experience. But also, maybe your opinion there, but even your issue where you say you find them, do you think that transformation would happen, or do we have to put mechanisms to ensure that it happens, so that we just don't find them but not understand that what they are doing from where they are sitting is insignificant, perhaps even because I see you are training even some of the young people, which is quite commendable. But those that are there, because the issue is that some of them enter and they become junior advocates, but they exit because they are battling to sustain their practice. Your experience and your views in that?
My view on that is that if you're a good counsel at the bar, you will make it. And if you're not good counsel at the bar, you won't make it. Now, I'm not by that saying that those candidates were not good counsel. I'm not saying that there's skewed briefing patterns. But what I've noticed in the training, for instance, when I was involved in the training committee, I created subcommittees in my committee. And those subcommittees were responsible for, the one would be responsible for the appeals workshop, the other one would be for the motion court workshop. And I always made a point to, in those committees, appoint somebody who with that person will shadow that person to be able to take over that job at some stage in future. And most of those people were females. There were very few males, in fact. And they were the ones that exhibited the most keenness to assist and help. And when we were presenting lectures in class, those people sitting in front, asking the questions and participating, were the ladies, the females. And I've remarked to my colleagues many times the words that I used, and I hope I'm not offending someone. I said, but the boys are being outshone by the girls. They are outshining them completely. And that can be seen at the bar, as far as I'm concerned, because the females at the bar are really starting to climb the ladder. And there are a number of females at our bar who are doing complicated, high-level kind of litigation in terms of intellectual property work, income tax work, and coincidentally, many of those were some of those ladies who came into the training committee and assumed responsible positions and did a marvelous job about that. So I'm saying is, given time, given the opportunity and the space, they will prove themselves. And they are busy doing that.
Thank you, Chief Justice. Good afternoon, Mr. Fanika.
Good afternoon.
Did I understand you in answer to a question from the Minister to say good counsel will make it?
Good counsel will always make it.
Do you accept that the attrition rates at the bar amongst women and black advocates is disproportionately high?
I do not have facts to say, but I accept that. I accept that as a matter of fact. I will accept that.
And the high attrition rates amongst women and black counsel is a direct result of the skewed briefing patterns, which the President was addressing with you.
Well, I would accept that.
And so it's not really a question of whether good counsel make it. It's a question of whether there's a fair and equal distribution of work to enable everyone to make it.
Yes.
Now, in relation to a question from the President, you said that you accepted that there are skewed briefing patterns, but you went one step further and you said that skewed briefing patterns are based on competence. You said that as black practitioners become more competent, that will address skewed briefing patterns.
Yes, I don't think it's correct to say that with respect, I don't think it's correct to say that I said that skewed briefing patterns is as a result of competence. I said that what I convey is that as those counsel become more confident and more competent through years of being the skewed briefing patterns will start to correct itself. Perceptions out there, perceptions, unfortunately, in our country plays a big role. And speaking of this, and it's a sensitive subject, but speaking about this, my colleague John Mullins said to me one day, and he told me about when we were busy with the training, and speaking about the issue of the confidence of the black advocates who come into training. Every intake, it's better, and it improves, and they shine more. And he said to me that they did a study in the United States at a university, and there were some people that they told all the time, oh, you're not so good because of your race. And when they were given certain tests, the results were completely reflective of the impression created to those people. So if you tell people for many years that they are subordinate, they will feel that. But if you change that perception, they will change. And that, unfortunately, is part of the history of this country. But that history has been eradicated by the constitutional imperatives. And I think time, I know it's 30 years later, but today we've got a complete different picture at the bar and in the courts and in terms of counsel who appear there and the kind of work that they do that we did 20 years ago. I've had before me sitting as an acting judge, one of my judgments here, where there were two senior counsel appearing. They were both black senior counsel. Probably the best advocacy that I've seen in action. And you would not have found that 20 years, 25 years ago very easily. They were very scarce.
So we go back to the answer you gave the President at the end of her questioning, that as black practitioners become more competent, it will address skewed briefing patterns?
I didn't convey by that they are incompetent. I'm saying you're getting more and more black practitioners who are very competent. And the more and more of them you get, because they are going through the system and they're coming into the system, and the more and more of them you get, the more the briefing patterns will change, because they will be briefed. Good counsel will be briefed.
And at the moment, because they're not being briefed, we can assume that black people are just not, they don't make the cut.
No, that's not what I'm saying. There are many.
So please tell us what you are saying, Panika, because this is exceptionally important. And you've got the public listening to you. And you will know yesterday from the interviews that we have that this has become quite a bugbear. So please, let's be clear about what you are saying.
Yes. I'm not saying that the black counsel are incompetent. I'm saying that the number of everybody at the bar, there are many counsel at the bar, black, white, all races, who sit there and do the normal day-to-day work. And of all of them, there are a few who starts to doing the very big work because they distinguish themselves. And I'm saying that those kind of counsel, those who distinguish themselves, if you look at the composition of the bar in years ago, were mostly white. But as time progressed, these counsel, the black counsel that come into the bar and improve and become very competent, those numbers change. And that will change the briefing pattern in respect of those numbers. That is what I said, or trying to say.
Do you believe that the conditions are the same for both sets to equally distinguish themselves?
For both?
That's what we're trying to get at.
For both, I could not...
For black counsel and for white counsel to distinguish themselves?
No, I don't think so, because a lot of the big commercial work being done emanates from big corporations. And we all know that most of the big corporations are still run by predominantly white people. And they brief firms that are predominantly big white firms. And that is going to create a pattern of briefing, I've got no doubt.
So when I put to you that the attrition rates amongst black and women are disproportionately high because of the lack of access to work, do you understand why your assertion that good counsel will make it is a particularly painful one?
Ma'am, it may be painful, but that does not imply that those people who don't make it are not competent. What I'm saying is, you see that at the bar, you see that all the time. You see somebody that come into the bar and they are there for a while and they work and they go away. But there are counsel at the bar, and I'm not one of them. I would call myself a mediocre senior counsel. But there are those people that come to the bar and very quickly climb the ladder, and they are specialists in some complicated field like intellectual property or income tax law, and they climb the ladder quickly. And it's not just white counsel, it's black counsel as well.
And then just lastly, you indicated that you had only ever led 2 black juniors in your entire career.
Yes, if I recall correctly. Yes.
Over how many years?
I've been at the bar now 38 years.
38 years?
Yes. And I think in my 38 years at the bar, I've had a junior counsel probably, I don't even think 5 times. That's the nature of my practice.
You've only ever led 5 juniors?
Yes.
In total?
Yes.
In 35 years?
Yes.
And why is that, Mr. Panika?
Because most of the work that I did in terms of going to court, opposed motions, civil trials, relates to matrimonial work, where you have the man off the street who's your client.
But I understood you did put a different slant on your practice at the outset. It It's not your run-of-the-mill matrimonial work. This is the kind of
No, it's a
commercial
general
matrimonial
commercial,
work.
yes.
Yes, that's how you introduced it at the outset
Yes.
of your interview.
Yes.
And you're saying even with these larger matrimonial matters, the one that are more commercially oriented, that even in that space, there's no room to bring on a junior.
There is room to bring on a junior, and in some of those matters I have, but not that often.
Thank you, Chief Justice.
Commissioner Mangen?
Thank you, Chief Justice. Good afternoon, Advocate Vanika.
Good afternoon.
Yeah, I just want to explore with you this aspect a little bit more, and ask you. You strike me as someone who is committed to transformation, except that the people who give you briefs are not willing to allow you to bring in juniors and or black practitioners. Now, my question to you is, what price are you prepared to pay to ensure that transformation takes place in the legal profession?
So, I do not understand with respect, if you're saying what price I must pay, I mean, what am I prepared to do?
From the interaction you had with Commissioner Pillay, it appears you accept that there are skewed briefing patterns in the country, number one.
Yes.
Number two, you have just said, verbalized here, that financial power is in the hands of corporates, and they brief white law firms, who in turn brief white advocates. And my question to you, when I ask you what price are you prepared to pay, I need you to tell me, as an act of commitment to the transformation of the legal profession and transfer of skills, are you able to sacrifice briefs in pursuit of that commitment?
Well, if you say I sacrifice briefs, then I must say to the client, I don't want to do this. You must give it to someone else. And
no, that's one thing that you can do. But the second one is, you can say to the client, I need a junior on this matter, and I need Advocate Moloisane as a junior on this matter, because you explain.
Yes. Yes, I can do that.
Now, in 38 years of practice, how is it that you have only had less than 5 juniors in your practice?
Because in those matters, it was not necessary to get a junior. I could do it myself. A junior increases the legal fee substantially, especially for the man in the street. And a junior is there to assist you to prepare the work. I mean, a junior is not there to, with proverbially, carry the case. The junior brings in value to the case. Then it increases the legal fees. I'm a specialist in the things that I do, and I did not require the services of a junior. And where I did require the services of the junior, I did what I've already referred to, inter alia, paying one of them to accompany me in order to assist in a pro bono matter.
Thank you, Chief Justice. I'll let it rest here.
Commissioner Trolley?
Thank you, Chief Justice. First a comment and then a follow-up question. Advocate Van Niekerk, I note from the nominations from T. Ngongwana, SC from Papasa, and J. Mullins, SC, that they commend you for your commitment to transformation and upliftment and training. And I contrasted that with one of the anonymous comments or allegations of lack of commitment to transformation. That's my comment. In the time that you've been on the bench, have you dealt with any state cases?
If you say, Mr. Trollip, state cases, is it where government is involved?
Yeah.
Yes, I have.
Have you noticed any marked transformation in briefing patterns where the state is involved?
Yes, yes, there are mostly black counsel in those matters.
Thank you. With regard to your specialization or interest in aviation, there's currently a standoff between aircraft owners and the South African Civil Aviation Authority around the 12-year engine overhaul recommendations.
Yes.
Where the South African Civil Aviation Authority is saying that if your aircraft says after 12 years you must have an overhaul, you must have an overhaul.
Yes.
Whereas in the United States of America and in Europe, they say those are recommendations, and as long as the aircraft engine is maintained, regularly inspected, rigorously inspected, that you don't have to overhaul.
Yes.
What is your position there on?
I think that directive by the Civil Aviation Authority was very, it didn't comply with the provisions of PAJA because they did not consult the industry and they did not apply knowledge, specialized knowledge to arrive at that decision because there is no proven history of the mere fact that an airplane engine is older than 12 years old failing. And therefore, it was an arbitrary decision. But I know that it is subject to legal proceedings, and I know that there is a judgment given on that, which I've been told is going to be taken on appeal. I'm not quite sure about that.
My last follow-up question, Chief Justice, is what are the consequences of potentially grounding at least 1,400 light aircraft, not only to the aviation industry, but to the economy of this country?
Devastating.
Thank you.
Thank you very much for coming, Advocate Van Niekerk.
Thank you, Chief Justice. Thank you very much for the opportunity.
You're excused.
Thank you.
Lunch? I, for one, am hungry and Please switch your mic on. Thank you. How are you?
I'm very well, thanks. And how are you?
I'm fine, thank you. You are an attorney.
Correct?
With a BProc, LLB, and degrees and an advanced diploma in project management.
Correct.
Okay. You obtained your legal qualifications from the University of Limpopo.
Correct.
Okay. You were admitted as an attorney in 2001 and started practicing right after. And at some stage, you established your own law firm. That was in 2006. Have worked at other law firms.
Yes.
But then you say it remained inactive because you got engaged elsewhere at the Council for the Built Environment, which took all your time.
That's correct.
And you worked with them first as a consultant and thereafter as a manager, a regulations manager. Providing legal leadership, you say.
Yes, Chief Justice.
Setting up their legal department, drafting and positioning operational procedures, and you say you even developed an appeals manual for them.
Correct.
How long were you there?
If perhaps I may be allowed to refer to my...
Certainly.
I was there, I'm trying to, because I don't...
Well, you say you resigned in June 2007 to pursue your practice full time.
Indeed, Chief Justice.
Mm-hmm. And what kind of work did you do once you started your practice in earnest?
I have been doing since then until now what would be known colloquially as your general legal work. It's like your MVAs, your civil matters, and that would include also your divorces and an array of civil related issues or matters. And it would also, I also did criminal.
All right.
And I also did matters administrative in nature and labor related matters here and there, just a snippet.
Okay. Well, in the midst of running that practice, you've done other things. Between 2013 and 2016, you were a member of the Department of Justice's Audit Committee. What did you? What does that role entail? What did you do there?
Just to play an oversight role over the Department of Justice, as it was then called, stakeholders. That would have included your NPA and yes, and other related stakeholders. So we would play an oversight role.
Okay. Then, between 2014 and 2016, you acted as a magistrate in Kempton Park.
Correct.
Was it a busy court?
Very busy court, I must say.
What kind of cases did you adjudicate?
Family law, that would include your domestic violence, your maintenance-related matters, and your criminal trials, criminal court rather, because that was inclusive of everything that had to be dealt with in a district court. And that would include also your civil-related matters.
Civil trials as well?
Yes. And the motions.
Motions.
Yes, and the administrative part of it. Your debt reviews, which you would have to deal with, obviously, in chambers.
Then you stopped in November 2016. And started acting as a judge a few months later in the Gauteng division. But then you say you've also acted in JP Tlalitse's court in the Northern Cape for a period of 31 weeks.
That's correct. 31 weeks, yes.
Uh-huh. And a total of 93 weeks in Gauteng.
Yes, but if I may, whilst I was reconciling my stats, I realized that there are 5 weeks in the Gauteng division of the High Court.
95.
That I left out, yes. So I put them in my stats as I was
Oh, all right.
reconciling it. So in total, in Gauteng, I would have served for a good 98 weeks.
Sorry?
I served for 98 weeks.
98?
That's correct.
Okay. So 98 in Gauteng, 31 in the Northern Cape.
Yes.
Okay. And in which course have you sat in the High Court?
I would say all courts, except for tax. I never dealt with any matter that was tax related. I dealt in civil. I dealt with everything that was assigned to me.
Okay.
And that would involve your civil trials, your special civil trials. I dealt with motions and I dealt with both
Appeals.
opposed and unopposed motions, including your special civil motions.
Appeals?
I dealt with appeals, civil appeals. And also in criminal, I dealt with criminal trials, petitions, and your criminal appeals, and your bail appeals, of course.
All right. Did you sit in the Ashton Court?
Yes, I did.
Did you find time to write judgments during these lengthy acting stints?
Yes, I did.
How many?
I wrote as many as 80.
80.
That's correct.
Any of them reported?
None of them.
Okay. I see that you've also chaired disciplinary tribunals for a number of bodies, such as the South African Council for the Architectural Profession, the Engineering Council of South Africa, Council for the Built Environment where you worked, and National Home Builders Registration Council.
Correct.
And what lessons have you taken, can you use from that experience for this job for which you are applying?
No, it's just to pay attention to detail. That's for me, that's the most takeaway I gathered from all those bodies.
Okay. All right. I will leave it here for now and hand over to the acting judge president of the division.
Thank you, Chief Justice.
Good afternoon, Ms. Vuma.
Good afternoon, AJP.
I think maybe I should first disclose that did you do your articles at my firm or you joined me after you admitted?
It was after my articles, after my admission.
We worked, you were my PA for about 3-4 years.
Thereabouts.
I also heard you talking about MVA. Just shows that you've been practicing for many years, because so that people know it as RAF. Okay. I've looked at the records. You've got the necessary experience, and I've also looked at the recommendations made by various legal bodies. I'll just raise one thing, and I need your comment. This is the information that I received today, that you are involved in the criminal case, State versus Sibanyoni, where you're representing 3 accused, 17, 19, and 20.
Yes.
This is a matter before Judge Kuni. When did this trial start?
It started almost 2.5 years ago.
Has the state closed its case?
It's yet to close its case.
And there are 23 accused in the matter.
That's correct.
The information that I get is that this matter may still run for another year because the state must close this case and there are about 23 accused. Any comment?
That remains to be seen. Once the state closes this case, AJP, the accused
Speaking
might...
too softly, Ms. Bowman.
Apologies. Once the state closes its case, it could well be that cancel old instructions that the accused are going to be closing their cases.
Okay. So you don't know for how long the matter will last?
Certainly not.
No. Yeah. My colleague also told me that the record consists of about 10,000 pages in the matter. The record of the proceedings.
Am I to comment, AJP?
Do you agree or do you disagree that the record is this big?
Obviously, it would be that big. The matter has been running for over 2 years.
Okay. Now, why I'm raising this matter is that should you be recommended for appointment, when would you be available to start, or what would happen to this matter? Because I'm told that the 23 or most of the accused are in custody.
First, with your last question, if I may, AJP. I'm on brief by the Legal Aid Board of South Africa, and it's 7 of us, counsel, that is, who are representing this accused. And as perhaps the AJP might be aware, the Legal Aid Board prescript allows or permits for counsel to represent at least up to eight accused in the same matter. And if perhaps I may bring it further to the Commission's attention, there is no conflict of interest amongst these accused. So were I to be appointed, it is a general practice where legal aid accused, or where in an instance where accused are not in conflict with one another, that those clients, for one reason or the other, should counsel no longer be available, that they be spread across the counsel who are available. Because these things do happen, AJP, that for one reason or the other, counsel may no longer be available to continue with that matter. But I would imagine that should it get to that point, then it shouldn't be too difficult for 3 of my clients to be allocated to any of the other 6 counsel who are involved in the matter, especially since there's no conflict of interest amongst these 23 accused.
Yeah. Do you agree that if you are recommended for appointment, it will also depend on these clients whether they would agree to be presented by other counsel or not?
I did explain to them the ramifications of the outcome of my interview, and as I sit here, I have their blessing.
As you sit here?
As I sit here, I have their blessing, to the extent that perhaps the Commission might recommend my permanent appointment.
Okay. Thank you, Chief Justice.
Premier.
I'm okay, thanks, Chief Justice. Thank you.
Any questions, Commissioners? JP Tlalesi?
Good afternoon, Ms. Guma.
Good afternoon, JP.
Are you well?
I'm very well, thank you.
Thank you. I just want you to, or refer you to the cases you referred to on page 15, the paginated pages, regarding the cases in which you have appeared that would regard as being most significant and why. State versus Twala is the first one. Have you reached the page? Yes. Is there anything that perhaps would want to clarify on the significance of these cases? You might have held back and then maybe just if there's a need to supplement so that you can have the information.
JP, there isn't much really to supplement what is already contained in this matter. Unless if perhaps the JP seeks a particular clarification, then perhaps I could
No,
attempt.
the significance. I'm more interested in the significance of these cases. Why you refer them?
In respect, sorry. In respect of the 1201 JP, why I find it significant, it's because of the closure that it brought to the family of the deceased, especially post the conviction, the court having made an order, a declaration that the missing councillor is declared dead. So I found it very, very, very comforting to know that at least whatever would have happened, they can now move on with their lives. That's the significance which I find in State versus Twala and two others.
Okay, and then Matlatse Trading Enterprise, CC versus Nuku Powerline, CC and another.
The Matlatse matter, it is a matter which involved, if you will allow me, a Pedi speaking and a Pedi male person who, on the instruction of the plaintiffs at the time, received summons for some monies and so on and so forth. But what is interesting is that what he receives is this document, which is written in Afrikaans. And he sits on it, he doesn't know what's going on until he consults with me. Now, together or over and above this Afrikaans written document, he has with him what is now a default judgment application, informing him that on the basis that he didn't enter an appearance to defend, a default judgment is now going to be taken to court, and that he has to, for reasons, flowing from the summons. And that is when we drafted the papers asking for the rescission of that judgment on the basis of the unfairness, insofar as him being Pedi speaking, for one reason or the other. Summons are drafted in Afrikaans, and he couldn't make head and tail as to what that is. And what I find very interesting is what the judge finds in this matter, in his judgment, that it's not fair, because imagine where the defendant in a matter, it's Afrikaans speaking, or it's an Afrikaner, and the plaintiff is vendor. Would it be fair for the vendor speaking plaintiff to draft her summons or her papers in Chivenda, since it is one of also of the official languages, despite the fact that one is well aware of the fact that both Afrikaans and English, they are deemed to be competent languages insofar as court matters are concerned. But ultimately, there has to be fairness when all is said and done, and that this was not fair. It was designed, it would appear, to frustrate the defendant to the extent that perhaps he might have been willing to mount up a defense. And how do you fight an enemy you don't even know? So the constitutionality and the access of justice, it was brought to bear to say, if you draft papers knowing that I won't be able to make sense of what is written on the basis of the language in which you express your issues, then effectively you're denying me my right of access to justice in a way. So it reinforces and emphasizes the fact that the right to access, it's got many, many angles, and it can be denied one way or the other, subtly so, or pointedly so. And in this instance, it is my sense that it was a subtle denial these defendants' right to access to justice. And the court affirmed that right in its rescission of that judgment or default judgment.
And the third one, State versus Matotsi and 13 others.
The significance that I find, from where I'm sitting, JP, the significance that I find in the Matotsi matter, because you cannot undo, you can't unscramble an egg. What's done is done. But what personally I found maybe could have been, in a way, comforting to the victims of his actions was what I deemed to be his apology, his sincere apology. There's nothing more which under those circumstances, that could have been done other than to say, well, it's our loss, but he apologized. For me, I found it to be very important. Perhaps given the attachment that I put to an apology. That is why I take it in high regard that he apologized after all.
But do you still recall the sentence that was imposed?
Yes, he was given 15 years. And perhaps I must leave it at that. He was given 15 years.
Thank you, Ms. Buma. Thank you, Chief Justice.
Minister.
Thank you very much, CJ. Good afternoon, Ms. Buma.
Good afternoon, Minister.
How are you?
I'm well, thank you. Yourself?
I'm okay. Just want to ask something that I picked up in the comments where it was said that you conducted a court in a restaurant. Your comments on that one? I don't know if you saw the comments from the law bodies.
Yes, I did, Minister. Perhaps if I may bring it to the Minister's attention that in 2021, I said before this body, vying for this position. And it's on that basis, of course, it's my understanding, I stand to be corrected, but it's my understanding that it's primarily, if there were other secondary reasons, it's primarily that very spare issue that see me sitting here again today. So even back then, I apologized profusely. And of course, I hope and I wished it never happened. There was no...
So it was nothing like that has happened ever since?
No, nothing. It happened in 2018.
Okay. Let me just go to the issues around access to justice. I noted in your CV that you've also acted as a magistrate in one of the busiest areas, Kempton Park, where there are issues actually in terms of access, because you have quite a lot that you deal with from the airports as well.
Yes.
Are you able to share as a practitioner as well, I'm thinking about that, opportunities that many women who have been coming through since last week, talking about access to opportunities for thriving in the sector in terms of transformation, but has that acting both as a magistrate and in the High Court given you access to opportunities that you think have made you better to be able to sit here today?
I wouldn't, I take it the minister is referring to opportunities insofar as briefing would be concerned. Am I correct?
The issue around access to opportunities for Black women would mean anything. Acting opportunities, briefings, briefing patterns. But in your case, I focus mainly whether the acting stints have added value in terms of where you are sitting, being able to, or is it just a passage for you to be able to say, I can be able to get to be interviewed?
Definitely, it has given me a new outlook, a positive outlook, as to the possibilities that surround me. And
Just pull the mic closer.
yes, sorry. It has given me, as you know, I think I'm now more confident, and my confidence is what propels me to believe that nothing is impossible, and it's because and even when I'm sitting on the bench, and I always remind myself that I'm not sitting here by accident. I've earned it, and I say this with the greatest of humility. I've earned it, and I continue to earn it by making sure that due diligence remains the order of the day, and that people get the justice which they so deserve, and many of them even paying for it, exorbitantly so. So yes, both the acting in the High Court and the Magistrate Court, it has given me some leverage, I must say.
Maybe what I need to, because Ms. Fum, just to get more details about your role, maybe let me link it to your question, how you answered number 10. And the reason I'm asking you this is, as I said, quite a number of female practitioners, you are an attorney, so you brief. Quite a number of advocates, for example, would say that they're not receiving briefs because they're not believed in and all that. And part of the issue is, as you experience being a magistrate, being in the High Court, seeing quite a number of them being briefed or not briefed, appearing before you in terms of exposure. So everybody has a role to play in terms of transformation. That's all I wanted to say. But when we look at number 10, I'm linking it, you don't seem to be reflecting quite a lot in terms of your contribution into pursuit for justice in the country, but also just around your significant, for example, your role, your significance in law. You just say the fact that you always make yourself available to assist the indigent whenever I am. What do you mean? How do we make that? What is that helping an indigent wherever you are, contributing to the pursuit of justice?
Let me put it in this way. There are many people who would consult with me. Even at my home, there are people who would come and they would seek legal advice. And it's on that basis that I assist them. And there would be times even using my own resources, them not having even approached the Law Society for a pro bono, that I run with their matters, free of charge. And I would regard that also as my contribution. Because at least someone at the end of the day is getting the justice that they deserve.
No, thank you. Your answers are quite short and sometimes they don't make us understand you. That's why I'm probing in this area.
I understand.
Your questionnaire, the way you wrote it as well, it's sentences yourself. For us to understand, maybe somebody does know you. Maybe you think that because you've been here before, I was not here. So I'm trying to understand the person in front of us. That's why I asked that question. Thank you, CJ.
Thank you, Minister. Prof?
Thank you very much, CJ. Good afternoon.
Good afternoon, Prof.
I've been looking at some of your judgments, and I've seen that you have came into contact with admin law, and you have written judgments on that area of law. And obviously, should you be successful, the court where you are going to be based will be dealing with a lot of admin law. And it really is satisfying to know that at least the candidate has some understanding of some of the basic principles. And it is on that basis that I'm asking you this question that I'm about to ask you now. I've always found admin law to be a little bit challenging. Sometimes I'm not quite sure as to when would one be justified to approach a court on the basis of parja directly or on the basis of legality. Can you just clarify to me the differences between the two processes, if there is any, and when does which process actually apply?
Thank you, Professor. With Paja, one would ordinarily employ it in an instance where, particularly, there has to be these three critical pillars, where you decry the fact that the action by whoever the administrator would have been, or the decision is procedurally unfair, or the issue of reasonableness, there's no reasonableness in that action, and that the action is not lawful. So you would be challenging the administrative action or decision on that basis to pursue the whatever that you want to write. And sometimes the issue of rationality would equally be factored in as you're employing parja. But the issue of legality and the issue of legality, it arises also in an instance where it could be due to it flows from the lawfulness or otherwise of an action or decision, and what you will be contesting is that the decision or the action which you want to bring to court or a tribunal, whatever body that you want to pursue that action before, the decision that you're challenging, it is not lawful, or it was not lawful, and the person against whom you would be going could be an executive person, perhaps in the person of the president, or even parliament, and to show that legality is wanting, you will have to establish that the action does not talk to the law, that gives this body the right to act in the manner they did. And further, that when you consider the action, that action is not justified by be it the facts or the information that would have been before the administrator at the time, and that the decision, even the reasons don't justify that decision or the action, and that the reasons themselves, they are not rationally connected to the empowering statute. So that would be in a nutshell.
I hear what you're saying, but it seems like you're saying the same thing in a different way. Obviously, when you review a decision of an administrative body, there is an issue of unlawfulness, and you want an upper body to set that aside. So unlawfulness will be common to both of them. But what I don't get is where is the distinction, if any, if there is any, and whether they can be used interchangeably. That's what I'm trying to get at. But no, I think your answer is your answer. Let me not burden you any further. Thank you very much, CJ.
Can I follow up? Chief Justice, may I follow up?
Yes.
I'm struggling to understand your answer, and good afternoon.
Good afternoon.
Are you saying when you're launching a review and you need to make the decision as to whether you want to review the decision in terms of PAJA or the principle of legality, as I understood what you were saying, and correct me if I'm wrong, you were saying if you want to challenge the procedural fairness or the rationality of the decision, you choose PAJA. If you want to challenge the lawfulness of the decision, you choose legality, the principle of legality. Is that right?
No, it's not right. It will be only because you would find that compositely the issue of legality it forms part of whatever that will arise, which will equally be catered for in PAJA. So it's not a separate aspect from PAJA.
So then, how do you decide whether something should be brought under PAJA or the principle of legality?
The nature of it depends on who the decider is. Yes. So if it's an organ of state, well, if it's an organ of state, or say for instance, or if it's a public institution, or if it's the president or parliament, you would then decide issues relating here to primarily turn on the legality aspect. And that is how you would go about it. Unless if I'm not getting your question, Commissioner.
No, I think it might be me not getting your answer. So give me an example of when you would say it's a PAJA review and an example of when you would say it was a legality review.
A PAJA review would be in an instance perhaps where tenders are involved, bids are involved, and you're not satisfied with having been overlooked or not having won the bid. And you want reasons, you want to be furnished with reasons as to why you would not have won the bid. So you would go the route of PAJA because you are entitled in terms of the Empowering Act to get reasons as to why not, or why even. Yeah, so that would be insofar as PAJA is concerned. And with legality, you will have to consider whether the action which, say for instance, maybe by the president, you will have to consider whether their action or inaction, it fulfills their constitutional obligations. And if that action, if it's an action which you're concerned about, you would have to check if that action was lawful. So that is where the issue of legality would come in.
So if a decision is an administrative action, can you use legality? Should you use legality?
Yes, if you are challenging the lawfulness, I don't see a bar. Why not? Because legality would equally address the issue of lawfulness. So you are impugning.
That's not my understanding. My understanding is that PAJA exists for all administrative decisions. And if once you've classified properly a decision as an administrative one, which is usually one made by the bureaucracy in its daily work, you're obliged to go by way of PAJA. Where the principle of legality comes in is where the decision is not administrative, but is still subject to still has to be exercised lawfully, even though it's not an administrative action. So I think that's the threshold. So you're right, usually the president's decision, the reason it's usually reviewed under legality It's because it's not an administrative
Yes.
decision in the course. Thank you.
Sorry, Chief Justice, just to clarify something as a follow-up. Uma, that's just the answer you've given, that the dividing line between pleasure and legality is the identity of the decision maker. Did I hear you correctly?
That's correct.
But, I mean, this was decided in 1995 already in SARFO, that it's not the identity of the decision maker, but the nature of the decision. So I'm not understanding why you are still saying the dividing line is the identity of the decision maker.
You are correct, Mr. Commissioner Gauteng.
Thank you, Sir.
Ms. Vuma, you're excused. Thank you.
My pleasure.
Please switch your mic.
Excuse me. Morning, Chief Justice.
How are you?
Fine, how are you?
I'm well, thank you. May we start?
Yes.
Okay. You are an advocate.
Yes, I'm an advocate.
And you've been practicing in such since 1989.
Yes.
Okay. You hold 3 degrees, a BA, majoring in economics and psychology, which you obtained with distinction, an LLB, cum laude, and an LLM in tax law with distinction.
Yes.
And the first degree you obtained from the University of Cape Town.
Yes, Chief Justice.
And the other 2 from the University of Witwatersrand.
Correct, Chief Justice.
Right. So what kind of practice have you been running for this past 36 years? What kind of work do you do?
My practice was generally commercial work, and I intentionally tried to steer away from matrimonial work because I knew that it tends to pigeonhole women at the bar. And I continued until I was offered the opportunity to go to the State Capture Commission. And I spent 2.5 years at the commission.
As an evidence leader?
As an evidence leader. And then when I left the commission, there was a lot of offshoot work from the commission, particularly work from the National Prosecuting Authority, because I'd been in the law enforcement agency work stream. And we were asked by the ID and the general part of the National Prosecuting Authority to assist with several aspects following upon the commission. And that filled a lot of my time after I left the commission. But what I also found is that when I'd left the commission, I was substantially older. And my commercial practice before I went to the commission had been to be a senior junior in commercial matters. But I was now actually found myself being too old to be briefed as a junior in those matters. I stopped getting those briefed. But I also stopped receiving the more junior commercial work because I was regarded as too expensive, and I also wasn't a silk. So what then happened with my practice is I started to get other work from the state attorney, work that was not related to state capture, but was also generally not commercial work. I started to do very different work with the state attorney. And what I found is that I would then began to be able to command juniors. I was able to ask the state attorney to appoint juniors for me. And in the last few years, I've acted with a number of juniors, all of whom have been black juniors, except for one colored junior. So the nature of my practice is really, it's changed enormously. I'm actually doing quite a lot of labor law, which I've never done before. I've done a lot of constitutional law. I had done a lot of constitutional law before because I'd been involved in a lot of reviews, particularly with tender irregularities and corruption. But I find myself with a very different practice, and I've actually quite enjoyed it because I've been more self-sufficient, and I found that the state attorney has allowed me to command respect.
You've also practiced as an arbitrator.
Yes, I've acted as an arbitrator on numerous occasions. I've also been appointed by the Bar Council to act as an arbitrator. And I've also, in the course of preparing for this interview, the acting judge president asked the candidates to have a look at how many judgments we'd written, in which fields we had written those judgments, and also in which courts we had sat. And I actually determined that I have acted for 31 weeks. And in the course of that time, I've actually written 49 judgments. So although the ones that are appearing on SAFLI, it seems to be about 29, I've written 49 judgments, and I've written them in a huge array of fields. So I've had a lot of experience acting as a judge. I've learned a lot, and I really enjoy the experience.
Your acting stints have been here in Gauteng.
Pardon?
your acting stints have been in this division, in the local division?
Yes, they have. So all my acting stints have either been in Johannesburg or in Pretoria.
In Pretoria. And have any of your judgments been reported?
You know, I found it confusing because for me, when you say
Reported is in the law reports,
in the
not,
law
not on
reports.
Safely or any
Not
online
exactly,
platform.
exactly. So for me, the one that's been reported is the one, I think it's Mbeki Manganese, or I can't remember the exact name of it. It went to the Supreme Court of Appeal. That's the only one that I'm aware of that's reported in the law reports.
Why have you never taken silk, if I may ask?
That is a good question. I have applied for silk, and interestingly, one of the objections to allowing me to be conferred with silk was that it was well known that I had aspirations for judicial office. And it was put to me, but if we give you silk, you are just going to go straight to apply to go to the bench. And my answer was that I don't see why that would deprive me of being afforded silk. And the response that I got was, it does, because you are going to be appointed silk, and then the bar itself is not going to benefit from your having been a silk. And for me, I don't think that's a valid response, because honestly, it's in the interests of the bar to have good judges on the bench. And it's also in the interest of the bar and the judiciary to have people who go to the bench appointed silk if they deserve it, because it lends to the gravitas of the bench. And I know there's a kind of moratorium that if you want to go to the bench and you are a black or a white woman or a black male, you're eligible if you're not a silk. But if you're a white male, you must be a silk. But the truth is that where someone is deserving of silk, we don't want to be elevated to the bench on the basis of a moratorium. And I do believe that I'm deserving of silk, and I think if I applied again, I would get silk. But
So
what
did you apply only once?
No. I think I applied on 3 occasions. And one of the issues that was also raised, which I just wanted to add, is that I hadn't acted sufficiently with juniors. And what I tried to explain is that at that time, the nature of my practice was such that I was briefed as a senior junior in very large commercial arbitrations. But I was not briefed independently. And if I can tell you how that happened in my practice, because I think it is important to understand why it was that it became difficult for me to act with juniors and to be briefed with juniors. And I was building up a very good practice for myself when my children were young. But I worked with my first 2 children, but all 3 of my children, until the day before my babies were born. I was in court with this big pregnant stomach. But after my son was born, I thought I've missed out so much of my life with my children. I'd like to see if I can try and practice from home. So I applied to practice from home, and I was granted permission to do that. But unfortunately, what I found is that when you are a woman at home at the bar, you're kind of out of sight, out of mind. And also people stop taking you seriously. And if you're a commercial lawyer, but people think, well, she's not available, she's fetching her children from school, or she's doing this. So if in effect, my practice diminished enormously during that period. So after that, it was a period of 2 or 3 years, I decided that it wasn't feasible for me to practice from home. I needed to take chambers again, and I joined Group 1. And when I joined Group 1, before I joined Group 1, I'd looked at the kind of nature of women at the bar, and what I realized is that to try and be taken seriously and receive good work, it was very important to be specialized. And so I decided what I'm going to do is I'm going to register. I was into my 40s, and I'm going to see if I can specialize in tax law. And I registered, I joined Group 1, I was granted, afforded a pupil, and before I could move into my chambers, I had a massive thrombosis in my brain and a stroke. And that precluded me, I had to sublet my chambers, tell the Bar Council I can't take the pupil, and I had to go and recover for a year. And somehow at the end of that year, with very little time, I had to get a thesis in, which I did. And the next year, I had to write an exam, which I did. And then after that, now you can imagine, I've been out of sight, out of mind for another 2 years. I went to Group 1, and I didn't have really any attorneys who were briefing me at all, and I was now in my 40s starting again. And so I was reliant for my work on the kindness of senior members of my group who brought me into matters that they were involved in. And then what happened from there is I got briefed in more and more complex matters, which in a way was very good for me, but also to my detriment, because they were not matters where the attorneys felt that they would brief me on my own. And the attorneys who did brief me, I had to draw all the papers in the matter, and when it came to going to court and there was a silk on the other side, then, and I'm telling you, it didn't happen to me once, it happened to me on several occasions. In every one of those matters, the client and or the attorney said we need to bring in a white male silk. And so I never got to actually run those matters, and it was incredibly frustrating for me. But when after I had applied for silk and I'd been told I didn't have juniors, and I was trying to explain that it was very difficult for me, the very first brief I got from the state attorney, that I had an opportunity to bring in a junior, I spoke to the state attorney and said, can I please bring in a junior? This matter is big enough, it's complex enough to have a junior. But unfortunately, the department I was acting for said they were not going to pay for a junior. So what I did is I approached the Bar Council and I asked them if they could assign a junior to me, which they did, and I paid for that junior. And it was a big matter, and I was actually very generous in the amount that I paid him, because I was told that there was a certain rate that I would need to pay him, and I paid him twice that rate.
And who was this junior? Was it a woman? Was it a man? What was their race?
It was a black man. But I had no choice. The Bar Council assigned that junior to me, and the idea behind it is that I think people are only eligible if they are baby juniors at least less than 5 years at the bar. But I think it's generally people who've just come to the bar to try and assist them in meeting, as he did, the state attorney through me, and that helps his practice get going. And after that, as I said, since then, and since I've not been only doing estate capture work with the state attorney, in all the matters I've been briefed with black juniors.
I interrupted you as you were saying you believe that if you applied for SIL today, you'd get it. What's stopping you from applying?
Because in my mind, I didn't apply last year because I was hoping that I wanted to apply to come to the bench. And then I did apply, and the current Deputy Chief Justice called me, and he said to me, I am not going to, the reason I didn't make the shortlist, he explained to me, is that I hadn't acted enough since I'd left the commission. And he asked me to please come and act for a further periods, which I did. So I acted for a month at the end of November, and then July, August this year, I acted for another month. And with those additional 8 weeks, I've now acted for 31 weeks.
Okay, you list your involvement in the Human Rights Subcommittee of the Bar Council.
Yeah.
The Briefing Patterns Subcommittee.
Yes.
And the, excuse me, the Transformation Committee of Group 1. What do these committees do?
Well, the Transformation Committee when I was there, what we wanted to try and achieve, and it's a matter that I tried to propose, is to see if we could introduce a clerking system, something similar to what they have in England, so that if a group gets work, attorneys will phone the group, that they'll speak to either the administrator or clerk is in that group, and particularly for a divorce, unopposed motion, noting judgments, that kind of work, there would be a pool of people who could be recommended, and that the group would then say, okay, you've had your turn, it's this person's turn, it's that person's turn. And the other was but that didn't really find favor. It wasn't seen as a very good idea. When I was with the Briefing Patterns Committee at the bar, it wasn't my idea. They had a very good idea, and that is in the unopposed motion court, and particularly the default judgment court, which makes up an enormous amount of the matters that appear, the matters that are before the judges in those courts. And that was to approach the banks themselves. And there was approach to Standard Bank, I think, and they actually were very amenable. And a list was provided of a whole lot of juniors who were previously disadvantaged juniors, and they were asked to try and brief, giving people a chance all on that basis. And the idea is that it would be run all over the country. But ultimately, it was quite difficult to police that system. And I remember we had a lot of frustration with that. There was also a lot of the juniors, like middle, senior black juniors on that committee, who found it increasingly difficult that they didn't have skills, and that there was no way for them to get skills unless they got the briefs. So they needed And they didn't just need the junior briefs, they needed to take that, not junior briefs, I mean the unopposed motion court kind of briefs. They needed to be able to take that step that they would be briefed in their own in the magistrate's court and this type of thing. So we also then engaged with the state attorney to try and give lists of people, of previously disadvantaged people, see if they could brief on that basis. But I remember Standard Bank came back to us and they had very positive kind of response saying, this is how many black juniors, this is how many whites, this is how many coloreds, this is how many years they had experience, this is just how many briefs they got. But after I left that committee, I'm not sure how far that has got and whether it's been persisted with. But what I have seen recently now is I've seen that when I mentioned earlier that I thought that it's very important for people who try and build a career at the bar to try and specialize. It's very difficult to compete as a jack of all trades. So I've seen that what AFTR's doing is they're starting to run workshops, and I think I saw that there's a workshop that was supposed to be run, I think it might have been cancelled, but on competition law. And they're doing that in a number of fields. Now for me, that's probably the most productive way of trying to transfer skills and equip juniors to deal with a whole variety of things and then take that leap. Because if you get a brief in competition law and you know nothing about it, you've got to spend so much time reading and working it up that you can never charge for. But if you can attend a couple of courses, when you get that brief, you're already halfway there. So I think that's a very important initiative that I'd never thought of that, but I think it's very important.
Any such initiative?
Have I been involved in that initiative?
With that kind of initiative?
No, I haven't. What I did offer my services to the advocacy training at the bar for year after year after year. And at the time that I had applied for Silk, I actually mentioned that I keep putting my name forward, but nobody seems to respond to me to invite me to do it. And when I was finally invited to do it, it was when I just joined the commission. And so I couldn't do it. But what I have done is I've been teaching the pupils for the South African Independent Bar to help them with their exams. And I've done that 2 years in a row. So it's outside of the bar, but I've assisted those pupils.
Okay. Thank you, Advocate Wenzel. HJP Network.
Thank you, Chief Justice. Good afternoon, Advocate Wenzel.
Good afternoon, Commissioner.
When I look at your work schedule, you haven't done a criminal trial.
Yes, that is correct.
Should you be appointed, are you aware that such matters can be allocated to you? And as a judge, criminal trials are not exclusively for certain judges.
Acting Chief Justice, I am aware of that. And I know it was a comment that was raised, I actually think by AFT. But you will see in the schedule that I've prepared for you, I think for 3 weeks of my allocation, I sat on criminal appeals. It is different from running a criminal trial. But obviously, through no fault of my own, in my acting appointments, it's the discretion of the deputy judge president to allocate where you're going to sit, and I've just never been allocated in the criminal court. But what I can tell you is that I've sat for several weeks in civil trials. I know criminal trials are very different. There's a totally different onus. A whole lot of different principles apply. Never ashamed to say to counsel, and often at senior counsel, I'm not familiar with this law. Please go slowly with me. Don't assume I know anything. And in that way, I am taught in a way by the counsel. And then afterwards, I will always go look up the law further, read all the cases I'm referred to, research if there are any other further cases that I have not been referred to. And then after that, I'm more familiar with that area of law, and the next time I get a trial or an opposed motion, I'm in a different position. And I would just take exactly the same approach to criminal matters. I would ask assistance from fellow judges. I would ask assistance from counsel in front of me, and I would make sure that I did justice to whoever it was or whoever the accused people it was who appeared before me. Because obviously criminal law is very, very serious because people's liberty can be taken away from them. It's not the same. Well, it's terrible to lose money and to lose your house, of course. But if you've got a prospect of being incarcerated, that's very, very serious, and I would take that job very seriously. But I do believe that I have the intellectual capacity, the competence, and a sense of justice and fairness that would allow me to run those trials in a fair and proper way.
Are you aware that when you are in a criminal trial, you've got the benefit of asking for assessors to help you?
Yes. And I would certainly do that.
Thank you, Chief Justice.
Fully covered, Chief Justice. Thanks.
Minister.
Thank you very much, CJ. Good afternoon, Advocate Vansal.
Good afternoon.
The first one, I want to check. In your questionnaire, you don't seem to have any community work reflected or mentoring program or training program. Are you able to share if you are involved in any of those?
I tried to address that earlier with the Chief Justice to explain that I did try to put myself forward to do mentoring programs, particularly with the advocacy training. And I have taught the pupils from the independent bar. What I've also done is there's an initiative in Group 1 where, and it only involves females, but it's an initiative where the senior female members of the group are each year paired with a new junior in the group. And I've participated in that program ever since it has started.
Okay, thank you. The second one is relating to your response to CJ.
Yes.
As he was talking, she was asking you some question. You made reference to say, and I'm trying to understand it better perhaps, you made reference to say that when you came from the work of the state capture, you were no longer regarded as a junior. It made it difficult. I couldn't understand what you were trying to communicate there. So you became a senior advocate. You wanted to remain a junior. That's what I'm trying to understand there.
Yes, yes. I'm sorry for the confusion. What I meant is that so when I went to the State Capture Commission, I was about 55 years old. And at that stage, I had been a senior junior in big commercial matters where, and I'd left a lot of those matters halfway when I joined the commission. But when I got back, what I found is even those briefs I wasn't getting anymore. And that's because I was now 3 years older. I was 58 and approaching 60. And I found that I was actually just regarded now as too old to be a junior, even though it was in a senior matter. And I don't know why those 3 years made such a difference, but it did. But as at that stage, I'd already been out of my practice for 3 years. So I didn't have a set of attorneys who are now immediately briefing me on my own in those matters. And even when I did, as I said, what was happening to me is I was being told, no, we need to have a silk. And black males were brought in to lead me. So I just was in between, and that's what I tried, the frustration I tried to explain to the silk committee is, you're putting me nowhere because I'm not getting the work because you're not making me a silk, but I'm too senior to be a junior, so I can't do junior work. So it was very, very difficult. And actually, the work I started getting from the state attorney is what rescued me.
Okay, and at that time you were also doing the work for NPA.
Yes.
If I may check, during the time you were doing the work for NPA, were you also acting as a judge?
No, I didn't act as a judge because of the commitment that I'd made to the NPA. And I had wanted to, at that stage, I've always wanted to be a judge. Ever since I've acted, since I was 2015, I've always wanted to be a judge. I love acting as a judge. I feel it's the one place that you really can make a difference. So that even though it is not a pleasant exercise reading 80 default judgments for one day in court, the truth is, particularly now with the rules relating to the execution of property that is somebody's primary residence, the new rules require reserve prices to be set, but also giving judges an enormous discretion to allow leeway. And also leeway to have time to sell a house privately rather than at an auction with a sale and execution where you're going to get far less at a forced sale. And it's in a lot of matters also where you appear as a judge and there's an unrepresented litigant. And they ask for time and advice as to where do they go to get help. And I've often asked the counsel on the other side, please go provide assistance. We're going to give time. These people must be represented. It gives me, just gives me a sense of fulfillment that you have power to do justice. The other part I love is...
No, I was asking if at the time
yes,
you were acting for NPA on the matters that are brought before court out of state capture.
Sorry, I did.
Were you the acting judge? So I'm battling to hear your answer there.
Yes, you're quite right. I've gone off on a tangent. The reason I went off on a tangent was that when I left the commission, I wanted to go and apply to be a judge again. But I felt that I was so invested in the work at the commission and I owed a duty to complete the work through the NPA. That work was ongoing and it was literally keeping me busy every single month. And
so you're still in brief currently from NPA?
I'm still currently in brief with the NPA and hopefully it's going to come to an end. But I've done almost all the preparatory work in that matter now.
Your contract now is how long with the NPA?
No, I'm not on contract.
You're not on a contract.
No.
Just it's a brief.
It's a brief.
Okay.
It's not on contract.
And
do
you're
have
working
a s-
alone on that brief?
No, I've got a senior on that brief.
Okay.
But
You'd understand my concern from where I'm sitting as a Minister of Justice.
yes, I understand your concern, but I've got a senior in the brief, I'm in the brief, and there's a second junior in the brief. We've worked together on it for a very, very long time. I think it's about to go to a conclusion, but I was concerned that I've waited since I got back from the commission in 2021. I've actually waited 4 or 5 years, and I was concerned that actually, if I keep waiting until this goes to finality, every year I'm going to get older, and the older I get, the more I'm going to get an answer that you're actually too old now to be appointed a judge. And I want to avoid that, because I would really love to be a judge.
Thank you, CJ.
Thank you, CJ. Good afternoon.
Good afternoon.
I'm this side.
Commissioner.
I'm this side. Okay. Thank you very much. It's Commissioner Marumu Akhai. I was looking at your CV, and I was convinced that perhaps maybe discussions relating to mercantile law will be worthwhile with you. That mercantile law is your area of specialization. Different parts, company law and intellectual property.
Yes.
Yes. I had a chance to read your judgment.
Yes.
United Manganese of Kalahari that was taken to the Supreme Court of Appeal.
Yes.
And it was an interesting read. And from that judgment, I just want to ask you, because I've also read the Supreme Court of Appeals judgment also.
Yes.
I just want to know, what is the actual role of good faith in derivative action applications? And in answering that question, I just want to find out whether your view has changed in light of the Supreme Court of Appeals decision in relation to the minority shareholders in terms of Section 165 of the Companies Act, whether they bear the onus of proving the absence of collateral purpose as a self-standing requirement of good faith inquiry when they seek to bring this action to protect the interest of the company.
Yes, thank you for that question. It's something that I deliberated on a long time, and I looked at a lot of international law, and I think if I remember, I looked at Australian law as well. And I obviously at the time believed, yes, I've come to the right conclusion. But when I did read the judgment of the Supreme Court of Appeal, I think they are correct on the onus. I think I got it wrong.
No, thank you very much for that. My second question to you is, many people are starting businesses in townships and in villages, and most of them do not even worry about the intellectual property sort of protections that can actually arise from what they are starting, from protecting their names, protecting the goodwill, and everything else that comes with IP. I just want to get a sense whether, and obviously sometimes you find yourself having a company in the Northwest, and all of a sudden you get a letter from a company in KwaZulu-Natal where they say, you are using our name incorrectly, we want you to change your name and all those things. I mean, the company's tribunal is inundated with those kind of applications. I just want to know, and sometimes these are companies that are trying to protect their names, but they are not registered, those names. And you find that both companies' names are not registered. And the other one is saying, no, my name is a trademark and I've been using it for quite some time. Sometimes it's part of the same name of the family where they come from. I just want to know, in South Africa, is it possible to protect an unregistered trademark? And if so, under what circumstances?
Commissioner, to be honest with you, I haven't done an intellectual property case for several years. But as I recall it, if your trademark is not registered, unless it can be shown that you are passing off that name as the other corporation or entity's name, I don't think there is relief. And I'm not sure if you are in a village and you are not even aware that there is this other entity that is using your name, how you can possibly be found to be passing off.
In fairness, I should not take it further because I thought these are things that you are doing on a regular basis. But passing off is an extra thing that deals with unfair competition. So just from a common law perspective, I was just looking at it from a statutory point of view. But nonetheless, I won't take it further. Thank you very much. Thank you, CJ.
Thank you.
Thank you, CJ, and good afternoon.
Thank you.
Advocate Wenzel.
Thank you for putting up your hand.
Yes. I'm sorry to take you back from what you just discussed with the minister.
Yes.
Yeah, and it relates to separation of powers and the current position relating to the judiciary and the prosecuting authority.
Yes.
The other being part of the executive.
Yes.
And the impression that might be created might be that you are working for the NPA. Now, if you could just explain the nature of your relationship with the NPA and the kind of work that you were doing. For example, I want to establish whether you were working with dockets, getting involved with police officers and taking decisions on prosecutions, or were you still independent counsel, accepting or doing work for the NPA, receiving work from the NPA and taking independent decisions on professional basis?
Yes. The work that we've predominantly been involved in for the NPA is running disciplinary inquiries. So we haven't been involved in the criminal work of the ID. But if I understand it, and I believe I'm correct, is the nature of disciplinary inquiries are confidential. So I feel a little bit constrained to tell you what the nature of it is, but it's not criminal. It's internal disciplinary inquiries within the National Prosecuting Authority.
Your appointment was not the same as the appointment for prosecutors and people who take decisions to prosecute?
No, we've not been involved in that at all. That work is all done through the state prosecutors who are appointed by the ID.
I see. And then when last did you have this engagement with the state attorney? I mean with the NPA?
It's been ongoing. So what has happened is obviously there are delays, so we do some work, then a few months go by, and then we get briefed again to do some more work, and then another period elapses and we get briefed again to do more work. So it's just been an ongoing matter in that respect.
On the basis of the briefs that you received?
On the basis of the briefs that we received.
Thank you. Thank you, Advocate.
Thank you.
Chief Justice.
Thank you, CJ.
Minister is a...
My apologies, CJ. I'm confused, Advocate Wenzel. In IDEC, the work that they do in relation to state capture,
yes,
it's very clear.
Yes.
Now I'm confused about what you are saying to the answer to DJP.
Okay.
JP Tlalet's my apologies. My apologies.
If I can,
Yeah, I'm a bit confused.
okay, sure.
Because when I asked the question, that's why he did a follow-up.
Yes.
And I asked you, are there matters that you're dealing and you understand my concern? Hence, I asked you about your involvement in NPA and acting judge. Your answer to me was that you pulled out of being the acting judge. You've not been acting. You've been focused on the work of NPA. And I asked whether you're working alone. You said, no, you've got a team that you are on brief on. That's why I asked, are you on contract? Because I wanted to determine
No, we're not
whether
on
you
a
are a
contract.
Section 38 appointment or not. And that's the context I'm asking now. Your answer to the last question leaves me quite worried and hanging.
Okay, if I can understand what worries you is that there's no conflict whatsoever between the work, the disciplinary inquiries we've been assisting with in the NPA and the prosecutorial work that the NPA is doing. So the ID is briefed to prosecute matters that have arisen from the state capture inquiry. But our focus has been on disciplinary inquiries within the NPA, which have gone on for a very, very long time. There have been enormous amounts of delays, and they are not yet finalized. But it's gone on so long that most of the people who were being disciplined have already left the NPA and have retired.
No, maybe let me clarify. IDEC was established in 2024.
Yes.
The disciplinary will not be in IDEC but directly with NPA, because those will be employees of NPA, not in the IDEC. Because this work of IDEC is more around fighting corruption and organized crime.
Exactly.
So because they are employees of NPA,
yes,
the corporate services will lead on disciplinary measures, not IDEC. That's why I got confused about why you're referring. And the reason why I got concerned is because your reference to IDEC is because of the mandate of IDEC in terms of its work within NPA. Now, if you are working on disciplinary, it can't be within IDEC.
No, it's not within IDEC.
Yeah, that's what confused. So your reference, maybe clarify then your reference of involvement of IDEC.
No, it is, the work that we're doing is not for ID. Our brief is coming from the NPA and particularly the Human Resources Department of the NPA. That is who our brief has come from, through the state attorney, of course. So they have engaged the state attorney to brief us. The disciplinary inquiries, and this is where I'm saying I'm feeling, it's difficult for me to tell you the nature, but there were allegations that were made at the...
You don't have to go into detail. That's why I was saying what you led us to be confused.
Yes.
It's your reference to IDEC.
Because
of the mandate of that organization.
Yes.
Thanks, CJ.
I understand. I'm sorry for that confusion.
Commissioner Matolo Hlebo.
Thank you, CJ, and good afternoon, Advocate Wenzel. Good afternoon.
Good afternoon. Sorry, I'm just finding it hard to see who's talking to me.
Okay.
Oh, thank you.
You know, when I looked at your CV and your questionnaire, I got excited that you are serving on the briefing patterns subcommittee and the transformation committee. But whilst you're talking, I got worried that you don't seem to understand what these committees are doing. Can you just maybe give me comfort that you tell me what you do in this committee? Because for me, whilst we're talking, it's as if some people were doing it, not you. I need to understand what they
No,
did.
we were meeting on a weekly basis. And everybody was coming up with ideas and how are we going to fix things? What are we going to do? How are we going to be proactive? So on those committees, it is, so at that stage, the project that we were following was trying to approach the banks to try and see if we could give them schedules of previously disadvantaged people to brief. And then they have certain attorneys who get certain amount of the work, and they were instructing those attorneys to please brief the people on the list. And they were reporting back to us as to who had been briefed on the list. So it was a way of trying to assist previously disadvantaged members of the bar in getting work. Because as we all know at the bar, you start your practice doing divorce work, unopposed motion work, and noting a judgment. But every one of those matters is important, and the reason they're important is because they're an introduction to an attorney. So if you can get a bank to say, I want you to make sure that of the briefs, so instead of sending all your briefs for default judgments to one attorney who briefs one advocate who sits with 50 briefs, which they move on the one day. What we were trying to achieve was that work would be spread out. And if they could brief from the list, then every single one of those advocates who then got a brief from the list, they now got an introduction to a new attorney. And that was a way of, you get introduced to an attorney, they think, oh, I like that person. I need to note a judgment. I'll phone them and ask them next time. Or, I've got a small trial. Let me phone them and ask if they can do it. It was a way of seeing how can we make a difference.
You have been in practice for 36 years as an advocate, am I correct? And how many black juniors have you led? Especially females?
I think now I've had 5 or 6.
For 36 years?
Pardon?
For 36 years in practice?
Yes, but that's what I was trying to explain to you, that actually in the way that my life went, and I think I omitted to say to you also that before I went to the commission in 2014, my husband died. And he died in horrible circumstances, and he left us with an enormous amount of debt. And I had 3 small children. I was completely shattered. And I had to support my children. I had to put my head down. And unfortunately, in those years, my life was inward looking. But the minute I got myself back on my feet, you will notice that I've taken every single possible step that I can to try and get black juniors. And the first opportunity I did, I paid for that junior myself. And the other thing is, recently now, I'm a member of AFT. A few months ago, I got a request to pay a contribution towards pupils at the bar who are struggling to make ends meet. I didn't hesitate to make that contribution. So I know I haven't done as much as I should have, but I've actually, things have been a little tougher for me, but I've done what I can, and I continue to do what I can.
Are you still a member of this committee?
Of AFT?
Yeah, no, of Group 1.
Yes, I am.
I come to Group 1, I think on 2 occasions. I haven't met you actually, talking to the Transformation Committee. Well, are you really active in this group?
I'm active in that group, but I'm no longer on the Group 1's Transformation Committee.
Okay. Thanks, CJ.
President Moleman.
Thank you very much, Chief Justice. Good afternoon, Advocate Vessel. This is just a follow-up. I'm following up. I'm over here, ma'am.
Oh, sorry, I don't know. Do you know, when I had that stroke, I've lost my directional hearing. So I actually don't know from which side of the room the sound is coming.
Okay, that's fine.
Sorry.
Yes. How are you?
I'm fine, thank you.
Thank you. I'm just following up on the question that was posed by Commissioner Matolo to you. So I just need clarity. Could you please just clarify this for me? Are we at a stage where we can say that the issue of skewed briefing patterns has now been addressed and it's now a thing of the past? Or is it something that is still ongoing? Thank you.
Commissioner, the issue of skewed briefing patterns is nowhere close to being something of the past. And I'll tell you that I have felt it very keenly as a white woman trying to compete with white males in a commercial field. I will tell you that it's even harder for black males in the commercial work to try and compete. It's even harder and much worse for black females. Not that there are not some very successful people who have achieved it. But what I did get the sense when I was on the Transformation Committee was talking to the people who were really trying their best just to break in. And the problem with the bar is it requires someone to give you a leg up. So if you go to the bar and you join a group and somebody says, okay, let me help you do this, I'll try and do that, it gets you that one step further. But unfortunately, firstly, the bars become enormous. People don't really know each other properly anymore. And that's why I think you have to have some kind of system in place. That's why I thought of the pupillage system in England, because then the work comes to the group, not to the individual advocate, and then it gets spread out. But it's very, very difficult to address that, because so much is also luck that you manage to get a good mentor, and another is that people just continue to struggle. And the worst thing is that although group fees are subsidized, if you're not getting any work, it doesn't matter that your room is costing 5,000 Rand a month, because you can't pay for it. So it's far from being addressed. There's a long way to go.
Thank you for that clarification. Thank you, CJ.
Commissioner Shivan.
Thank you, Chief Justice. In the review of your application by the General Counsel of the Bar, they stated that you had 3 judgments they found that were delivered after 5 months, 1 after 5 months, 2 after 5 months, and 1 after 4 months. Before I get to that, do you know the average time, the recommended time within which judgments must be delivered?
I'm not sure which of those judgments that they are referring to, so it's hard to address it. But I know that there is now a rule.
Sorry, I can cite the judgments. They've cited it if you want.
Oh, have they? Yes.
It's M versus S. It's 2018, and it's Johannesburg High Court.
Yes.
They have 19 April 20, I think, I don't know if that was the hearing date. 19 April 2018. Then Kahalo versus Road Freight and Logistics Industry Provident Fund. They dated 19 April 2018, 5 months. And TABK versus LVK, JDR Johannesburg High Court, 4 months. 2023 case number.
Okay, the last one I recall, and it's the matter that involved the interpretation on the Adoption Act and whether a foreign couple could adopt a young boy. That matter took me a long time because firstly, I wanted to see the child, which I arranged. And then after it, I deliberated and changed my mind and deliberated again because it was a massive, massive issue because these were Polish people who wanted to apply to adopt a little boy that they'd looked after since he was a baby. They'd been in South Africa for 5 years, they'd moved back to Poland, and they were applying now, not as residents, to try and adopt this boy and take him to Poland. So that one, I know I just really struggled to come to a conclusion. To be honest with you, I can't remember the reasons for the other two judgments, but I know there's a rule that you must give a judgment in 3 months, and I will generally give a judgment in less than 3 months.
Thank you. What was your ruling in the case that you said, the Polish adoption case that took you 5 months? What was your ruling? 4 months, sorry. What was your ruling?
Okay, so what the argument was is that the High Court didn't have jurisdiction, and because they, not being residents, also had no jurisdiction to approach the High Court. And because there'd been a decision by the Department of Social Work that the child was not adoptable because there was an aunt in the country who was available to adopt him. Therefore, they couldn't go to the adoption court. They then approached the High Court to say, please allow us to at least have the matter heard in the High Court. I finally decided that they were entitled to bring an application to the adoption court, where it would then be, I gave a ruling on what I understood by adoptability, and the ruling that had come and had been made by the Department of Social Work was that it was based on policy of the department. It wasn't based on legislation. So I felt comfortable that I could say no, that wasn't going to be applicable, and they were entitled, all I declared is they were entitled to approach the children's court to apply for this child's adoption. But I have seen that leave to appeal has been granted in that matter. I haven't seen anything further as to what has been decided, but I have seen that leave to appeal has been granted.
Thank you, Chief Justice. I'm done.
Inkos.
Thank you, CJ. Afternoon, Council.
Good afternoon.
I have heard your response, in fact, many responses on the issue of you leading other councillors in your 35-year period. I don't doubt what you have told us, but take into consideration that you passed your LLB degree with cum laude to one of the best universities in our country. Is there any reason that you could not attain silk besides what you have told us?
Commissioner, you put me in a difficult position because in my view, I am worthy of silk. In my view, I've been worthy of silk for several years. And I don't understand why I haven't been given silk. I actually feel that I've been treated unfairly. I feel I deserve it, but it's unfortunately not in my hands. I can apply and I'm either afforded silk or not. But I do think I'm worthy of silk.
No, thank you, Counsel.
Thank you.
You produced about 29 judgments.
I actually saw 49.
49.
Yeah.
Thank you. 49 years, yes. And only the 29 that were reported fed through safely. But you say about one that had been reported in the law reports, if I understood your response to CJ's question on this regard. Why?
Part of it, I think, is firstly, I think that the reported judgments should really only be judgments that introduce novel areas of law. I have written judgments which I have thought might be reportable, but to be honest with you, when you're an acting judge, it always seems to me a little arrogant to mark your judgment reportable. So even the judgment that was reported, I was approached by the librarian and they said, we'd like to report your judgment. Would you like to review it? And I said yes, and they reported the judgment. I think if I was appointed a judge, I'd feel more confident to say, yes, I think this should be a reportable judgment. But I think while you're an acting judge, it's, I think it's a little assuming.
Thank you. Lastly, as a senior junior, and you know that you are capable of leading other juniors. You seem to have led very few.
You're correct.
Yes, and is there any reason why?
I'll tell you why, is that very unfortunately, as I tried to explain, what happened to me is that I first went back after spending a few years at home with my children. As soon as I went back, I got sick. At that stage, I had lost my attorneys. I was then reliant on senior people to be their junior. Then what started to happen is, as I got older, I got involved in more, even larger commercial arbitrations. But the attorney hadn't briefed me. I was brought in by seniors, and those attorneys didn't brief me on my own. And unfortunately, you can't go and tout at the bar, and you get the work that you get. And even when I started to get the state attorney work, I was trying to bring in juniors, but then the state attorney doesn't want to spend too much money. So they were saying no. But the first opportunity that I got where I said, this is a matter that deserves a junior. It can command a junior. Even then I was told no. And it's only of late that the state attorney is now briefing me in every one of my matters with the junior. But those matters are also ongoing. So my practice isn't that I'm in court 3 days a week. The matters that I'm involved in are going over several months. The one is over 2 years where I've had the black female junior.
Thank you, CJ.
Commissioner Hassan?
Thank you, Chief Justice. Advocate on this side, Commissioner Hassan.
Thank you.
Advocate, I appreciate the context that you've outlined in a great level of detail of how we've gotten to this point. I think my concern is that it almost reads as if you had no agency to confront those entrenched briefing patterns that you've taken us through. Given your seniority and your relative advantages that have been held within chambers over the years and maybe even on the roll, what did you do personally, using what agency you have, to disrupt this exclusionary briefing system?
Well, I tried to join those committees to see how you can change it. In our group, in group 1, we've got an initiative, obviously, to try and assist the young female juniors in our group through a mentoring program. I've always had an open door policy in my group. Anybody wants to come in, I will try and assist them. But ultimately, the fact is people have been trying for 20 years to change those patterns. They're not easy to change. And I've done what I can within the realm of my practice and having regard to the nature of the briefs that I've got.
All right, thank you, CJ. I think you've also, through other questions, answered some of my follow-ups. Thank you.
Thank you.
No more questions? AJP?
Thank you, Chief Justice. Yeah, Advocate Vansel, as we were busy interviewing you, you indicated that the stroke that you had has got an impact. Did you say on your vision or on your hearing?
My hearing.
On your hearing.
But it's just, I can hear, but it's directional hearing. So if my cell phone rings, and I don't know my bag is here and it's in my bag, I'm not sure if it's ringing here or if it's ringing here. So it's not an impairment that I've ever had a problem in court that I can't hear counsel, or because I can see that person standing there, that person is standing here. But in a room like this, it's more difficult for me to see where is the person speaking to me.
Also, in court, it does not have any
It doesn't
impact.
have any impact at all in a courtroom.
Thank you, Chief Justice.
We've reached the end of your interview, Ms. Swenson.
Thank you very
Thank you
much.
very
I'm
much.
indebted to everybody for the opportunity.
You're excused.
Thank you.
Okay, shall we clear the room, please? Long.
Good evening, Chief Justice.
Just bear with us for a minute. We are waiting for the Premier and the P. Patudi and Premier Ramatuba. Welcome, and we do apologize for keeping you waiting all afternoon. We were supposed to interview your candidates much earlier, but it is the nature of the business of this body for things to delay, things come up unexpectedly. We've had a very busy day, but the delay is regrettable. And that the apology extends to you as well, Mr. Holong. All right, are you ready?
Yes, Chief Justice, I'm ready. Thank you.
Okay, let's do this. And time is okay. We interviewed you just last Friday, 10 October 2025. So we are not going to put you through the unnecessary pain of questions to which you already have the answers. We have a full transcript of your full interview in front of us. We know exactly who you are. So what we plan to do is to just give you an opportunity to explain the memorandum from you that we received this morning, raising certain issues pertaining to your interview last week. And then I will allow the commissioners to put questions to you, if any. Right.
Thank you very much, Chief Justice, for the opportunity, and I think thank you to the commissioners for the guidance that was given to me on the occasion of my previous interview.
Just pull the mic closer to you and try to speak louder.
Thank you.
arising from that experience, I deemed it prudent, Honorable Commissioners, to settle an explanatory memorandum to deal with matters that I believed were left hanging in the minds of commissioners, in spite of the concessions made during that interview. One of the key questions that arose was circumstances arising from my nomination and acceptance, the similarities from the two nominators, in spite of the fact that they were from different locations, as Honorable Commissioner Tlaleti then raised. It occurred to me, as I considered that the acoustics failed me a bit and I didn't quite get the question, which actually derailed my responses moving forward. So I deemed it prudent to settle a memorandum, firstly dealing with that confusion that may have arisen out of the similarities in the templates used by nominees and the acceptance letter. But also, just put it on record that with the indulgence of the JSC, I plead that reference to 2004 as then discussed should be understood to mean 2024, the finger error that was discussed. But I think also relevant to this interview, Chief Justice Commissioners, I noticed that out of 3 bodies that had commented, by the closing date, I had 2 positive comments from Advocates for Transformation and the Law Society. I had a negative comment from the Black Lawyers Association. As at the date of the interview, I had 4 positive comments and 1 comment that was not positive. And I thought that it behoves me to take the JSC into confidence in terms of my responses to that issue. The Honorable Minister had also raised an issue around accessing some of the work that I had dealt with, and I thought that for the convenience of the commissioners and the Honorable Minister could share one such. I noticed that there are 3 names that I work with, but the name that I'm most commonly known for is actually Shami, which is perhaps where the confusion might have arisen. A lot of the articles that I wrote were under Shami Kolong instead of Solomon or Tebo. So I thought that was the one issue that I needed to deal with. Chief Justice, I confirmed that I had a discussion with both Ms. Dlamini, my nominee, and Mr. Nguku, my second nominee, regarding my nomination. In respect of Mr. Nguku, who was interested in nominating me, our discussion started in 2004 and again around May 2024, I beg your pardon, and again around May 2025. In respect of Ms. Dlamini, we discussed the nomination in June 2025. In both respects, once I decided to accept the nomination and move ahead with it, I agreed with both Mr. Nguku and Ms. Dlamini that I'll provide them with a template document which they could use for the nomination, as all of us had no experience handling the JSC nomination. That template document has been generated on my computer in previous years for nomination to other bodies. Both Ms. Dlamini, as reflected in Exhibit A, and Exhibit A is an email, Honorable Commissioners, addressed to the Commission. And in it, Ms. Dlamini points out that I hereby confirm that all the information provided with regards to my nomination of Advocate Kolong, JSC, is true. A template document was shared with me in June, which I then considered and used for my nomination. Noted Ms. N. Dlamini. That's Exhibit A. And I also attached Mr. Nguku's copy of the nomination letter sent to me on 12 June 2025. That's Exhibit B. Now, in it, honorable commissioners will note that it was sent on the 12th of June 2025, and Mr. Nguku addresses it to both my emails and says, "Would they please find attached the signed JSC nomination for your attention? Kind regards, William." I had agreed with them that we will finalize the nominations on the 12th of June, which we duly did. That is the reason the letters are all dated the same and the nominations are the same. Ms. Dlamini was with me in Johannesburg, and Mr. Nguku had been traveling outside Gauteng at the time. As agreed, all documents were put together for submission by me, together with the questionnaire and other required documents by JSC in June 2025. As stated previously, I regret the finger error on paragraph 9.2 and paragraph 8, which reference 2004 and 2024. I think that is a lesson in a learning that will, editorial error that will, last one a lifetime. I'm indebted to the commissioners for the guidance that was given to me in respect of that particular finger error that I had made. Addressing the concern by one of the law bodies about provincial experience, my submission to this august house is that despite having no adverse comments by 2 of the 3 law bodies as at the closing date and 4 of the 5 as the date of the interviews, a concern was expressed about my lack of experience with what it terms customary law cases in what is termed rural province like Limpopo. Honorable commissioners, I respectfully submit the following in response. Firstly, besides the work that I did at the Limpopo provincial government over the years in their governance structures holding the legal portfolio with oversight over a number of departments, including the Premier's Office and COCTA, which departments are assigned to deal with, amongst others, issues of traditional leadership. I have, in addition, also extensively dealt with and served in the structures of different localities in Limpopo, like the Capricorn District Municipality, where the provincial seat is located, and Polokwane Local Municipality, Tsamin Local Municipality, Maruleng Local Municipality, Giani Local Municipality, Letaba Local Municipality, Bapalabora Local Municipality, and Elias Motswaledi Local Municipality, amongst others. Many of these localities and communities have a number of tribal authorities. I served in these communities, which also had many matters on the role of the provincial division, wherein I exercised oversight with dedication and skill that demonstrated experience, acknowledgement of this work in the communities. And I must pause here, Chief Justice, Honorable Commissioners, to say these communities are communities that are constitutionally recognized in terms of Section 152 of the Constitution. And my plea and submission to the Commission is that their observations must be measured against the criticism of the BLA, in addition to the positive comments, 4 positive comments that I've received from the law bodies. Honorable Commissioners will note in Exhibit C a certificate of appreciation, and it states, this is a certificate of appreciation for your years of dedicated and outstanding service as a member of the Audit and Performance Committee. And this certificate is signed by a constitutionally recognized structure representing the communities of Polokwane. That's Exhibit C. In Exhibit D, there's a certificate of recognition accorded to me for the work that I did between 2012 and 2016 for being a member of the audit committee at Aghanan local municipality. Now, there is no, I can't think, honorable commissioners, Chief Justice, of a more rural community like the community of Aghanan local municipality as it then was. And the duly recognized and elected representative of those communities with tribal councils deemed it fit, based on the work that I did in those communities, to accord me a certificate of recognition, holding the legal portfolio and exercising oversight and guidance on matters on the roll before the Provincial Division of the High Court in Limpopo. The same can be said of all these other local municipalities and district municipalities that I had the privilege of working with. So I put before you Exhibit C and Exhibit D in response to the criticism of the BLA. In terms of academic grounding, besides being steeped and fully understanding African customary practices as an African, I've also studied customary law as a discipline at the University of the Free State and African politics at Wits University. That gave me academic grounding and I believe would enable me to deal adequately and competently with any customary law matter that may arise should I get the nod of this commission to the division. I was further in the senior management at the then Department of Provincial and Local Government that processed the white paper on traditional leadership and resultant Framework Act. I beg your pardon. Traditional Leadership and Governance Framework Act. And I pause here to mention, Chief Justice, Honorable Commissioners, that this white paper and bill and consequent legislation was processed, if Honorable Commissioners would note, as per paragraph chronology of work done since leaving college, which is paragraph 6 of the questionnaire. I mentioned there that I was in the Department of Provincial and Local Government from 2002 to 2004, 2004 to 2007, holding the title Director and later Senior Manager in that department. So I was part of the senior management that processed the bill, the white paper in the first instance that deals with these issues of customary law, and later bill and act that deals with Traditional Leadership and Governance Framework Act. Even though I was not in the core team, I was part of the management that considered and helped shape both the bill and Traditional Leadership and Governance Framework bill before it went into cabinet and into parliament. So I'm fairly conversant with policy issues. I'm also fairly conversant with the legislative framework that deals with issues of customary law and practices. And I also pause here to mention that a lot of the disputes, by the way, in the provincial division, has to do with disputes about who, in most instances, is the most deserving or rightful appointee to the role of traditional leadership. Now, in spite of reference to customary practices, a lot of that and guidance in terms of how that is to be dealt with, whether in terms of ancillary legislation by the Premier in the province, or in terms of the Act, for example, for purposes of the King and Queens, this particular piece of legislation, with which I interacted with as early as 2003, is the policy framework that guides issues of customary law and practices in the country. So on that basis alone, I respectfully submitted that that experience must be deemed to be sufficient experience that enables me to can deal with any customary law matter as may arise in the division should I be successful in this nomination. I've already, addressed the issue of articles which I also attached in Exhibit E, Chief Justice. I thank you, honorable members of the JSC.
Thank you, Mr. Kholong. All right, I'm going to hand over to the commissioners to put questions to you. None of us are bound to put questions, are bound to confine our questions to him, to the explanation is just given now. And that applies especially to the JP and Premier who have not interviewed him at all before. On that note, over to you, Premier.
Evening, I wanted to say morning. Evening, Chief Justice and evening.
I'm sorry, it's the JP. What did I say, Premier?
Yes.
The JP goes first. It's been a long session. Sorry, Premier.
Thank you very much, Chief Justice, and good evening to you and to the honorable commissioners. Good evening, Advocate Kholong.
Good evening, JP.
Yes. I will not be confining questions to this document that you have filed, but I would like just to shoot straight from the questionnaire that you have submitted timelessly within the time which we are required to make a submission. Having gone through the questionnaire, I've noted, and there's no doubt about it, that you have acted in both the the Western Cape and Gauteng divisions of the High Court as an acting judge. But however, you did not act. I do not see anywhere where it seems to me you have acted in Limpopo division of the High Court, both in Polokwane as well as Togoyando local division. Am I right?
Yes, Judge President.
I see. And the fact that you have mentioned in your in the document you have identified this explanatory memorandum explaining your exposition to the activities in the Department of Coxta, not Cocta, Limpopo, does not mean that you got any exposure in any of the traditional leadership disputes and claims that obtained in Limpopo province. Am I right?
The only way I interacted with that was through my holding portfolio legal in the Provincial Audit and Governance Risk Committee, where matters in which both the Premier and the local and Coxta are parties, we as structures of the provincial government, we had a duty to exercise oversight and be able to guide, be it the DG or the head of department, with a view to advising, where appropriate, EXCO on efficient management and case management of those specific cases as and when they arose. So that is the experience that I had in respect of those matters.
Yeah, but that does not, that's not applicable to litigation in that court. Is that my understanding correct?
No, we'll be getting reports from a client or you know, whether, you know, the Premier's office or Coxstar in individual case would be, you know, a respondent. It will be from that perspective that we'll be getting reports and we'll be giving guidance on the efficient management of those cases. Whether the opportunities for alternative dispute resolution, whether, you know, those cases should be left on the roll. So it will be from that perspective that we'll be dealing with those issues, JP.
Thank you. But however, the purpose of my question is to establish the extent of your familiarity with the applicable practice directives in those two courts. Strictly on litigation.
Yes, I've familiarized myself, you know, but of course, nothing beats practical experience. But where I was coming from, JP, was that, you know, the Constitution and the legislation requires a person with legal qualifications who's fit and proper for appointment. It was against that backdrop that with experiences that I have of the province, that I thought it expedient that I can make a contribution in the manner I was nominated.
All right, let's leave it there and proceed to another question. You will note that the Limpopo division of the High Court has at the moment a composition of only 7 permanently appointed judges, of which only 3 are women or females. That is 2 Africans and 1 white female judge. Now, the current vacant post for which you have applied is also contested by a female aspirant judge who, if recommended for appointment, would balance the race and gender equation in our division. Now, the question is, would you have any objection if you could volunteer to step aside, tipping the scales as to give effect to the provisions of Section 174, sub 2 of the Constitution, that is for the judiciary to reflect broadly the racial and gender parity, especially for the Limpopo division of the High Court. Would you do that? Or consider to do that?
I support the principle of women empowerment, and I also support the good work which this commission and the Chief Justice has done for the empowerment of women in the country. I put forward the nomination, being mindful of the appointment in the previous year of a woman judge to increase the number of women from 2 to 3 in the province. It was against that backdrop that I thought it would have been fair and equitable to, in this instance, having appointed a woman in the previous occasion, to consider appointing a black male a young black male in this current cycle.
Yes, but then doing so would now increase the number of males than to balance the equation with race and gender. Would you agree? Because we'll be having now a total of, say, 4, 5 male judges instead of having 4 with the new post we intend to create now. You see where I come from in terms of the imbalance, gender parity.
I understand that, but I was, and perhaps this is where my human resource or organizational development grounding comes in. I was looking at the Office of the Chief Justice as a whole in terms of gender, race, youth, balance, in terms of both divisions, but also the national picture, how it looks like.
All right, let's proceed to your permission, Chief Justice. Let's turn to page 17 of your questionnaire at paragraph 6.3. Have you arrived at that page? Thank you. You have enumerated 4 cases which you regard as most significant. However, you failed to make provision with regard, rather to properly give a citation for one to can track those cases. I mean, they're from 1, 2, 3, 4. The question there is which cases in which you have appeared would you regard as being the most significant and why? Now, I was unable to trace this, to track these cases because of improper citations. Perhaps can you assist us? Why is it like that?
My page 17 has paragraph 9.4 to 9.4, 9.5, 9.6, and paragraph 1, JP.
Yes, I refer to the cases at cited under paragraph 6.3 at page 17. Let me give you an example. This case, which number 2, Temba Velase versus the state. We don't know what the citation is. Number 3, Marman and 15 others versus Raf. Neither is there any citation proffered, given rather. Is there perhaps an explanation for the omission?
No, I had assumed because they were attached, they are part of the cases, JP, that I had attached. The Prudential Authorities case number 1, in terms of the order of cases that I had attached, it's in fact 6 different cases against the Road Accident Fund, where parties agreed for all the 16 cases to be had. This was in the Eastern Circuit Local Division in Tembaletu. And that's Marman. The Prudential Authority is case number 1 in terms of the order of cases I had attached, and this is case number 2023-071935. In Gauteng division, JP.
All right. Now, turning to page 18, at paragraph 6.4. Required to list all the reported cases in which you appeared as an instructing attorney. And you state that I appeared as a corporate counsel in the following matters. There you listed 1, 2, 3, and 4. I took the liberty to go into, for example, the Constitutional Court case of Johnson Matotoba, Nokotiana, and others, and Ekurhuleni Metropolitan Municipality. Then, upon perusal of this case, I went to check as to who the instructing attorneys were. And with respect, I could not find your name as an instructing attorney in this matter, which is clearly reported as CCT 31 of 2009. Perhaps maybe it could have skipped my attention. Do you agree with me?
No, I'm with you, JP. In the previous occasion, I made a concession that perhaps I was over eager because the question specifically requires instructing attorney.
Yes.
So I should not have tried to be creative to indicate the client role because I was corporate counsel in the client or party, that being Ekurhuleni because I was the corporate counsel of Ekurhuleni at the time. But I think I misdirected myself, filling the form in the manner in which I did because it requires an attorney, or at least I should have phrased what followed below much better. Perhaps to read, I was corporate counsel of one of the parties or a client in the following matters. It would have read better because I was corporate counsel and legal advisor in those institutions that gave instructions to the attorneys and counsels that dealt with those matters on our behalf, JP.
Yes, but then you did not address yourself to the question as it appears in paragraph 6.4. It required of you to list reported cases. Now it is clear that the Johnson Matotoba case has been reported under CCT 31 of 2009. It's a constitutional court matter. Now, one would have expected if you appeared, as the question says there, as an instructing attorney, then your name would have appeared. But here it is recorded that counsel for the applicants were Advocate Mensing, instructed by Weber Wenzel, and then counsel for the first respondent is Advocate Campbell, SC, Advocate Creer, instructed by Bam and Yaya, and counsel for second respondent, counsel for the is Advocate Madlanga, SC, should I say SC then was, and Advocate Rajab Brundler, instructed by State Attorney, and there, counsel for the third and fourth respondents, Advocate Gilmarcus, SC, also instructed by the State Attorney. Nowhere is your name mentioned as an instructing attorney in this particular case. Do you agree with me?
Yes, no, I misdirected myself there.
Okay. The same could be said of Matetiele Municipality and others. This is President of the Republic of South Africa. That's also a constitutional court case. But on going to Safli, your name as an instructing attorney is neither mentioned. You also agree?
Yes, I was a client. I was representing I was an instructing client as Chief Legal Counsel of Ekurhuleni Metro in respect of Nokotiana, and I was Chief Legal Counsel of respondent Ekurhuleni Metro in terms of Nokotiana, and in respect of the Eden Park extension, I was the Chief Legal Counsel for Ekurhuleni Metro. And in Matatiele, versus the President and others, I got involved in that matter as a manager on behalf of the then Department of Provincial and Local Government.
Okay, that might be so, but the fact is, you have, to a reasonable reader, one would have expected you as an instructing attorney to have had your name enlisted in the latter matter that I've mentioned. Was that also an omission to say that you're an instructing attorney there?
And below that question, which is where my concession of misdirecting myself came in, I mentioned below that I was corporate counsel, and that is not what the question required as I was guided the last time I appeared.
All right. You will also assist me to turn to page 10. Sorry to take you backwards. Page 10 of the questionnaire. You have mentioned that your membership of Mangaung Youth Congress and SAICO, having been a member from 1987 to 1988. Am I right?
Yes, JP.
Right. Immediately thereafter, also indicated the member of the ANC, 1991. But you did not disclose if you are currently still an ANC member or if your membership ceased, and if so, since when? Am I right?
Yes, JP, my membership of the ANC has expired. I was mindful of the fact that a judge, if so appointed, cannot be politically affiliated. So it expired a long while ago. Not only for that reason, but also because of my commitment to professionalization of the public service. So I know that a public official cannot be a member of a political party.
Yes. But what I am saying is, why the difference? I mean, in the case of Mangaung Youth Congress, you've indicated the period when you became a member and when your membership came to an end. But however, in the case of ANC, it remains as 1991, and you haven't indicated whether membership has expired. So to me, it appears that you're still a member. Am I right? That's the interpretation one can accord there. And if so, what are you going to do in the event you are being considered for appointment as a judge?
I have not renewed my membership of the ANC Judge President for a while, mindful of the role that a judge, amongst others, has to play in terms of being non-partisan in dealing with disputes in communities. So I can assure this august house that I'm not a member of any political party.
I see. Well, finally, or lastly, South Africa today faces great challenges of overcrowding at detention facilities. Are you aware of that? And this issue of overcrowding in this country especially in Limpopo province, is a menace to the remand detainees awaiting trial. As a judge, or if appointed, what legal mechanisms, if any, would you employ in order to alleviate overpopulation at correctional services centers? Legal mechanisms.
I mean, as a judge, one would obviously have to apply themselves more in terms of, firstly, the requirements of Section 60 in terms of awaiting trial prisoners, but also on conviction and sentencing. One would have to, assess the gravity of the crimes that might have been committed and whether it would be just and equitable, to commit an offender or not. So one would have to carefully weigh each individual case very carefully to ensure that only deserving offenders are committed.
Is that all? You wouldn't consider, or rather, if you're aware, the provisions of Section 62 sub A of the Criminal Procedure Act, 1977?
Yes, we'd have to, consider all the, relevant applicable provisions, JP, to ensure that, there is proper balance, between, in case of, people that have not been sentenced, that, you only commit, you only retain those that would not meet the bar in terms of either being able to demonstrate, exceptional circumstances in respect of very serious crimes, or that, the interest of society warrants that such people be released. I think that balance, one would have to be mindful of it as and when one deals with these matters.
Well, Advocate Kulong, I thought you also enlarge so as to satisfy my question on the provisions, not only of Section 62A, but also traverse Section 62F and Section 63(1) of the criminal procedure. Those are the mechanisms which courts can employ in order to mitigate the problem of overcrowding in our prisons. So, but I thank you for your very much. Chief Justice, I have no further questions.
Thank you, JP. Premier?
Good evening, Chief Justice, and evening to all the commissioners, and thank you for inviting us to this process. I think the JP has covered me, but evening Advocate Kulong.
Good evening, Premier.
Maybe just a follow-up from my interest as a Premier of the province on mainly on the issues of the Traditional and Khoisan Leadership Act of 2019. I've heard your presentation tonight, but I just wanted to understand, because you focus on your experience, which you explain as if it is a relevant experience, wherein you are focusing on being a audit committee member
if the mandate of the audit committee, you've gone through it clearly and see how does it link with this particular act, and how will it assist you? Because the province is 80%, more than 80% rural, and the biggest headache is stability amongst the traditional councils, which has got impact on the economic growth, because investors do not want to invest in province where there is instability. Now, the internal or being a member of audit committee, which you cited and gave us the certificates of appreciations. When I go through it's mainly a focusing on the governance and performance, mainly on internal controls, reviewing the management strategies to make sure that the annual financial statements are done properly in terms of the law, and all the municipalities that you have served. I can tell you even today, they are still outsourcing annual financial statements, meaning all those who served in those audit committee failed us as a province. That is just by the way, but I just want to understand, why would you bring this as evidence that you do have experience in terms of this particular act, which as a province we need a judge that is very clear in terms of practical experience and would help us to move the province forward.
No, thank you very much, Premier, for that question. My experience as we're engaging with key management, both at local government level in the various municipalities, but also with the provincial department of local government and that of the Premier, where we are, amongst others, dealing with issues that the Premier is alluding to, is the failure to ensure that, firstly, there's proper conclusion of partnerships between traditional councils and municipalities. Because for the province to be able to deliver, if you're talking about community-based planning and development, our advice to the structures was that there must be proper partnerships and even agreements that would, for example, dictate your integrated development planning processes, how the traditional leadership interchanges with those processes. But my experience, in spite of the advice and some of the reports that would give to the executive authorities, like councils and feedback which would be filtering through to EXCO, is that because of capacity challenges, a lot of that work was not moving with the speed which we desired. Our view, and my view on that question, Premier, is that the partnerships as constitutionally envisaged between traditional councils and the localities need to be practical and working, so that traditional leaders, sub-councils, councils can be able to meaningfully contribute to the development of the province. So that is one area of work that still needs to develop. It appears that there's more of a ticking exercise when it comes to integrated development planning. When your IDP circles come, and at times you inquire as to the degree of interaction with traditional leaders, a lot of that interchange, very often we are not able to pick it up.
You see, the more you elaborate, the more you confuse me worse. Because in your just explanation now, if I was looking for the special advisor to the Premier on the issues of traditional affairs, you would be very relevant. But here we are looking for a judge. The judge which were in a province like Limpopo, which has got one queenship, which is currently under dispute and in front of the courts. Two kingship, the Bavenda and the Bapedi, they are equally in the courts. If you look at the senior traditional leaders, more than 800 cases amongst the Mahoshi, Manduna, they are within the courts. Now, the judge must be able to assist us on those. The advice you are giving us is what we need to do as the Premier's advisor or Coxstar or Premier herself. But here we are looking for somebody with the experience to can be able to assist us when it comes to those matters that are within the courts. So that's why I'm saying the more you talk, the more you confuse me worse.
No, thank you very much for that question, Premier. I think the key thing as a judge would be to assess whether processes in cases where such conflicts obtain in terms of African customary practices and as now envisaged in terms of the Framework Act have been followed because and the provincial ancillary legislation, because those processes are defined in legislation in addition to customary law practices. So to the extent that exceptions might be identified, for me as a judge, if those processes have not been properly followed, either in terms of determination or otherwise of designating Mahoshi, would inform, one's decision on each one of those individual cases. Premier.
Thank you.
Thank you, Premier. JP Taletsi.
Thank you, Chief Justice. Good evening, Mr. Kholong. I propose that you keep your mic continuously on because my questions are going to be very short. Yes. Ms. Munisi, who nominated you for this position, is the same one of the two who nominated you from Mpumalanga?
Yes.
Are the same letters identical? Is this letter identical to those two?
No, I understood your question last time to say why.
No, answer the one now. Is this letter identical to those two? We'll come to the explanation.
It's an email.
Your nomination letter that is written by Ms. Dlamini. Is it the same? Yeah, Ms. N. Dlamini. Is this letter identical to the two in your nomination from Mpumalanga, Division of the High Court?
Commissioner, I understood the difficulty that we had being the similarities in font in the dates, in spite of people being in different localities. So that was the specific question I was answering.
Yeah, but then answer this one now. Is it identical to those two? Is it anything other than that is for this division, Limpopo? Are they not the same or identical, same similarities?
They would be the same.
Are they or not in the, that they would be? Are they the same? So that I should understand.
I'm not certain of that question, whether they're the same, because one was addressed in respect of Mpumalanga, the other is addressed in terms of Limpopo. So they cannot be the same if one is addressed for Mpumalanga and the other is addressed for Limpopo, if I'm understanding the question correctly.
Yeah, I'm saying the difference will be the name of the court, but the contents are the same. They're identical.
Indeed.
Including the font, the number of words in the same letter.
Yes.
And then your letter accepting this nomination is also identical, except for the identification of the court to which you've made yourself available the same.
Yes, because we use the same template.
Yes, let's deal with the template. For the template, what did you send? What was contained in the template?
The template was the paragraphs as it was a template because they've never what do you call it? They've never made a nomination as we discussed, the matter with them to the JSC. So they asked me, how does the nomination be looking like? It was on that basis, based on my experience with previous boards and entities that I had worked with, that I agreed to share with them a template they could look at in considering the nomination.
What was contained in the template?
It was nomination to the provincial divisions, as you have it before you, Honorable Commissioner.
The information in the letter, is it what was contained entirely in the template?
Yes.
So it's difficult to say everything that is in the letter is what you sent to them.
I can't speak to that right now, but it was more or less the same. I mean, when it came back to me, it looked more or less in the same mold as the template that I had sent to them.
So what they say about you is what you told them to say about you.
No, I shared with them information about myself, including qualifications and experience, which they did not know. I did not tell them what to say about me. I provided them with a template.
Yeah, but you said the template was the same. So what is contained in the nomination and motivation letter is what you shared with them, and it came exactly as it is.
It would appear they were happy with the template that I had shared with them.
Yeah, well, happy or angry, I'm not saying it came the same. So actually the views expressed are your views and not theirs.
No, once they, determine that that is the template that they're going to use, as Ms. Lamini states, and as illustrated in the email that has been shared by Mr. Nuku, that is the nomination that they used. So they were not expressing my view or anybody else's view. That would be my respectful, submission. I just provided them with a template.
Okay. Just help me. Previously in your interview, you said you gave them nothing. They drafted the letters.
No, I said exactly the same thing. And that is what I thought when I said my answer could have been better. Because I said I provided them with information and I ensured that the quality of that information would be the correct one for submission to the JSC. And that was the answer that caused, a bit of a discussion by the JC the last time.
You said you gave them, you did not, they are the ones who drafted the letters. That was the first version. Later you said you shared information. Today is the third version, you say you shared the template.
Well, template and information is the same thing with respect, Honorable Commissioner. And if you, as you can see on exhibit B, titled Nominations JSC. Good day, please find attached the signed JSC nomination for your attention. Kind regards, William Nuku. So it is Mr. Nuku making the nomination and not myself.
Yeah, she only signed. She says so, doesn't she? Please find the signed, meaning she received something, she was mailed to sign and send it back to you.
If you go to, Exhibit A, addressed to the Secretariat of the Judicial Service Commission, Honorable Commissioner, it says, I hereby confirm that all the information provided with regards to my nomination, of Advocate Cologne to the Judicial Service Commission is true. A template document was shared with me, so it's not me saying that. There's an email that is addressed by Ms. Lamene to the Judicial Service Commission. A template document was shared with me in June, which I then considered and used for my nomination.
Yeah, I'm just concerned you are making it worse and involving other people with these letters. But then if you take it the matter further, don't you think it would have been advisable rather to take some time and get everything in order so that when you appear before this commission, you don't have to deal with these aspects? You were requested, I think, by Councillor Pile to say, reflect whether you still want to come and appear having had this kind of an experience in that particular interview.
Yes, but what the commission has in front of it is confirmation of the nomination, Honorable Commissioner. It's not myself making the nomination. The email that is sent on the 13th of October by Ms. Lamene makes it clear that she's the one who made the nomination. The copy of the email sent by Mr. Nuku on the 12th of June at 13:09 makes it clear that he is the one making the nomination.
So you stand by this nomination. So I can argue, am I free to say if you lack an error of judgment in dealing with this matter, that you are just rushing things through, you cannot see the difficulties that we are going to face, to recommend to the president to appoint a judge who comes with 3 versions, which change from time to time? Will I be unfair to argue that way? Maybe you can just help me.
With respect, my respectful and humble submission, Honorable Commissioner, is that that would be very unfair. Because I considered the last time that I provided the information to the colleagues. The colleagues are confirming today.
Mr. Kholong, it's late in the evening. You're an intelligent man, and certainly no one around this table is stupid. I think we should just put a stop to this. You have given 3 different versions, and each time, each one of these versions was put to you, you became evasive, and you became belligerent. That's the word that came to me as JP Tlalese was questioning you on Friday, and it was the same. The impression got even stronger when Commissioner Pillay questioned you about this. You were evasive. I mean, you were asked a simple question. Let me just go to the relevant page, the first version. JP Tlalese says, I noticed that these two nomination letters are identical. Have you noticed that? And you say yes. Who drafted them? And you say I was involved. I was aware of the nomination. Then he says, I don't understand who drafted the letters. A simple question, and goes to pages you avoiding to answer that simple question. And then later I would say you provided information for quality control, and today you are telling us that you gave them a template. Why are you doing this to yourself and to us?
I'll take the submission no further, Chief Justice.
I'm just concerned that the public out there and the professional bodies are watching what is happening. This does not reflect well on you. Thank you.
Thank you, JP. Commissioner Trollip?
I'm covered, thanks, Chief Justice.
Any more questions for the candidate colleagues? All right. Thank you very much, Mr. Holong. You're excused.
Thank you, Chief.
How are you? We are fine, thank you. We were supposed to interview you about 5 hours ago, but the day just ran away with us. Please forgive us.
That's fine, thank you.
You have 3 academic qualifications, a BUris and LLB from the University of Durban, Westville, and then there's a certificate you got later, a short program in business administration management.
Yes, Justice.
Which you passed with a distinction, I might add.
Thank you.
You have risen through the ranks of the public service. Your first job was as a prosecutor.
Yes, Chief Justice.
And you never left government.
No, Chief Justice.
So that between 1993 and 1999, you worked as a public prosecutor in the district and regional courts, and then worked your way up, switched over to the magistracy in 2000.
Yes, Chief Justice.
And there worked your way up to the position of acting regional court president earlier this year.
Just for a week, Chief Justice.
But still you sat in that seat.
Yes, Chief Justice.
You started acting last year in October?
No, Chief Justice. I started acting in 2022.
Oh, your application form doesn't say that though. When in 2022? Oh, sorry, it
goes down
from the bottom. Or it's
most
been a long
recent
day.
to the oldest.
Okay. You started in February, you're absolutely correct. You started in February 2022. And then had intermittent stints until the last one was in December last year.
No, and I'm currently acting Chief Justice. I finished the 3rd term and I'm now into the 4th term.
You'll be
I will
staying
be
on
there till the end of the term.
All right. So where have you been acting as a judge since you started?
Just in Limpopo,
Just
at
in
the
Limpopo.
Polokwane Court.
All right. And how have you found the experience? Well, you kept going back, so you must have enjoyed it.
It was very empowering, Chief Justice.
And what kind of cases have you adjudicated? The whole spectrum?
Chief Justice, I've did all the civil, motion, posed, unopposed, trial, civil, criminal. I even did now a review on taxation.
How did that go?
It was interesting, and it was quite an interesting matter that I had to attend to.
All right. And you've written judgments during these acting stints?
Yes, Chief Justice, I wrote 44 for the High Court, and that's outside of my regional court judgments in the criminal court, as well as in the civil court, in the regional court.
All right. So, what the ones you wrote in the magistracy matter too? In all, how many would you say you have? Many.
Chief Justice, it was many. I was sitting in the criminal regional court from 2013 before I got promoted to the regional court in 2016. And in the regional court, you don't have simple cases where you don't impose direct imprisonment as a form of punishment. So you have to give a detailed reasoned judgment.
Yes.
So it's been 9 years now that I've been in the regional court here in Limpopo. So I've been writing for quite a number of years now.
All right. Any of them reported by any chance?
No, Chief
Not yet.
Justice.
Okay. Do you have any judgments that you've reserved for longer than 3 months?
Chief Justice,
currently or in
currently,
the past?
no. I have no outstanding judgments. In the term of term 4 last year, I had to just go beyond the 3-month period with some of my judgments because I had finished on the 7th of December, and then I found out that I was going to be transferred to the Polokwane Regional Civil Court, which meant that I needed to finalize my criminal matters so that I didn't encumber Mankweng Court with my part heard cases. So that was the reason for the delay, but the JP was aware of it. And I tried very hard to have them finalized urgently.
You remember of AMSA and SAC IWJ?
Yes, Chief Justice.
And I see that you've done a lot of mentoring work. There's a long list. I'm not going to get into everything, but it starts in your courts rather, in Germiston, Edenvale, and Kempton Park, where you lectured attendees in the department's adult diversion program for traffic offenses. So you say you lectured attendees about the court procedure from arrest to finalization of the case,
Yes,
including
Chief Justice.
ancillary orders. What was the value of that exercise?
Chief Justice, it was quite empowering for the offenders that were now on the diversion program because they needed to do the 6-week course so that they did not end up being prosecuted for their offense. And once they realized just how serious this offense is and how they need to comply with the diversion program, they then started to treat it seriously. And I think it was empowering to see that all the people that I generally had contact with during this time complied with the 6-week mentoring program or not mentoring, but diversion program, and then were moved out of the system without needing to be having a conviction or a sentence for their traffic offenses.
And you list your involvement in the training of district court magistrates, in the trainer program, and aspirant regional court magistrates for SAJ.
Yes, Chief Justice. On the request of SAJ, as the regional court, we were asked or tasked to assist with presenting programs for the regional court magistrates when we went out on course.
And I see that you've been involved in moot court assessments and hosting pupils on career day and some such.
Yes, Chief Justice.
Okay. All right, I'm going to allow Judge President Patuti to put questions to you.
Thank you, Chief Justice, for the opportunity. Good evening, Ms. Pillay.
Good evening, JP.
Are you well?
Yes, JP, I hope you are well.
It's been a long day, eh?
It has, JP.
Okay. Having the Chief Justice having taken you through your academic experience, your past practical experience, would you like to share with us that in your combined period of 32 years experience as both the district magistrate and regional court magistrate, have you presided in both civil and criminal cases? And if so, did you find any difference between the rules of evidence, for example, applicable in those courts vis-a-vis the High Court rules of evidence?
The first part
Any
of your
difference?
question, there's no difference as far as the rules of evidence is concerned, JP. And yes, I have both presided in criminal and civil matters.
And any difference noticeable in the criminal procedure applicable in the magistrate's court and the criminal procedure in the High Court? Any difference?
No difference, JP.
All right. So I take it was easy for you to preside in criminal cases at the High Court level as well?
Yes, JP.
Right. For how long have you been invited and actually acted in the High Court as an acting judge? If you could just perhaps throw light on the number of weeks or things in which you have acted.
JP, I've acted for 54 weeks currently.
when the term ends in December, it will be 61 weeks.
Yes, I'm just, for sake of completeness, at page 11, you, at the time when you made this, your submission, is that you had about 41 weeks at the time, am I right?
Yes, JP.
And then the weeks had now increased up to, you say, 54 as
we sit right now.
as we sit now.
Yes, JP.
And then and you have indicated to the Chief Justice that you are presently acting,
Yes, JP.
and you continue to act
Yes, JP.
in the Limpopo division and until the end of this term.
Yes, JP.
And all in all, you say it would be how many weeks?
It will be 61
Yes.
at the end on the 7th of December.
All right, thank you. I also note that you have attended the SAGI, Aspirant Women Judges Program in 2023, am I right?
Yes, JP.
Now known as the Bridget Mabandla Aspirant Women Judges Program.
Yes, JP.
And in that process, underwent 6 weeks of monitoring, that is monitoring program in the High Court, in particular, Polokwane.
Yes,
Is that the position?
Yes, JP.
Okay. And that, of course, must have expanded on your experience through that monitoring program.
It did, JP.
All right. The Chief Justice also asked you to take us through the training sessions that you have conducted. Would you regard that, especially that mentioned at page 15 of your questionnaire, as a contribution towards the development of the law and legal practice? Is that the case?
Yes, JP.
Okay. Thank you. I have no further question to this
Thank you, JP.
candidate.
Thank you, JP. Premier?
Thank you, Chief Justice, and good evening, Madam Pillay.
Good evening.
Yes. Ma'am, me and you comes from a province which, I'm going to be honest, as women, me and you, we have serious challenges. If you get appointed as a judge, you know that you will be carrying on your shoulders challenges facing women, millions of women in our province, because the 6.5 million population, more than 50% is women. This is the province where researchers have published that a girl child has got 4 times chances of being raped in their lifetime than graduating. So my question would be to you, what is it that you are going to do to assist this girl child and also these women who are killed, mutilated, and raped on a daily basis? You spoke about, as a acting judge, it was empowering. How are you going to empower the women of our province? That's my question.
Premier, I was fortunate that in 2022, I was involved in a project which just came by surprise. I decided, instead of donating my clothing to the usual charitable organizations, that we would have a collection of all the women professional outfits and then do a donation of it to the women in Mankweng. Specifically because I worked in Mankweng, I interacted with the community in Mankweng, and I felt it would be empowering for those young women to have, be it an evening frock or a business suit that they could wear for work. We collected 100 outfits, and on the date of the function, we invited 100 recipients. We donated the clothing individually. You entered the court from the one end, decided which outfit you wanted, and you exited the court on the other end. Each woman went in by themselves, so they could choose whatever they wanted from those clothing, and they could then leave.
And Premier, it was such an uplifting experience to see how excited those women were to be receiving a gift, clothing that they could use. There were gowns there for matric farewells, there were suits for work, blouses and trousers that they could wear if they were going out for work. So I'm passionate about empowering the women in Limpopo. I believe that it's important if we can uplift one or other person, sharing of what we've got, why not?
Minister?
Thank you very much, CJ. Good evening, Ms. Pillay.
Good evening, Minister.
In the report by Judge Mseneke on the rationalization, he noted that the establishment of the Polokwane High Court, Superior Court, had an impact in terms of improved access to justice, where he reflected even in terms of establishment of your sheriff's opening offices. It had economic and employment opportunities that existed. But furthermore, he reflected as well the de-establishment of the Palale area in terms of court. So having been there since 2016 and looking at what this report reflects, what do you make about the proposals that are contained in that as part of access to justice, but addressing the issues of a province such as Limpopo, that is rural by nature, majority of the people having to come and travel some of the distances that they do to access our courts?
Minister, I'm very fortunate. I've got a very dynamic regional court president who was very empowering for us as regional court magistrates. We were very involved in virtual hearings of witnesses, and just of late, it was in the middle of this year, 25, that we've gone online as far as delivering of judgments is concerned. This is so that victims that live far from the court don't need to come back to the court to hear what ultimately happened to their case. It's streamed via Teams, and it's streamed for the various departments so that the police who are in the area where the incident occurred would be able to have insight into what the presiding magistrate considered when dealing with the judgment and considered when dealing with sentence. So we are trying very, very hard to get virtual proceedings so that we can empower people not to have to come to court physically.
What else can be done? I understand the introduction of digital platforms, especially all of us applaud the Office of the Chief Justice with rolling out the court online. It does provide quite a lot in terms of that, but also the online. But there are rural communities that do not have access to even 2G. Majority of them can't even make a phone call within the Limpopo province. How do we ensure that those as well who cannot join online do have access to justice?
Minister, from my conversations with the regional court president and what she's informed us as the regional court magistrates is that all the local police were empowered as far as technology is concerned, so that people could go to the local police to be able to see the streaming of the judgment or streaming of the sentence, and to be able to also utilize that facility as far as testifying is concerned. So we are trying to connect the people to the local police station or the local magistrates court in the area so that they can then have access to be able to virtually appear and testify or virtually hear what is happening exactly in their case in court.
Thank you, CJ. Thank you, Ms. P.
Commissioner Mwiman?
Thank you, CJ. Good evening.
Good evening,
Ms. Pillay.
Commissioner.
Just one area from my side. I see that you highlighted the Seshiko Land Claim Committee versus Minister of Agriculture as one of your judgment that you cite as your contribution to jurisprudence. Seshiko Land Claim Committee.
Yes. I actually didn't highlight it as one of my cases for that purpose, Commissioner. It was for highlighting the fact that I had a matter that was sent on appeal and that it was the ruling and order was confirmed, but the reasoning behind the confirming of it by the full court was different.
Yes, my interest is more on the reluctant on the part of the court to come to the rescue of the Seshiko Land Claim Committee in terms of addressing the injustices of the past. The court was very reluctant to order the executive to address the plight of the people of Seshiko. What is your understanding of judicial restraint or judicial negativism in light of the preamble of the Constitution, which compelled the court to address the injustices of the past, particularly given the fact that the court has the inherent jurisdiction or the discretion to address the rule of law and social justice.
Thank you, Commissioner. Commissioner, I do believe in the separation of powers. At the time that I dealt with the matter, it was clear that many of the claimants were still with the land court as far as their claims were concerned. So it would not have been prudent for me to step within the terrain of the land court as well as their claims being ventilated in the correct forum. And it was for those reasons that I was reluctant. I believe the full court also did not rap me on my knuckles, but reminded me that I should not have dealt with the matter in total because of the fact that I was not the correct forum to entertain the matter on the merits.
Thank you, Ms. Pillay. Thank you, CJ.
President Wulemet.
Thank you very much, CJ. Good evening, Ms. Pillay.
Good evening, Commissioner.
How are you?
I'm good, and you?
I'm fine, thank you. Ms. Pillay, you are probably familiar with the provisions of Section 174 of the Constitution in relation to transformation. You are? Yes. I note that the GCB in its comments at 3.3 stated that the candidate is a black woman, in brackets Indian. None of the permanent judges in the Limpopo division, whether male or female, are Indian. Her appointment would accordingly advance the imperative of transformation from both racial and gender perspectives. So that's their comment. What's your comment? Do you agree with EFT? Sorry, it's Advocates for Transformation. Do you agree with their comment?
Commissioner, I would hope that outside of being a female and outside of being an Indian, I would be considered on merit and that I'm a fit and proper person to preside in the High Court.
Yes, to be fair to them and all other law bodies who commented, they did not confine their comments to only the fact that you are a black woman. And so, but I'm just...
I do agree with them.
You agree with them. Yes. Why do you think this is important?
I believe that it's important because it reflects the people that we serve. And if the people that we serve have confidence in us because they believe that they can see there is representation, and they will possibly get a hearing that is fair, they would then have confidence in the judicial system.
So it enhances public confidence in the judiciary.
Yes, it does.
Thank you. Thank you very much, CJ.
Thank you, President. Commissioner Pillay?
Thank you, Chief Justice. Good evening, Ms. Pillay.
Good evening, Commissioner.
I was a bit concerned about your answer to the Premier's question, Ms. Pillay. The Premier asked you a question very pertinently about the dire circumstances facing women in the province. She specifically mentioned murder, gender-based violence, and mutilation. And your answer, with respect, was a very superficial answer. You spoke about an empowerment initiative where you handed out clothes to women, 100 women. I'm just concerned that that doesn't grapple with a very serious question that the Premier put to you, and one which I think warrants a proper response.
Thank you, Commissioner, for that question. Commissioner, I've been sitting in the regional court for 11 years, and I've had to deal with serious rape cases and serious murder cases. And the only way we can empower the young woman is through spreading the word about how they need to be safe and how they need to be careful, and empower them by education and by our delivery of our judgments that are going out into the community, where they can see that we treat these offenses as serious, that we want to punish offenders for the violence that they've committed against these young women. And Commissioner, we can only pray, unfortunately.
Thank you, Chief Justice.
Objections Committee, the complaint that was lodged by the LAA was dismissed.
Yes, we dismissed it,
Thank
Chief
you.
Justice.
Okay. No, Commissioner Hassan?
Thanks, Chief Justice. A quick one, but an important one. Ms. Pillay, so my name is Commissioner Hassan. Your candidate pack has recorded that you prioritize a trauma-sensitive, safe courtroom, particularly when it comes to GBV, sexual offense, and child protection matters. Could you briefly set out what those measurements look like?
Commissioner, in terms of the Criminal Procedure Act, we have court in camera, we have children that are in child-friendly environments and their evidence is taken through an audio-video link. We try to keep them away from the general public so that they don't have to interact with the accused person in the normal course of trying to enter or exit the court.
Right, and do you find those sufficient? Are there any other measurements or interventions you would add in if you could?
Commissioner, I would like to have the evidence heard virtually, because then they don't even need to leave their home. And if we could just empower people with that type of technology, it would work a long way to helping to ease the secondary trauma that comes from them having to come to court to relive that experience.
No, thank you, Ms. Pillay. It's also encouraging to see that the court online process and various elements of technology can be and is being adopted by the judiciary. So thank you very much. Thank you, CJ.
No further questions, colleagues. Commissioner Nonkonyan?
Thank you, CJ. Good evening, Advocate Pillay.
Good evening, Commissioner.
Now, it's just minor. There is an adverse comment from Black Lawyers Association about your involvement in the matter of War McCarthy in the Bengal against the Premier of Limpopo province. What's your comment on that?
Commissioner, if one had to read my judgment, it would be very clear that the forum that was being sought to utilize as far as review was not applicable as far as a rescission of a default judgment was concerned. I do not believe that I could, in any event, entertain the matter, but instead of dismissing the matter in toto, I removed it to afford the applicants, not necessarily their counsel or their legal representative, but the applicants an opportunity to go to the correct forum where that matter was being dealt with or had been dealt with, to bring the rescission application in the correct location, have the rescission then ventilated, and then come back for the review as far as the Premier's role was concerned.
Yeah, thanks. And incidental to this criticism, they acknowledge your expertise in criminal law, but are of the opinion that you needed to be given some acting stint so that you can understand the customary law, particularly as we all know the disputes around the claims and counterclaims in the institution of traditional leadership in that province. What's your view?
Commissioner, I've been to Sir Jay's Bridget Mbandla course. I believe that is one of the foundational courses for any aspirant woman judge. I have acted in the High Court, and when opportunity provides me with needing to ventilate issues dealing with customary law, I treat them very seriously, Commissioner. So I would say that possibly they don't know me very well.
Thank you, CJ.
Commissioner Steinberg.
Good evening, Ms. Pillay.
Good evening, Commissioner.
I just wanted to say that I had a look at that judgment based on those negative comments, and there's absolutely nothing untoward that I could see. And it's written in very temperate language, so I truly didn't understand the comment. I think it's a fine judgment.
Thank you, Commissioner.
Is that a hand? Commissioner Jivan? Oh gosh.
Thank you.
Sorry.
You, Chief Justice. I understand that you've come up in the prosecution service, and so you've got a lot of criminal law experience. How would you describe your civil law experience through all your years serving the judiciary as a magistrate? So
Commissioner,
is it equally, or would you say that you're more experienced in criminal law? What's your answer?
Commissioner, in 2006, I was appointed the head of the civil section in Tembisa. It was a new court that had to be operated. I don't believe the chief magistrate would have trusted a person that was not capable to be able to run the civil court there. And I ran it with distinction until I got moved to the regional court, where I acted in the civil and criminal court. I was in 2013 acting on the bench for a week, and I got invited to attend the fast track civil course so that in the regional court I would be able to be appointed to deal with civil matters. So I believe it's balanced, but I deal with each case as they come, whatever the case might be.
Thank you, Chief Justice.
Interview, Ms. Pillay. Thank you very much for making yourself available, and you may go.
Thank you, Chief Justice. Thank you, Commissioners.